first session of the day. The legal field has seen tremendous change over the last decade with the introduction of technology into everyday work processes. In addition to making lawyers more efficient, these advances have also helped reduce costs associated with litigation. What does this mean for people looking to enter or continue this field? Learn more about the future of lawyers with our upcoming session. And so our first session will be a panel discussion, and please join me in welcoming on stage the moderator and the panelists, Mr. Rahul Totala, counsel at RT Legal. Welcome, Rahul. Next we have Prashant Shenoy, Chief of Technology at Unicourt Inc. Welcome, Prashant. Dr. Abdel Karim Al-Kadomi, Chief Legal Officer at Abdul Latif Jameel Enterprises. Welcome, Doctor. Advocate Kanchan Talreja, Senior Counsel at Advocate Kanchan Talreja and Associates. Welcome. Welcome back. And Manu Joshi, CEO and lawyer at RK Joshi Law Office. Welcome, everyone. Get ready to listen to the views of these thought leaders on future of lawyers, the impact of legal tech, big data, and virtual courts. Ladies and gentlemen of the panel, you will have your timer here. Please leave the last 10 minutes for questions from the audience. Thank you.
Hi, good morning. A fresh day, a fresh start, a fresh cup of coffee. I hope everyone's ready for another engaging session. So we are here to discuss the future of lawyers, which is incomplete without discussing the future of courts. I will begin with introducing myself, though most of you already know me. I am Kanchan Talreja. Though I hold an Indian passport, I have clients all over the world. We have been practicing in this field for the last 15 years. And of course, we faced a lot of challenges during this COVID period where there has been a transformation towards online courts and digitalization. For this, we have Prashant here on stage with us. Prashant, could you take it forward?
Thank you, Kanchan. I'm Prashant Shenoy. I'm a CTO and co-founder at Unicourt Inc. We are a legal tech SaaS company that provides access to US court data for large law firms, insurance companies, and a whole lot of people. So my background is dealing with US court data. I've done this for over a decade. And big data is the reason and the topic why I'm sitting here. Thank you.
I'm sure lawyers here have a lot of questions for you.
I welcome that.
Hello, everyone. Good morning. I'm Rahul Totla. I'm a lawyer practicing at the Bombay High Court in India. I specialize in corporate and commercial laws. I have also acted as an arbitrator to resolve international disputes. And I have government organizations, NBFCs, banks, and infrastructure companies as my clients with whom I daily engage with. Looking forward for this session. I'll request Dr. Karim to introduce himself.
Thank you. Good morning, everyone. I'm Dr. Abdel Karim Al-Qadomi. I'm the Chief Legal Officer of Abdul Latif Jameel Enterprises, which is a Saudi-based company. We are the diversified arm of Abdul Latif Jameel company in Saudi Arabia. Abdul Latif Jameel is a company of 75 years legacy, and we are the largest private auto distributor in the world. And we are focusing in terms of ALJ enterprises on auto adjacency, logistics, healthcare, collection, auction, media and entertainment, energy, and water desalination. I have 30 years of experience, 18 years so far in-house. Before that, I was a judge. And before that, I was a lawyer. And it is my pleasure actually meeting all of you. And it will be a very interesting day, hoping that we'll wake up with coffee or without coffee. Thank you. Manu.
Hello, everyone. This is myself, Manu Joshi. I'm CEO of RK Joshi Law Office, a firm based at Chandigarh. We have expertise in civil dispute resolution, and it basically deals with the real estate sector. I'm almost into this industry from last 11 years, and we are going to address what are the challenges basically the legal industry is facing, and the transformation that digitization and the AI is going to bring in the legal industry. Thank you.
So, future of lawyers. Let's start with Dr. Karim. What does legal technology transformation mean for in-house counsels and law firms?
Yeah, thank you very much. This is a very important question and a point that we need to address. We are witnessing, big transformation in terms of digital understanding and what exactly it is for lawyers and for people in general. People maybe need to understand that digital is not about being digital savvy, rather than to be a digital enabler. This is a tool that you need to help you to deliver different and better service to your clients or to your in-house. So there are so many things that people will need to look at in terms of what exactly that they are working on their daily basis, type of work. Whether that's the contract management, advices, practice management, compliance requirements. So we are seeing that there are so many things that the in-house or the law firms that they need to focus on. So moving from traditional way actually of delivering the service, okay, which is, maybe sometimes you gather the documents from here and there using the normal typical calendar to record your timesheet or to record, next hearings or your tasks. This is how bring documents and the stuff of documents, whether on your laptop or in your normal life. All of that, actually, if you put that within a proper system that will address all of that to you, and proper technology that will enable you to look at things differently and will help you to reduce time, to reduce cost, and to be more efficient, that will be the game changer in our lives. One of the studies that had been just recently prepared by Solicitors Association in association with Cambridge University. Imagine so far the percentage of lawyers that are really using technology in their daily life. How much that percentage is? Can someone figure that from the audience? The lawyers who are really using technology. Any idea? 10%?
May I? 2%.
2%. Okay, it's 1 to 2%. That's really amazing, That's not good for lawyers, that technology base is just, 1 to 2%. That's a problem because of what? Because change and going towards digital needs cultural change, mindset shift. You cannot go to technology by somebody enforcing it. You cannot go to technology by just attending one, let's say, seminar or, a conference. Technology is something that you need to embrace internally to really understand, and this is where will take you to different level of digital transformation. How you can use this technology, like artificial intelligence, like Internet of Things, like blockchain, and to gather all of that in one pool. And this is what it will really help you in reducing and being more efficient in your life. I'll give you live examples from Saudi Arabia. We are witnessing big transformation when it comes to automation of legal services and legal, let's say, court hearings and so on and so forth. So the pandemic was a main trigger, actually, towards this transformation. Now, we have something, let's say, an application or a website called Najis. Najis is associated with the Ministry of Justice in Saudi Arabia. Through Najis, you'll be able to access all court hearings you have. Go there, the transcript is there, the hearing schedule is there. Before the hearing, you will be receiving SMS on your mobile if you are a person, individual engaged in that case, or you are a manager on the CR of that company. You'll access the hearing, and immediately you can download the transcript of that hearing. All the hearings, next hearings, is already in the calendar of Najid, so you don't need to have your own calendar because all of that is scheduled. So, and this is just, a very short description of what Najid can do. And other stuff that, taking us towards transformation, there is another thing called Abshir. And what I was just telling my colleagues about, experience I had in terms of buying a car. Imagine how much time it took me to buy a car online and register it through this system, Abshir. Usually how much time it takes you to buy a car with all the formalities that you are encountering when you go to the traffic department. Can someone tell me from experience how much time it takes you to buy a car?
Well, in India, at least a week.
At least a week. Different experience from the audience? Less than 1 week? Okay, it's 5 minutes. 5 minutes, okay? That's a big thing to have. Power of attorney. I was able to issue power of attorney in 2 minutes. And this is where the automation, because there was a real good infrastructure that helped towards, this very important step towards digital transformation. One of the key things when it comes to transformation is what, for us, is security, okay? KSA is now ranked #2 in the world, worldwide, in terms of cybersecurity. So it's not only about transformation when it comes to digitization, without, covering that with, cybersecurity coverage, you'll be exposed. And if you are a lawyer, you shouldn't be exposed. You need to ensure that you have the proper infrastructure to transform, you have the proper tools to protect, and you know what exactly that's needed actually towards proper digital transformation from the legal perspective. Now we are seeing, and I'll conclude with this, that I'll leave the floor to my colleagues, that we are witnessing that there will be a shift and a change in terms of legal services delivery using technology. Maybe non-lawyers or non-legal specialists will enter into the sphere because of using those technologies. So for the future, it's either that you'll be a lawyer who knows technology, or you might be out of the market. So this is something that we need to be aware of. Thank you very much.
Thank you, Dr. Karim. I am with you on the thought that lawyers need to be enablers. We need to accept and adapt to the change. With that, we bring Manu on stage, Manu on the mic. I believe he is into litigation, civil litigation. So your thoughts on e-courts?
So first of all, as we all know, with this transformation the AI is bringing on, prior to this, according to OECD, Organization on Economic and Cooperation Development, there are only 46% people who live under the protection of law. And 1 billion requires on the whole, protection of law in a year. And 30% of the people, they don't even come up for their court redressals. The reason being, the backlog of cases, the cost, the time consumption, and the complex procedures. Even the developed systems which we take on, like they are very developed, even they are under-resourced. And if they are under-resourced, the time they consume in civil dispute resolution, that certainly pose a threat to the rule of law and to the judicial system as well. So the answer to this is a shift from the adversarial or the conventional traditional courts to the online courts. By online courts, I mean it's something that is different from virtual hearing. Virtual hearings is somewhat like, it's a kind of video conferencing where a judge addresses the lawyers are there, they'll put up their claims, they'll put up their arguments, and that is being decided. That's what we all call about virtual hearing. And so far as the coming generation, it's all about online courts. That is basically transformation. It will re-optimize, it will redefine the boundaries and the judicial system. Now, how it's going to work? In India, we had e-courts. How does they work? Like, many people, they don't have access to justice. Reason being, they are not that literate. And the access to justice is the basic essence of the rule of law, and that is denied just because of the time and the cost that the traditional litigation systems are taking on. So to transform this, AI has played a bigger role. Now, without discussing the future of courts, we cannot discuss the future of lawyers. So the future of courts lies in online courts. Certainly, this is not a solution to every problem. Online courts are not the answer to every case or every dispute, I would say. We'll have to do the restructuring of the courts, keeping in view the future and the needs of the litigants and of the market. We'll have to restructure the courts. Now, how this restructuring has to be done? The restructuring, basically, it has 4 parameters. What I can think about is, one is the dispute resolution, dispute containment, dispute avoidance, and improving or providing legal health. Now, taking on to these 4 parameters, there are many jurisdictions all over the world that have provided for successful online court systems and that have resulted in great changes that have brought toward for the litigants. For example, we have in Estonia, we have robot lawyers for small claim disputes. In the US, we have US Resolver for disputes relating to consumers and their suppliers. In this, the people or the customers or the suppliers, those who have any claim against others, they put up their claims online. They had tools which will provide them as to what are their entitlements. They can classify their grievances. Then they can optimize. And most so, there is a predictive tool also, what is going to be the outcome of their case. And this predictive tool has helped a lot to the litigants. And then when this goes on ahead, the second step is toward the negotiation part, online negotiations. Thirdly, when the negotiations don't work, then there comes the role of case managers. These case managers, they interact with the clients, they interact with the litigants, and they provide their insight on their grievance, and they try to classify their grievance and try to bring them on a non-judicial agreement, which can be having a binding contractual force. And lastly, when even that does not work, we have the final adjudicators. The case manager will refer it to the adjudicator, and the adjudicator or the judge, he will take on the clients, he will take on online through teleconferencing, telepresence, and finally, he'll decide the matter online. So this is what I think is going to be the future. Apart from this, I had some certain, because we have a technical, Prashant along with us, he's a technical guy. Prashant, what would you say if we talk about telepresence in courts?
Yeah, so a few comments before I get to that question. It's super interesting to hear Dr. Karim's view on things such as, if there are systems that are built from courts and the justice system as a whole, you're forced to use technology, and that can overall improve everything. From virtual courts standpoint to telepresence, just a small incident. A couple of days before the panel discussion, we got online to discuss on what we're going to talk here. And all of us were sitting on that meeting, and I had a choppy network. So by the time I could try to get my message across, the conversation had already passed. Okay. So telepresence, I mean, virtual courts, there are challenges. So keeping aside the challenges, I think that's from a technology standpoint, it's very practical to do that now in today's day. There's pretty decent connectivity. Data isn't a problem anymore. The size of data, storage, processing, people getting online isn't a huge challenge now. So adoption isn't difficult, but there are always challenges to that.
So while we are looking at the rise of use of technology, I myself am into family law. I specialize in maintenance, divorce matters, domestic violence. I'm not sure e-courts works well for us because empathy is needed. We need to deal with our clients on face-to-face basis, the complexity of the matters, the emotions that are involved. e-courts cannot justify that. Hence, I truly believe a blended approach where we can use virtual courts for civil litigation
Exactly.
or for in-house matters, counsels. But when we are dealing with human feelings, with family law, with maintenance matters, we still need to approach the traditional courts. Let us get some insights from Rahul.
Yeah. Hi. So I feel because of so many products which are now already available in the market, we need a tech to know what are the products of legal tech now available. Because there is so much data, so many apps, so many products. Just 2 weeks back, I attended a legal tech conference in London where there were 70 companies which displayed their products from UK and US. So I'm really confused. I just need to know what actually is going to help my client or help me. So I think, Prashant, you have a new business model where you aggregate all the legal tech products into one platform. Because in India, it is only because of COVID, which forced lawyers to adopt to technology. The products have always been there. They're improving. There are new products which are coming in the market. But honestly, for myself, it is only because of COVID which forced us to adapt and to accept technology. As litigating lawyers, where you have hundreds of files in your offices and where you have support staff, your juniors, your colleagues, as team members with you, assisting you. But when COVID happened, there was complete lockdown. You had to attend to virtual courts. You're looking for files because ideally when you get to a case, you just ask your office help to give you the file and get ready for the next day. But I realized that hence for the coming few years, because the COVID had struck so badly, there was lockdown phase 1, phase 2, phase 3. So I think overnight, from my personal experience, I digitized my entire office in 15 days. Whatever files I had, I completely scanned those and had it on my drive. So I think it was just because of COVID that changes happened. Virtual courts, it has its advantages and disadvantages, but the advantages are far more better than its disadvantages. Because we all must keep in mind that the justice system is not for the lawyers. It is for the public at large. We are just a part of the society. The whole object of justice delivery system and government is to provide people access to justice. And because of technology, they are simplifying the ways to get justice very easily and make it more accessible. So what I predict is, apart from the legal tech or the products which are there for lawyers in technology, there are products which are going to be available in the justice tech sector. Because our Chief Justice, Dr. Chandrachud, his entire office is now virtual. He gets no physical files in his office. He is the busiest judge in the country, but he himself wants to set an example by adopting technology. Now, in India, when you have hundreds of cases listed before a particular court and where you have 10 different courts, we need to give our appearances. For example, in a particular case, there are 5 lawyers involved. Usually what we used to do is that take a piece of paper, write down all the names of the lawyers who are appearing and give it to the stenographer. And then he will type it out. Usually there are mistakes in the name. Then particular lawyer has not appeared. The client is making a fuss about it. So day before yesterday, Dr. Chandrachud has made an app or a portal where you can give appearances on the app itself, which, as per their data, which is published on the Supreme Court website, roughly it is going to save around 6 lakh trees per year. So just by putting your name on the name slip and just putting technology in the courts, I think we've able to save 6 lakh trees. So I'm sure technology will go a long way forward. We must know and we must understand what actually is required.
Absolutely. The challenge we face in generating lawyers today is universities are still generating lawyers that belong to the 20th century. What we need is lawyers that are adapt with knowledge, not only of law, but also of technology, the 21st century lawyers. Prashant, why don't you talk about predictive analysis? We had a little discussion down before the session about predictive analysis used in courts so that clients don't have to wait for a court date.
This is a big topic. Yeah, I think, see, the fundamental raw material for, I mean, AI is loosely used, but the fundamental raw material to generate any kind of analytics or predictions is data. So the availability of data is the most important thing. So the predictions or analysis done is only good as what data is supplied to it. So accessibility to this data is right now a huge problem. If there is enough data, they say no data is enough for big data, right? So if there's enough data in there, there are a lot of things that can be done to improve the lives of lawyers, judges, the public at large, and the justice system as a whole. And today, the technology is not a limitation. Processing is super cheap. Data storage is really cheap. Courts are coming online. So the information is getting digitized whether you like it or not. Rahul did it in 15 days. Okay. So there is a lot of digitization that is happening. However, when it comes to predictions and analysis, the completeness of data is really important. So having data voids or spotty data is also a problem. But overall, I think the technology is there to be able to provide the necessary tools for every party in the justice system to improve the system as a whole. The question is the accessibility and the adoption. Like Dr. Karim said, I mean, if you put a system tomorrow where everything is coming on your app, from reminders of your hearings to who the other attorneys on the case are, I mean, life becomes so much easier, not just for lawyers, even for technologists to build solutions that really matter. Otherwise, we'll just be scrambling as technologists to figure out what solutions to build and where to start.
True. So the future for lawyers is to be enablers, like Dr. Karim said. So we either resist the system or help build them. So let's open up this for any questions that the audience may have for us. Yeah, please.
I believe the entire panel and panelists were discussing about the future of lawyers or legal profession, how it would be adoption of new technology into it. Well, I just wanted to understand. So to still, as I think our moderator said, that the universities are producing an advocates of 20th century. Now it's a high time to think about millennials, Generation Z, and how they want to do it. Good that Rahul told me about the app. But I think I heard there is a mixed response as far the adoption of technology is concerned. But the thing here is, we will not be able to escape. You'll not be able to escape because the time is very crucial. Whether our next generation or millennials will be able to withstand the today's court system. So, I just want to have the view of the panelists and tomorrow the adoption of extreme technology and whatever we are today. So today what has happened is a means and the end. In the verge of meeting the means, people have forgetting the end. End is a justice. And I see a lot of cases has been dismissed because you have not followed the process. What's very crucial is the end, not the means. So technology in any way, will it come for our rescue? I think Prashant would be the right person to answer it. So there is a dichotomy between this means and end. At the end is important, not the means.
Yeah, before Prashant answers that, I must say, even I have an 18-year-old daughter at home who's preparing for law college, and she has all kinds of technological solutions to offer to my firm. But we are taking it one step at a time. Prashant, over to you.
So, about 5-6 years back, when AI sort of entered the legal tech industry, or the legal industry in general, there was a rumor, is AI going to replace lawyers? Okay. But today, I think if you start reading about how AI in the legal tech has evolved, AI will not replace lawyers, but lawyers who use AI will replace the lawyers who don't. Okay. So the adoption of technology is not an option anymore. Yeah. So you have to adopt technology. And I think in doing that, I think it's just better for the entire justice system as a whole.
Yeah, if I just can comment on that. There are two things that we need just, to take into consideration. Yesterday, we've been talking about the importance of universities actually in change. Now, with the digital transformation for legal, that should start at least from the university. You cannot do the change at a later stage. If that can start earlier, that's the perfect solution. But for lawyers, that's where the start should happen. You cannot wait till you finish university and start learning, because learning should come from early beginning. Whatever you learn, you cannot stop learning in your life. That's a fact. But if you learn earlier, you'll benefit, much better. That's one very important aspect that should be added to the lawyers' components and lawyers' education and overall legal practitioner setup. Let's put it that way. In addition to that, digital, what exactly digital means? Digital is end-to-end solutions. It's not something that you can start from here, then stop. It should connect everyone, actually. This is where when in the normal digital connectivity, you have all the relevant stakeholders, whether that's the vendors, that's a customer, that's a producer, that's a supplier. You put all of them into one platform, like, the 5G technology. When you connect all of that, this is where you reach digitization and not automation, because there is a big difference, actually. Prashant can comment on that much better than I do. He's the specialist. But digitization is end-to-end solution, that you cannot have something in the middle. And this is when it comes to legal, there where you have the court system is linked to lawyers or law firms, systems, then to the client systems. This is where you have this connectivity. At the end of the day, what's important for digital, from our perspective as legal practitioner, is the customer, is the client. Are we reaching the required satisfaction? Are we delivering the right service? Is it really efficient? Is it cost efficient? All of that should be actually considered. And I would like just to, from Prashant and Rahul to comment on the digital part, and the importance of, the digital transformation. Then maybe we can talk about, the relevant, actually, connectivity for lawyers and the customers.
I also feel that it is for the government now to really step in and get the technology as a part of the curriculum straight from the university stage, at the college stage. We are talking of future lawyers, but the question is about the next generation. How do I get my next batch of lawyers ready for the kind of futuristic law firm which I am aiming for? So I think it is for the institutions, governments, as Kanchan mentioned about the universities, they really need to have this as a priority. The funding on the legal tech sector has to increase from the government. There has to be a mindset change. The lawyers are accepting it. But for the larger picture, larger good, I think even the government needs to support it. And the government's role can be clearly visible on the budget allocation, which happens every year. So legal technology is far behind. We are actually fighting for legal infrastructure. So I think it is the mindset change which Dr. Karim was mentioning about. That is really important. Prashant.
Just to touch on that topic, I think starting at the university level is super important. I'll just give you an example. The only way sort of technology and lawyers, one is from the curriculum, but interdisciplinary studies where engineering can collaborate with law students right at the law school, right? I wanted to get something like this going where at least I stay in Mangalore in India, and it's known as an education hub. But guess how many engineering schools had law schools in them? 0. Okay. So if we start from there, where at least the collaboration between the students at the university level can happen, I think that's a huge melting pot that can be created.
Prashant, I think, as far as I know, I may be wrong. So at Kharagpur, IIT Kharagpur is the only one institution where after completing your engineering course, you can do a 3-year law course for the engineers, because that specially focuses on the intellectual property rights. Because to understand patent law, intellectual property, you really need to have the domain knowledge. Because to have a patent, you need to understand the process, product. So I think the numbers really have to increase, but IIT Kharagpur is one institution which has this course where after you finish the engineering, you can also take a diploma course in law.
That's very interesting, actually. I have a question regarding the future, actually, of virtual law firms, virtual in-house. Will that really replace, actually, the current ones? Because we've been, talking about digital will not replace lawyers, but virtual, new type, actually, of offering, which will be more cost-effective, more efficient. That will be maybe something that we need to tackle. So what do you think?
That's true what Dr. Abdul, you're telling about. See, it's not that AI is going to replace the lawyers. It's not the case of unemployment. Rather, it will be the case of deployment. It will be redeployment, basically. Am I right, Prashant, what I'm saying?
Technical
It's
terms,
basically
yes.
redeployment. So that's what Dr. Abdul and what Rahul were telling about, that to have the access to justice, we need to have the new structuring of the courts, and that's basically the answer. We'll have to structure the courts. And that's what I earlier opined about, that there has to be restructuring, as Rahul was telling, that government has to take the initiative. So if government has to take the initiative, the first thing is to keep in mind what is the need of the people, what are the need of the litigants. What my learned friend has asked about. It's not, it's all about the need. And what he said is like, for me, I would say the court is not a place. It's basically the outcome. It's basically a service. So keeping this thing in mind, that court is not a place, it's a service, then how we can ensure this service at the doorstep? That is what the essence of justice is. To ensure this justice at the doorstep, many jurisdictions are taking many initiatives. So far as we talk about India now they had classified the cases, as Kanchan was telling about family courts. We had a separate family court system. Then commercial courts are there. Then we have specialized courts for negotiable instrument disputes. Now, if we take about the future, take this as about what is going to be future, telepresence. Now to teach as okay, how we can teach this this aspect to the coming generation lawyers. Telepresence is the first thing which I can suggest, Rahul, that telepresence is basically a revolutionary tactic that can teach the lawyers as to how to deal in the high-tech online environment, to process the data, how to interact with the judge, then how to put up your case. And if this subject, telepresence as a subject, artificial intelligence as a subject, that will, I think that is going to make a change if that is being included in the academics. Then we talk about augmented reality. Prashant, can you put some light on augmented reality?
Oh my God,
And
Prashant,
talking about
you
the
have
legal aspect. Coming
4
on to
lawyers
courts.
attacking you here. huh?
Because I think if augmented reality is taken into the courts, certainly it is going to make a difference. Prashant, please.
Yeah, augmented reality, I mean, Dr. Karim was talking about Minority Report, you know, Tom Cruise doing stuff a couple of years back. Yeah, on one of the yesterday's panel, I think I heard somebody say, I can't, you know, if the defendant or the plaintiff is not in person, I can't see the sweat on their face. You know.
Yeah, I said that.
That's right.
Empathy, the empathy
Yeah,
part.
I think I.
Absolutely,
Yeah.
the human touch.
So the human touch, the empathy, the real feel, I mean, that's something that can be bridged by augmented reality for sure.
Prashant, can you please just detail what actually how can augmented reality be taken into the court system?
I mean, I think the infrastructure probably for augmented reality is yet to be built in that way. We are still struggling with just telepresence.
Exactly.
Augmented reality is definitely that's something that will be coming in the future. But yeah, that is the closest you can get to kind of being virtual but still being physically present. That's going to make a huge difference, definitely.
Yeah, if I can comment on that as well. Actually, there are two things that we need just to address. First of all, from where we start, whether for augmented reality, for virtual reality, for all of that, the university plays actually a significant role in that. So when you train actually students, then you know trainee lawyers, so on and so forth, they start from that beginning. They'll understand how this can really and actually work. You'll have virtual course in the university. You'll have augmented reality even will help in investigations. Let's say when you have augmented reality that will bring you crime scene. Imagine you have a crime scene with augmented reality. You'll understand what exactly happened. And even when you know explaining things to jury, and this is part of the change, you can challenge what happened from a criminal perspective. If you use virtual reality or you know augmented reality, this is where we'll take you to the second level actually of defending your case. That will defend your case on different grounds, not the normal, you know, things where you can challenge, examine, cross-examine witnesses or experts. You can do that by using technology, and this is part of the real dramatic change in using technology in the criminal courts, and you can, you know, build on that on so many other stuff that you can use in courts.
Yeah, just to add what you mentioned from the criminal perspective, I was just reading yesterday. So in the US, there is one app called PredPol. It is used by the investigating agencies to predict where the next offense is going to take place, where the next crime is going to take place on the basis of all the information indications we have. So while Manu and Dr. Karim, we were discussing that artificial intelligence will help the judge to arrive on the basis of precedents to arrive at a decision. But the US state agencies are using artificial intelligence to predict where the next offense is going to take place. So I think for a better society, the quicker we adopt technology, it's going to be better for us.
I've been just discussing with one of the tech guys yesterday, similarly to you mentioned, Raul. and this is, he's a tech guy in Saudi Arabia. Now there is a new service that is being applied, where if you are going to ask for certain service related to telecommunication, when you call, they'll tell you why you are calling. They know the service before you ask it, and they resolve it before you order it. And this is exactly one of the things, when it comes, investigation authorities, they expect, this is where AI actually can play a significant role in that.
One thing I just come to, I just want to ask, Prashant, can you just I had one thing in my mind that there is one drawback also for if we go towards artificial intelligence. This is basically the biased data, because basically because all it's working about is machine learning, it's learning from the past data. So how to overcome that thing, because the outcome, as we are talking about the prediction analysis, if the data which is being fed to the system, that is already biased, how come we are going to expect a fair trial, a fair justice for all? Can we have an answer to that?
So I think about 4 years back, I was attending the Codex conference at Stanford. And one of the primary topics there was the algorithmic bias that can exist in AI predictions. Yeah, I mean, AI, the predictions are biased based on the underlying data. That's what I was talking about. Even if you have a complete set of data, the predictions that can come out is based on historically what has happened. So from a lawyer's perspective, you don't need to learn AI, okay? But you need to learn how those predictions are arrived at and what biases can exist. And that is, I think, the most important learning that has to happen. Because if you're going to use these analysis, these predictions of what the outcomes can be to make your decisions, either as a lawyer or as a judge, knowing these facts, it's really important.
So this is what we call informed decision. And this is part of the digital transformation, is to make sure that you are doing informed decision.
So for effective use of technology, infrastructure cannot be an option. Every court, not just the highest funded courts, need to have appropriate infrastructure to facilitate the use of this technology successfully. Right, Prashant?
Absolutely.
So that's where we are headed, and that is where the future of our lawyers exist. I mean, if anyone wants to throw up a question, we have about 4 minutes to address it. Okay. Yes, please.
So it's very interesting for all the panelists, the way you all have brought this topic. So I have a question. We have technology, right? So technology, we shouldn't be the slave to the technology, right? Technology is an enabler for us. So where do you all see the challenges, right, in the future for the lawyers? Because I come from Singapore, and today in Singapore, it's totally digitalized. So recently, we had a case where someone was put to death, hanged, because they committed a crime, I think it was in drugs. And Singapore law is very clear. You bring drugs, goodbye. There is no need to talk. So they did a virtual thing, and this guy was somewhere, the judge was somewhere, the lawyers were somewhere, and the guy was then executed later on. Right? So it's what I'm trying to say is, there are many, many things that come into play, right? One is like the challenges, because you got your security problems, you got your privacy, and then lawyers need to also understand, the emotional aspect. Because now you're putting someone away, right? And you can't even see, because you only see this part, and this part all you don't see. So I'm just wondering, because in Singapore, the way the government is moving is they're saying everything digitalized. They don't want to waste time in courtrooms. They don't want the lawyers to waste their time also. They say make it chop, chop, and chop, chop. So maybe you all can share some light as what you all see the challenges lawyers will face in the coming years.
Can I start answering this?
Please.
I'll tell you something. The first and biggest challenge is people.
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 Yep.
You know, you may have money, you may have resources, you may have technology, but if people are not ready to change, that's your biggest problem.
Irrational reaction.
Yeah, so you need to start with people, you need to start with cultural change. One of the things, you know, when we appointed Chief Digital Officer, the first thing that I've been telling the guys around me is, do you think that Chief Digital Officer will make the digital transformation? If you think that, then that's a big mistake. Chief Digital Officer will just only supervise, guide. The transformation comes from everybody involved. So the digital should be part of what the people really think and how they can deliver, or how they can really serve. So this is the most important point, actually, starting point in terms of, as a challenge, is people. When it comes to lawyers, there are maybe, others, but this is the main one. But when it comes to the infrastructure, the legislation, the resources, but those will come after people challenge. This is from my perspective, this is how I think, but I'm not sure if any of my colleagues have different opinion.
No, I agree with Dr. Kareem. My point is that in whatever jurisdictions you work or you operate in, the laws, the rules, and the regulations which are drafted by the draftsman or by the government are made with a view to encompass or predict similar kind of situations which may arise in the future, so that you don't need to amend your laws again and again. And the aim is to have a perfect answer for a ABC kind of a situation. For example, if certain act is done, then that is covered in so-and-so section. But as a challenge for the judge, there is always an element of discretion given to the judge. Because if technology was to replace, and if there was to be a precedent for every case which comes to the court, then there was no need of a judge. The judge is sitting there to also keep in mind the emotional aspect, to balance the equities of both the parties. So I think our aim should be to have the technology to support in arriving at the informed decision, but not replace the decision itself. Exactly. Because if you replace it, then I think it's a very tricky situation.
Yeah.
Thank you very
Thank
much, panelists. I have to end it here because we are at 0 minutes, but this was really interesting. We all think as technology as being an enabler, but clearly there are challenges to it.
Sure. We close with this. So the future of the lawyers is for those lawyers who not only adapt to change, but help build it. Thank you.
Thank you
Thank
very
you.
much.
Thank you very much.
Thank you.
Thank you. That was excellent. All right. Ladies and gentlemen, next we have our silver sponsor, the CEO of iBlockchain, Mr. Vasim Jarkas, that will be discussing and sharing his insightful thoughts on the topic of the role of blockchain maturity model in easing technology adoption in governments and enterprise. Please put your hands together for Vasim. Welcome.
Morning, ladies and gentlemen. We can have started. Some energy. Good morning. All right. I will start with a shock. I hope not. The amount of hacks that took place this year on blockchain-based financial products has hit a record high. Axie Infinity has been hacked with $625 million. Crypto.com has been hacked with a loss of $35 million. Qubit Qbridge has been hacked with $80 million. Beanstalk has been hacked with some kind of rug pull and flash loans with $1 billion. RA Financial Trust has been hacked with $37 million. Nomad Token Bridge has been hacked with $190 million. Wormhole hack, one of the most famous that has taken the buzz in the media, has been hacked with $325 million. Casio has been hacked with $52 million. Yesterday in the news, one of the audit agencies of crypto exchanges, Mazar, has announced that it will stop auditing Crypto.com and Binance due to their lack of accessibility of information for them to carry on their full due diligence to reconcile the records, and they have publicly announced that they will stop the audit. Hacked. Who from the audience has some staking or yield farming in one of the DeFi projects that exist right now? Show your hands. Okay, not bad. After this, who from the audience is ready to take the risk to actually invest $100 in one of those projects or future projects that are based on the same concepts? Raise your hands. I will not. My name is Wasim Jarkas. I'm the founder of iBlockchain, and I am here to present for you an effort to a potential solution of a very promising technology, which is blockchain. Whatever has happened here is bad actors. This does not mean that the technology and the promise of technology is not sound. We as humans, with our practice and our greed, we make it become bad. But with proper regulation, proper governance, proper references, proper standards, we can actually create some kind of order in a rather chaotic technology that has reached the hype stage in a very fast pace. But it's time to take that one step back and introduce some regulation and some order in this very promising technology, and then reap the benefit of this promising technology. Hence, we have, okay, the order is the blockchain maturity model. The blockchain maturity model is based and backed by a culmination of effort for almost 3 years by the GBA, Government Blockchain Association, that's based in Washington, D.C. Arguably, GBA hosts the biggest landscape or the highest number of landscape of professionals under one umbrella, one association with the aim of delivering the promise of what blockchain technology has to give, yet in a very regulated environment. So the blockchain maturity model is actually a culmination of a combined effort of several work groups for almost more than 3 years that has ended up with a first, we claim, that's the first reference model, the first standard, the first real attempt to regulate the industry, measure the industry, create a qualitative and quantitative measurement on blockchain projects, blockchain-based projects, basically in the financial industry, that would convey certain level of reference and trust for everyone who wants to engage in these projects. Look at the report, read, see what kind of maturity it is, and then accordingly make your own due diligence, make your own judgment, and decide whether this project is worth your investment, worth your time, or maybe not yet, that some development needs to be done. So it's a culmination of IT specialists, blockchain experts, financial industry experts, and lawyers. In GBA, we have more than 20 work groups that works together. These were the 3-4 main groups that were involved together for the last 3 years in order to come up with this model. We, iBlockchain, are actually the representatives of GBA in the GCC and MENA region, and we work closely together. So, agenda for today is why the GBA BMM and why we need a banking and financial supplement for BMM. So BMM comes as a standard for the whole industry, and then you understand, I think you would appreciate that for blockchain, it can touch several industries, several verticals in the industry. It can touch the financial sector, it can touch the health sector, it can touch the regulatory sectors. Many sectors are touched by blockchain. Blockchain is disrupting a whole plethora of industries. But then the work groups decided that the BMM needs a special supplement for banking and financial sector, and we will see why. So we will go through what is a BMM, the blockchain maturity model, an overview, and then why we need a supplement. We will look at the overview of the supplement. We will look at the underlying use cases. We will look at the requirements. We will look at how the assessment process works. And you will see how exhaustive it is really to build a really reliable model and reference that we can back to and drive our decisions accordingly. We have been just talking in the previous panel about the data-driven decision-making. This is a tool that will help us in the process of data-driven decision-making. And then we will talk about more information and next steps, and then we will open the floor for some Q&A. So, why the blockchain maturity model? As we said, we have a plethora of blockchain solution types. We have real estate, we have finance, we have DeFi, we have health records, we have insurance, we have. But then, how can a solution buyer really assess this solution is viable, this solution is working, this solution is trustworthy or not? And given the fact that the blockchain is more or less still a nascent technology, yet it has progressed very fast, we have very few expertise in the industry that can drive the solution and help in driving these kind of decisions. So we have a bleak plethora of blockchain solution and blockchain solution types, yet a buyer has to have a medium to assess, is the solution trustworthy? And as we have seen the amount of hacks, blockchain is still, unfortunately, with all the promise the technology is delivering, is the wild, wild west so far. And then the second dimension is, how does a solution provider himself, I am a solution provider, and I want to deliver that solution to the public. However, how can I articulate my capabilities and how I can do some self-reflection on myself in a very independent manner to see, is my solution secure enough? Is my solution adequate enough for the verticals or for the industry that I'm trying to serve at the end of the time? And the blockchain maturity model is an objective measure for the buyer or the seller to come and independently assess yourself, create a grading matrix, assess where you are on the grading matrix on several dimensions, and come back with where you are today, where you need tomorrow, and it becomes an evolutionary journey on how you will mature yourself more and more over the course of time and reach a higher level of maturity model. So it's a closed loop model. It does not stop and say we have done. No, it's a continuous effort of improvement. And given that the blockchain is, again, an ever-evolving technology, it's not going to stop. So this model will evolve with the technology, and then once the engagement is there, we will keep doing an evolution cycle with a closed-loop model. Now, that's the blockchain overall. Why the work groups have decided that we need a supplement that is dedicated for finance and banking industry? We have identified there is a plethora of banking and finance use cases that are unique and specific for the finance and banking only. So it has to have some kind of a dedicated drill down on how the maturity model can tackle the specific peculiarities that exist in the finance and banking industry. There are a series of requirements that are applicable to maybe or maybe not some of these use cases. So we will end up with a complicated matrix that will tell you that for this specific use case, for the specific scenario, what kind of measurements are applicable and what kind of measurements are not applicable. Then, relevance to the future industry and recent headlines. So again, as we mentioned earlier, the blockchain as an industry, as a technology, is evolving very fast, and there is a need that a model, a reference model, is evolving with the blockchain evolution and can form this closed loop mechanism where us as a financial industry or the banking industry, we remain relevant to the industry. We don't make a one-stop choice and then after that, 6 months or 1 year down the road, we become irrelevant because we did not adopt the evolution that is taking place. Now, the maturity model itself is assessed over 5 layers. The first layer, we call it the initial phase, the initial layer, or we call it level 1. So what is level 1? Level 1 is we identify that the solution provider, the project, or the solution itself has actually achieved some element of documentation of their system, their processes, how they are adopting the blockchain, and they have documented they have achieved certain level of documentation, reliable documentation on those dimensions. So this is what we call a level 1 maturity. A level 2 maturity, it's called a documented level of maturity, which means that the whole solution has been properly documented in what we call a solution document package, SDP. So the solution provider or the project has actually achieved a fully reliable, documented package on the whole solution end to end. Level 3 of maturity is validated, which means that there has been identifying adequate evidences that solution actually demonstrates that the function it has been intended for is functioning the way it has been designed and the way it has been intended for. So that's what we call a level 3 maturity, which is a validated maturity. Level 4 maturity, what we call the production level of maturity. This means that the solution is capable of a full operational deployment. We verify that at level 4, all the 3 previous has actually been fully deployed, operational, and delivering to what is supposed, designed, documented, and supposed to be delivered. That's level 4 of maturity. Level 5, optimization states, which means that we ensure that whatever has been in production is maintainable, is consistent, is reliable, and has the necessary performance requirement over a long period of time. So that's what we call the optimization state or the maintenance state. So these are the 5 levels of maturity that we measure a product or a service using the blockchain maturity model. Level 1 is initial, level 2 is documented, level 3 is validated, level 4 is production or producing, and level 5 is optimizing, which is the maintenance state of the project or the product itself. So these are the levels of maturity. Now, the measurement dimensions of these levels of maturity. As we said, there will be many levels dimension. On each dimension, we will attribute that level of maturity, 1, 2, 3, 4, 5. So what are? First level is distribution. What do we assess? We assess that there is no concentration of implementation of the blockchain solution itself. And then we say blockchain solution, it can be, again, the industry on which that blockchain is being used, whether it is healthcare, finance, banking, you mention it. So we measure that there is enough level of distribution that is occurring, that is reliably occurring, so to move away from the centralization dilemma. Number 2 is governance. What we measure, the second dimension, is that there is an effective management and governance in place for all the components for which the solution has been designed for. Number 3, identity. We ensure that controls are in place for identity and access management. Number 4, interoperability. We ensure that the solution itself is able to share and use information and assets over existing infrastructure, legacy infrastructure, and even over other blockchain solutions. Interoperability is another measurement, another dimension we measure on. Number 5, performance. So we ensure that the transaction, the volume, the speed are suitable for which the use case has been implemented for. That's performance. Privacy. Yesterday we spoke a lot in the session about the GDPR and privacy, and there was a mention, I remember it was stuck in my mind, the T's and C's, the gentleman, I don't remember if I can see him here. Yeah, over there. Our colleague from Singapore, I believe, where he put in his T's and C's that he's gonna give, I don't know what, $1 million, and then he put in the T's and C's that you will give me your firstborn child. And everybody ticked that. And then, yeah, they didn't think that how they're gonna give him his firstborn child. That was, so yeah, privacy. We ensure that the solution has adequate encryption protections for all the personally identifiable information, the PIIs. Reliability. We ensure that there are adequate controls in place to address and mitigate the resolution of any possible forks, blocks, errors, or fraud. This is specific to the blockchain, but basically what we ensure is that there is enough measurements, designs, implementations, and maintenance that has been put in place in order to deal with any kind of error or fraud attempt. Resilience. We ensure the continuity of operations during unforeseen events, failures, like disasters, floods, any kind of natural disaster, any kinds of technical disasters. We ensure that the solution has been designed, implemented in a very resilient manner. Security. We assure that there have been implemented and designed adequate controls to address and mitigate any kind of end-to-end risks for the solution itself. Infrastructure sustainability. We ensure that availability of all resources required to maintain the capabilities and satisfy requirements throughout the life of the solution. So we have to ensure that there is enough adequate infrastructure in place in order to mitigate and in order to deliver the performance required of the solution. And last, what we call synchronization, is to be able to assess the means of the network to achieve consistency and completeness for the finality of the transaction over a fully distributed system. So these are 11 dimensions. We believe at the first stage that's quite exhaustive where we are today, and it's a continuous evolution of this journey where probably in subsequent revisions and subsequent versions, there will be fine-tuning for that. But we believe that we are the only model that exists right now that has such an exhaustive measure over all dimensions, and each of the following dimensions are measured over level 1, level 2, level 3, level 4, and level 5. So that's the blockchain maturity model overview. Now, let's quickly move why we need a banking and finance supplement. The need for a supplement came out from the standard and certification group itself, saying that we have to have a supplement for the banking and finance sector, because what we have designed as a generic model probably has to meet some peculiarities only attributed to the finance and banking sector. Then these requirements has been transferred to internally to what we call the banking and financial group, and they have identified a spectrum of use cases for which there is a unique differentiation of products, services, and functions. And accordingly, there has been a tailored model that is only addressing and tackling the banking and finance sector. Against each of those use cases, the working groups have identified a set of requirements that will be attributed for those specific use cases. Now, what we believe is that those requirements represent the peak and might not be applicable for all the requirements. That's why a continuous engagement through that process with the assessor of the blockchain maturity model needs to be in place to finally agree on a matrix where what is applicable and what is not applicable, and we will see that matrix as an example at the end of the presentation. So, for the sake of time, I'm thinking I'm being, so, yeah. So, what are those supplementary use cases? We will go quickly through the supplementary use cases. Additional information we can provide at the end because it's extremely exhaustive. The list is really, each one of those attributes, we can spend another 1 hour on them. So value transfer for business, B2B value transfer. Individual banking, that's a unique specific use case for banking and finance. Private banking. Institutional banking, community banking, micro-lending and micro-payments, credit cards, debit and prepaid cards, central and national banks, central banks' digital currencies, capital markets, debt, equity, structured financial products, exchange-traded derivatives, over-the-counter derivatives, retail investing, institutional investing, governments, supranational bodies like IMF, cryptocurrencies, centralized exchanges, DeFi, including decentralized exchanges, NFTs, and I think, in my opinion, the last one is the most important one. That's my personal opinion. P2P distributed apps, the D apps. Most of the hacks that occurred in the previous slide are actually attributed to that specific components. So these are the use cases that are attributed specifically and solely for the banking and finance sector. What do we measure? Quickly, I'm going to through this for 2-3 minutes, and then I'll open the floor for some Q&A because we're running out of time. So we'll just do it in a couple of minutes. What we need to have for these specific use cases, we must have auditable records. We must ensure that the clearance and settlement is actually properly implemented on those use cases we have mentioned earlier. So these supplementary requirements are unique only for banking and finance sector. We need to ensure confidentiality. We need to make sure that for the digital securities issuance that are controls that are only perfected in the network on which they have been implemented. We have to ensure that the distributed ledger records are compliant with the banking and finance requirements. We need to ensure that there is a proper distributed settlement that has been implemented in place. We need to ensure that double entry accounting practices are actually implemented as per the guidelines of the banking and finance industry. We need to ensure about fractional reserve accounting and the practices around fractional reserve accounting. We need to ensure that the obligations of future dated transactions are properly implemented. We need to ensure that there is enough high capacity in order to deal with high transaction and high volume of transactions. We need to ensure identity verification, KYC, and AML requirements. We need to ensure interoperability on 3 dimensions with existing infrastructure, with other blockchain network, and with other blockchain protocols. We need to tackle the lending aspects, payments, receivables, and make sure they are also compliant. We have to ensure real-time settlement is actually happening as per the requirement, and there is audit trail for all these real-time settlements. Reconciliation of records. This goes back to what I have mentioned earlier, that Mazar yesterday they have announced that they will stop the audit because they could not reconcile records. So this will tackle that specific problem. And regulatory reporting and monitoring of regulatory reporting, scalability of the solution itself, tax and tax requirements that has been implemented automatically on the solution itself. Third-party legal responsibilities like power of attorney can be reflected and indemnified from the solution itself. Transactions and balances. Now, that's the matrix I have told you about. It looks a bit complicated, but that's where the engagement has to happen. So here you have all the financial services use cases, and here you have all the metrics that we have defined, and we create a matrix that for each of those services, what is applicable, what is not applicable. Some of them has been already identified, RRR, you see that it is actually required. When you see A, that assessment is still in process, and it can be subject to the mutual interaction that if it is qualified as required or not required. And then NA, it means that that specific dimension on that specific service is actually not applicable, it's not required. So it's quite a comprehensive matrix that tackles specifically the maturity assessment for any financial services in the banking and finance industry that is leveraging and using the blockchain technology. We believe and we take pride that we have the most exhaustive functional model that exists right now, and we have not seen so far anything that is close to what we have achieved. And we look forward that together we can push that technology, we can push the end of that technology, but in a very mature way. And hence we have the blockchain maturity model. Thank you so much.
Thank you very much. We have time for one question. Anybody would have a question? Yes?
Yeah, I just wanted to understand, as we are now living in entire digitized banking system and mobile app, and initially when this technology was introduced, it came up with a myth stating that it cannot be hacked, okay? And now it has been proved, whatever your previous models have. So they are able to achieve it. I want to understand in what way your BMM is different from the earlier version, and whether it is hacked, and can we continue with the myth?
Okay. I'll answer you. In all the hacks you have seen and we have seen so far, it's not the blockchain itself that has been hacked. It's the ancillary systems that are accessing the blockchain in an insecure manner due to lack of knowledge, due to lack of personal due diligence, due to the lack of the security of the infrastructure itself, that has led to a leak that has ended in a hack. But the hack has happened on the application, or hack has happened on exposing personal confidential information that has not been properly stored by the owner of the information itself, that has led to access to the blockchain itself. There is almost zero hacks that took place on the blockchain itself. Now, having mentioned that, yes, there are blockchain solutions that has been immature, not to scale, not fulfilling all the requirements of a decent blockchain solution. That's why it has been hacked. By following the blockchain maturity model, you will be able to see and deduce that is that solution on all the dimensions we have mentioned, compliant? Is it mature? Is everything on level 1? If everything is on level 1, then probably you will say question mark. Is this something that I want to engage with? These are still at a very nascent maturity model. Maybe yes, maybe no. But if you see that the dimensions that are important for you as a buyer, as we mentioned earlier, maybe not every dimension is important to you. Look at the dimensions that are relevant and important to you, and you will see, okay, what level of maturity the project or the product has achieved on these specific dimension, and accordingly, you can make your own judgment, your own decision that yes, that's safe enough for me to go and engage or not. And then, as I mentioned earlier, it's an ongoing journey. It's an evolutionary journey. It will not stop on one place. This is a feedback cycle that keep evolved and then keep mature over time. But at least there is an attempt right now where we have an actual reference model that is fully exhaustive and standardized in a way where everybody will be talking the same language, and we say that, okay, to what level each dimension is matured.
Thank you very much for sharing this knowledge with us. Please put your hands together for Mr. Wasim Jarkas. Thank you, sir. Thank you. All right. Thank you, Wasim. And now, we have some amazing individuals who will be receiving recognition for their outstanding contributions in the field of law and finance. These remarkable individuals have made an immense impact on the success of their respective companies, demonstrated remarkable commitment and dedication in the pursuit of excellence. So I would like to call upon Ms. Corina Reibchen, CEO of Crypto Blue, to please join me on stage to present the awards. Oh, there you are. Hello, Corina. All right, ladies and gentlemen, are we ready? And our first recipient will be Mr. Ray Vikram Nath. Congratulations. Come on up. You. All right, our next award goes to Monsieur Esther Ong Tenku Saiful Sri. Congratulations. Awardee is Rawan Abdel Noor. Congratulations, Rawan. I believe we will hold on to Miss Rawan's award. Yeah, she's not present at the moment. Okay. Next, we have an award for Mr. Hans-Peter Beisser. Congratulations. I will be calling everyone who's received an award back up. Mr. Ray and Miss Esther, I forgot to give you mic time. Mr. Hans-Peter, a few words, please.
Well, I thank you so much. It's really a great honor for me to be here and to be awarded for all the work I have been doing for so many years in Germany, basically in Munich, doing real estate law, company law, some law, some work for charitable organizations. It's really great to be able to be here, to be presented with this award. Thank you so much.
All right, Mr. Avery Kremnath, I'm calling you back because you deserve this. Come on up, share a few words with us.
Thank you so much for calling me again on the stage. It's twice today. So, thanks to the organization. I have had a brilliant time over here, and I look forward to continue to be in touch with everyone that I've met here. Thank you so much. Thank you.
Thank you. And Miss Esther Ong. Oh. Welcome back.
Thank you for giving me this opportunity to give thanks. Of course, first and foremost, to thank God for this award given to me. And of course, secondly, I would like to really give tribute, or rather give thanks, okay, for my team. In fact, the award is rightly given to my team because really without them, I don't think our firm can really do well. Right? In fact, contrary to what later on I'm going to be a speaker for AI and IP, I am really a proponent that human resource, or rather be called human talent, is very important. Yes, I recognize AI is important, but human resource. Therefore, my legal team, yes, this is your award. Thank you. They're listening. Thank you very much.
Thank you. Thank you for those words. All right, our next awardee is going to Josh Dahlia. Come on up, Mr. Dahlia.
Thank you so much, everyone. It's been a very pleasurable month for me. First and foremost, just got married 2 days ago. My lovely wife is right there shooting my lovely video. 2 days later, post my marriage, little would I thought that I'm here amongst all of y'all. It's a great experience, great exposure, nice meeting some very important and interesting minds. And I do believe this is a very global platform where we are all able to share something much in common, that, you know, law is the way forward and we are only progressing forward as humans. We've gone through a pandemic, but we've all realized and we've come out stronger. From whatever my little conversation with everybody has been, I've not heard a single sob story. I've only heard how the pandemic struck, yes, but how we've all come out stronger. And I do believe so. It's only going up, up, and up for all of us. Thank you so much, everyone.
Thank you, Mr. Dahlia. Next up is an award for Anaga Anansigaraju. Congratulations.
Good morning, everyone, and congratulations to all the other recipients in this program. It's great to be here in Dubai, and I would like to thank my parents, my family, for the unstinted support which they have been giving, and also my team. Thank you.
Congratulations, Miss. Our next awardee is Anish Vohra.
Good morning, ladies and gentlemen. First of all, thank you so much for being here and being a part of this event. A huge thank you to the organizers of this event for giving us such a seamless, settling in. I am Anish Vora. I am an associate partner at Peer Counsel, one of India's leading boutique law firms. At Peer Counsel, we are a full-service law firm where we forte in venture capital transactions, private equity deals, cross-border advisory, cross-border structuring, in prominent jurisdictions such as Dubai, Singapore, the United States. We take great pride in also being part of a lot of technology, structuring, working with emerging entrepreneurs, and helping them protect their intellectual property. It truly is an enriching experience. Again, thank you so much for giving me this recognition. Truly happy to be here. I look forward to meeting you all over lunch and getting to know you all better. Thank you.
Thank you. Congratulations. Next award is for Dr. Abdul Karim Al-Kadomi.
Good morning, ladies and gentlemen. Thank you very much for your attendance. First of all, I would like to thank Allah the Almighty for His countless graces and blessings on me. I would like to dedicate this award to the soul of my beloved late mother, who passed away just 2 months back. She was one of my biggest supporters in everything that I achieved in my life. I would like to also extend my heartfelt thanks to my wife, my daughters and sons, for their true belief in me and supporting me all the time, actually, to do whatever it needs, whatever it takes, and giving me the comfort and space that I needed. At the end, I would like to also to thank the president of my company, of Abdul Latif Jameel, Sheikh Muhammad Jameel, for his trust and belief in the legal team, in the organization, and also engineer اللهم صل وسلم Faisal Samanoudi, the chairman of Abdul Latif Jameel Enterprises, for his continuous support and trust in the legal team and in me as part of the executive team. Thank you all and have a great day ahead.
Beautiful words. Thank you. Next up, an award for Mishika Bajpal.
Ladies and gentlemen, I'm Mishika Bajpai, a practicing advocate from New Delhi, India. I'm a member at the Chartered Institute of Arbitrators, United Kingdom. I'm also practicing civil dispute resolution for both private sector clients and public sector undertakings in India, and also cross-border resolution disputes. I've also had the privilege of publishing with the Harvard International Law Journal, but it's an honor to be standing amongst you all legal and finance luminaries. It's an honor. Thank you so much. And I'm hopeful that we all interact today. Hope you all have a great day. Thank you very much.
Thank you, Ms. Mishika. The honor is all ours. Next up, an award for Miss Hannah Becko. Congratulations, Hannah.
much to the conference organisers for contacting me earlier this year when they saw I'd released my book, The Authentic Lawyer. The book is really part of my legacy to change the culture in law and to leave this profession better than when I found it. I'd also really like to thank my assistant Diane, who's come with me all the way from England. Without her the last 6 years, I wouldn't be able to run the businesses I do. And also without my husband and my boys at home, they're, I suppose, the foundation I stand on, and they keep me going when I'm tired. Finally, I'd like to thank all the wonderful lawyers I've already spoken to here, who do seem to support the mission to improve mental health and well-being in law, because I can't change the culture on my own. I can change it with the help of everybody else. Thank you very much.
Thank you, Ms. Beko. Next award is for Mr. Manu Joshi. Congratulations, Manu.
Good morning, ladies and gentlemen. It's a great pleasure to be over here. And I would like to congratulate, first of all, the organizers and all the legal stalwarts and the luminaries of the legal industry who are present over here. Thank you all, and thank you very much. Last but not the least, I would like to dedicate this award to late my father, Mr. R.K. Joshi, because without whose blessings, this would not have been possible. Last but not the least, I also want to mention one more person, without whose presence, without whose inspiration, I would not have been here. She's with me today. She's right out there. I owe this to you as well, dear. Thank you very much.
Thank you, Mr. Manu. Our next awardee is Geraldine Bless. Congratulations, Geraldine. Come on up. Congratulations, Geraldine. Next up is an award for Sanjeev Gathani.
First of all, I would like to thank all my fellow recipients for the award and also the organizers. I think the organizers probably will tell you I gave them such a hard time because I couldn't get flights, I couldn't get everything, but I finally made it, and I would like to really dedicate this to my parents and my wife, who is in Singapore taking care of the kids, and she couldn't be here. But it is really, really, without her support, I won't be here today. Thank you.
Thank you, Sanjeev. Next award is for Prashanta Kumar. Congratulations, Prashanta. There you are.
Good morning, ladies and gentlemen. I just want to refer our yesterday's afternoon panel, where I think Hannah, Shah, and Ro and other designatories on the stage were discussing about issues, not on the legal issues, issues. Because it's not only the legal issues, the issues will decide anybody's fate. So with that, I would like to thank my wife, my kids, and my family who has been standing by me, sacrificing their valuable time for my growth. Thank you, and I would like to thank my team. Thank you, and thank you, organizers, for considering me for this award. Thank you. Have a great day.
Thank you, Prashanta. Also need an award for one of the most active members of the audience. All right, our next award is for Mike Hindi. Congratulations, Mike.
Hi everyone, very excited to be here today. First of all, I'd like obviously to thank my wife, my kids, my parents, but also to say big thank you to my team who has welcomed me after the transaction a few months ago. I'm now part of the Green Logistics family, and I really love the values of trust, integrity, and long-term sustainable partnership. This is such a blessing to have that, and I, thank all the different partners that we have who have been relying on us all these years and hoping for a long-term sustainable partnership. Thank you.
Thank you, Mike. Okay, next award is for Amit Bendale. Come up, Amit.
Good morning, everyone. I'm Amit. I'm the co-founder at Bright Capital, and we are into AI-driven financial planning. So lots of interesting talks on AI in law, as well as finance. So yeah, very relevant. And I would like to thank my team at Bright who work really hard, and my family for believing in me. And thank you, Money 2.0, for considering me for this award. This is the first global recognition for me, so it will be special. As well as thank you all the other dignitaries who have received an award today. So yeah, best of luck, and I wish to interact with a lot of you. Yeah.
Thank you, Amit. Okay, next is an award for Mayur Podar. There you are.
Good morning, all of you. I would like to dedicate this award to my mentor and teacher, Mr. Jignesh Shah. He's the founder of 63 Moons Technology. I would just like to say a few words for him because I'm sure he's watching live. So just want to say, boss, this is just the start, and there is many more to come. And also would like to thank all my family members and the team who has always been very supportive This is because of the team that we are here today, and they are rigorously working 24/7 round the clock so that 3.0 verse tomorrow can be a super app, of course in blockchain, decentralization, and the crypto space. Thank you, guys.
Thank you, Mr. Mayur. Our last award for the morning will be for Mr. Manan Dikshit of FidiPay. Congratulations, Manan.
Hi everyone. I'd like to thank Money 2.0 entire team for organizing this amazing event and recognizing us for this award. I'd like to thank my entire team at FidiPay for putting up all the hard work and effort so that we can be here where we are right now. Lastly, I'd like to thank my entire family and the friends and family at home. Thank you.
Thank you, Ms. Corina, for joining me on stage and presenting the awards. And congratulations to all the awardees for all your hard work and your efforts. And it's really lovely to be listening to your words of thanks to family members and to your team especially. It is a team effort. And I have to say, it's not an easy job that you have, especially with all this talk of virtual, and I would definitely not want to deal with an AI robot when dealing with legal matters. So clearly, a lot of change in the digital transformation world. Okay, so next session will be a panel discussion. And so we have here at some point in time, I'm sure every law professional wonders what it takes to grow a law firm and make it known globally. Our upcoming panel will answer this question while exploring how different firm leaders scale their organizations to get loyal clients. So this panel discussion is on scaling your law firm to win international clients. I would like to call upon our panelists for this discussion. Harsh Girish Patel, founder and managing partner for Water and Shark. Mr. Harsh. Joining Mr. Harsh is Mr. Stephen Ranger, Business Development Director for Hussein Luta and Associates. Welcome, sir. Pratik Harsh, contract analyst at Condé Nast. Nevin Jacob Koshi, legal consultant for United Trademark and Patent Services. Welcome, Nevin. And Jash Dalia, legal counsel, Office of Advocate Jash Dalia. Welcome, gentlemen. Perhaps we can put the chairs in a bit more of a semicircle so you can see each other. And the microphones we will need. Where are they? Oh.
Hi, good morning, everyone. I hope the morning's good for everyone so far. Breakfast been good? If breakfast been good, then give me a good yay. That's good, that's good. Now, so let us all dive into this topic. Now, how we are going to go about it, and before I even come to the topic, we have such an illuminated desk over here that we've all come from different facets of life. We've come from different realms. We have a council, we have an entire firm in itself, we have people who've gone global, we've got people who are working on the backbone to make things go global, we've got people of various entities over here. But we've all come here to speak over one thing, is how do we scale and how is it possible for not just one firm, but how an individual advocate can also scale. It's a very interesting and an important topic that we'll be delving upon. So I'm Josh, and I'll be the moderator for today's session. The topic that we are diving upon is how to scale. Now, as we all know, we've all seen that the pandemic struck us, and as I said even before, it struck us and it basically got us a few years forward in that sense. Because things which were all local have not just gone nationalized, but have gone global. We are not just talking about ourselves, but we are dealing with people across the sphere. We are on the screen, we are looking at people across this globe. We are there in one city another day. We are there in multiple cities and multiple countries in the same time, at the same day, possible through technology, possible through vision. The most important thing that we see over here is vision, is that one needs to strive to go forward, 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 and not be complacent and just be tired up on things. Secondly, it's important when we look at a global specter that it's not just for a firm or for a top 5 firm or for a large scale entity, but a single advocate or a small entity can also grow. And when we mean by scaling is not just growth in clientele, but scaling in thoughts, scaling in vision. You know, people have scaled from different fields. Law is a vast field, as we all know. Law and money together are vast fields. But we've all gone from different branches. We've opened new avenues for ourselves. And that essentially is the ethos behind scaling. Now, before I go further and dive further into the topic, I would like my fellow friends, and I call them all friends because we've had some great discussions already. And I don't consider them my co-panelists, but friends and all friends speaking together on these aspects. I'd like to give the mic to Mr. Stephen Ranger to share a few words with us.
Thank you, Josh. Clear? Okay. Yes, so I'm a director of Hussain Lutar and Associates, which is now a major local law firm. I've been there since 2010. I'm not a lawyer myself, by the way, but I am a director of the firm, so I became very close friends with the founder. So I'll just quickly, 5 minutes, tell you the story, because it's quite the way we went about scaling internationally was quite unique. But like most successful things, simple. I had a look at the luxury law alliances. I had a look at so many of these alliances around the world, and none of them I really particularly liked. And I wanted to set up something unique because my perception, one of the reasons I came into the firm and joined, because certainly in Australia, and I'm Australian background, the service, in my view, of legal firms is very ordinary and quite an arrogant attitude. And I had many businesses there, successful, and I never really found a lawyer or a law firm that I particularly liked, to be honest with you. So I was looking for a unique situation who shared the one thing we did have, and we still have, is a real care for our clients. So one of my real driving forces is to change the paradigm, change the structure, and develop a real care for your clients, not about fees at all. Fees are almost secondary. So at the time, funnily enough, I'd been invited by the Ruler's Office to do trade missions around the world promoting Dubai. This was in 2016-17 we started doing this, which is when, in my view, Dubai and the UAE really established itself as a strong base. And it was also the time we were, of course, promoting Expo 2020, so I was also asked to become an ambassador of Expo 2020, and I hosted the country. So as I went around the world on these trade missions, and we would follow His Highness Sheikh Mohammed bin Rashid Al Maktoum about 10 to 14 days after he visited each of these countries. And we did Europe, Germany, France, Italy, Spain, United Kingdom, of course China many times, Germany many times, because it's a real stronghold of law field, Brussels, and then into South America, Brazil, Argentina, etc. And on we go. So I use this as the means at the same time. I was donating my time because we were being hosted by UA ambassadors and whatever, so being taken very good care of. But of course it gave me credibility, certainly, and almost all the cooperation partners I formed associations with were in fact already attending our sessions. So I didn't really have to look that hard for them, but after discussions I found the right sort of people, and I built a tremendous worldwide network of real quality law firms who very much share our views. And between the start of 2018 and 2019, we in fact more than doubled our size each year. So we in fact went from the 1st of January 2018 to the 31st December 2019, we went 5 times our size. We became probably the second largest local law firm in this country, obviously next to our Tamimi, who are far ahead, but alongside Galadari, Hadef and Partners, these sorts of firms. So it was very successful, quite a unique approach. As I said, I didn't really have to look for them. They pretty much found me, and of course, I came with credibility. So it was, I guess, a very unique package and a unique way to go about it.
Thank you, Stephen. So what we all understood over here is there are 3 major words that I can coin out of this. One needs to has to dive upon every opportunity that one gets. You know, you look around your place, you look around the world, you will find so many opportunities, but you have to take them hands-on. Secondly, what Mr. Stephen really pointed out, making good associations. You know, he's delved upon how making good associations in different forms and in different worlds and clubbing them together to form a nice unity. And thirdly, he saw the problem. First point of, growth, or first point of progress is first you find the lacuna, find your problem, think about solving it, and you will eventually get to solving it. Thank you so much, Stephen, for spreading this. Next up I have Harsh, delving about some interesting topic.
Sabah Al Khair. Am I audible?
Yes.
Good morning, everyone. So, before I begin, a few aspects on deep dive into how to scale the practice. I want to highlight the point on the mindset. We all are gathered here for one important aspect, and what we are deep diving is scaling up your law firm, be it an individual capacity or be it firm. Major component is contributing to that is commercial success. So where I'm coming from is the mindset. So many of our learned advocates who are sitting over here, their experiences might be quite more than my age. But in my short span of 1 decade, which I started at the age of early 19, much before getting bar license or practicing as a chartered accountant, I learned one important aspects in if I have to reach anywhere, if I have to benchmark with the world best, not in your locality where you operate, be it in your country, be it in your state or anywhere. So compare with the world best professional firm and try to implement. If you compare yourself with the worst built firm, then I am sure you will fail above average. So that's where comes from. The point number 1 is a mindset. The mindset to reach to where you want to, that is very much important. Number 2, don't limit yourself to any particular boundary, be it in terms of different areas of practice, be it in terms of geographical expansion and so on. So a short story that I would like to highlight. So if you are sitting in one corner of one country and you are practicing in one area, I'm sure over a period of time, once you get a seniority or expertise, that will also add a lot of growth and potential to your firm success. But if you want to charter the different waters, you have to have a courage and risk factor. That's where the element of entrepreneurship comes for scaling up your practice to a global level. Risk awareness. What does that mean? So when I started at the 19 age, I took a courage that if I want to be in 20 years, 30 years to be on a level where any of the world's international law firm or the CA firm stands, financial consultancy, CPA firm, it doesn't matter where I come from. It doesn't matter what resources or what finances I have. If we can see the vision, if we can execute it and design it, then I am sure there will be more better chance than doing nothing. So I took up a challenge, and every geography which I used to like as a maybe travel or maybe something, just exploring, understanding that country's laws, capabilities, what we can deliver, what we can value add to clients, and slowly, steadily, hobby turn into a passion, and then leads into 8 jurisdictional as an office in just 8 countries. So it can be anything. Some other person having some different within a country expansion or be it related to the functionality expansion. So the second point which I highlighted is nothing but the risk-taking capabilities and abilities. As a law practitioner, we don't have to always think like a attorney. It is very much important to think and act like a CEO. Why? Because you have to work on your practice, not in practice. It's a very thin line of difference between on and in. When you're working in your practice means we have a limited time of 8 hours a day, so that you are getting paid for your time. And if you are working on your practice, that means building up your practice, creating the system, creating the team, and getting a dream client for your work. That's all I will touching upon in the later aspect as well. I will leave the floor to my learned friends come co-panelists.
Thank you, Harsh. Some very interesting topics, which I will be delving upon soon. Now, I would like to Mr. Nevin to please have a word.
Good morning, everyone. Thank you so much for sharing both of your thoughts. Mine is a decade, so not so much. I'm still learning. I would share my experience. I'm a partner for United Trademark and Patent Services. It's an intellectual property law firm. It's a boutique firm. We are a regional firm specializing in 18 jurisdictions, but locally present. International clients we represent international clients in this region. As a firm, we started with 1 office. Now we have around 18 offices. And as I said, for our local clients, we partner with US, Europe, and other law firms to do the work. When I joined the firm, the senior partner and the chairman told me this one simple statement. Nevin, we understand your credibility, we understand your CV, resume, everything. But what we need is not so much client that at the end of the day, we are not able to handle them. Even if you bring in 1 client, make sure they are happy. I don't need a complaining client at any point of time in your career. That went a long way because this is my 4th job, and the last 3 had its own share of experiences for me, but then this was an eye-opener for me. Because there was not a pressure from the firm that I get that you should bring in so many clients. That's typically how a law firm functions, right? You bring in more clients, you get so much. But here it was a different approach that they've taken, because if you have 1 client who is satisfied, then the word of mouth goes to the next one. And we always believe in referrals rather than just marketing. And also, as a firm, we don't market a lot. It's our existing client market for us to other set of clients. So that went a long way, and even now I practice. That's from the firm's perspective. Now, me as a partner, what I do is I need to empower, which I mentioned yesterday in my brief when I received the award, is to empower your team members. Because the reason that I'm here away from work is because there's a team that is functioning. And if I'm not able to build on and make sure I have a happy set of clients, there is no point in bringing more clients to it, because I'm just bringing more ruins to the firm. So empower the team. And I make sure that my team members, I have a daily, a weekly conversation as a team, as an individual. And randomly I'll call them and I'll say, are you happy? I don't ask about work, I don't ask about anything. I ask them, are you happy? And if the answer is yes, then I'm happy. There might be ups and downs in a week if I'm taking a week. But then if the answer is no from that particular team member on a constant level, then I start working on it. What is the reason? And I always tell, there is something that you agree, that is something that you disagree, and you agree to disagree. And if you know exactly both the partner and both the person are in that category, then we either work on it or you move on. So that's about the second part, empowering your team. The third is credibility, which one of the panelists have already mentioned, is when you talk to people, if you're not sure about a service that you're not able to provide, do not say yes. It's like, this is not our practice, but hey, I know XYZ who does that. And we do that quite often because we specialize only in IP. There's a lot of corporate work that gets to us, tax. We politely say no. And we refer it to other law firms who specialize in it. The advantage there is your credibility goes up, and then people know that as UTPS or United Trademark, IP is their forte. And if is there anything that is else that comes to their way, they refer to the right candidate. So these are the 3 points that I believe that goes on a day-to-day level to scale up your practice.
Thank you so much, Nevin. Pratik, the mic's all yours.
So my name is Advocate Pratik Harsh, and I was earlier a managing partner at a law firm. Now currently I'm working with Condé Nast. So being part of the law firm, one of the major things and the pointers I need to focus upon is diversity and inclusion. Because inclusion is one of the biggest problem which everybody faces when they go global. Getting used to the new culture, being part of the new diversified clientele is one of the biggest problem, and it's one of the very difficult factors one deals with while trying to expand his law firm or international legal practice. According to me, one of the easiest solution or the only solution which I think so is available is to upgrade yourself with constant learning, do more of networking, connect with as many persons and as many lawyers from different sectors, different fields, so as to understand the local jurisdictional practices, local norms, local values over there, which will in turn enhance your understanding of the area in which you are planning to expand. And also, I'd like to focus upon the pointers that nowadays with the coming up of the new technology, digitalization, and with, as my friend mentioned, that COVID in turn benefited the overall legal fraternity at a very high scale. So during the COVID time, I'd like to mention about a platform named Upwork. So it's very helpful for nowadays even law firms. So there's even an option to create a company profile over there. You can build your credibility over there on an internet, on an you call it digital platform or an internet platform, because credibility nowadays is not only about the word of mouth. It also about how's your online presence, how more you look in the market. Nowadays, you can call it everything is governed by reviews. Like people, even though if, somebody refers you, people try to search for you, look at your LinkedIn profiles, look at your website. So these are one of the most important pointers which you have to focus upon while you are planning to upgrade your international practices or global practices. Because being digitally active, technologically prominent, use of technologies like Web 3.0, integrating technologies like ODR in your firm practices, these are one of the most important factors which in turn makes your client happy and will also help you to grab more and more international clientele with a good credibility in the market. Thank you.
Thank you so much, Pratik. So comes down to me. Well, my practice has been fairly new. It's still 6, 7 years old, but it's still fairly new and dwarfs in comparison my co-panelists at this point of time. However, in a short period of time, what I realized, something very interesting was that there's not one thing that needs to limit you. I have my own practice. I'm a partner in a law firm, Palladium Legal. I'm also on a retainer with another top-tier law firm. And I also have my global presence through my networking accesses. What that essentially means is that you have multiple places to go to, multiple things to arrange to. At no one point of time are you stagnated or you have a monotonous thought process in something. And that really has helped me open myself up to various things, law was always, there was passion and desire was always there within, which I think is a very important thing if we have to process in any field. I mean, once you're passionate about something, you really want to go higher. And the most, when I started my practice, everybody, especially in India, it's a very common thing for people in the legal field to practice to say, wait for 7 years, eventually clientele will build up, wait for 5, 6 years, given the hard rights, eventually people will start noticing you. But hey, that's not the case anymore. The moment we've gone global, the moment venues have opened up, there are so many different things that we can do. Not just go, and we don't need to go anywhere. You can sit at home, sit on your bed, and do so many different things. Well, and what my co-panelists have also delved upon is the importance of networking, the importance of the power of creating a presence. Well, I'm not entirely sure how it goes in various countries. Some countries allow pure shot marketing for lawyers and law firms, but India does not. Now, how do we do that? How do we counter that? Now, there are certain platforms which help you empower your image and empower your knowledge onto various portals, which in turn garners presence. Secondly, is all about, having your online profiles very tip-top to the privy. And I have a very nice example for this. Some of you might have heard of this global recovery group called the GRG. Now, what they essentially do is they deal with recoveries for banks and financial institutions on a global stage. Spanish banks, German banks, European banks, American banks. The general counsel of GRG got in touch with me on LinkedIn, sent me a personal message on LinkedIn after seeing my profile, seeing how and what I do. Said there are certain matters in Bombay, in India, which needed to be handled, which were being handled by a previous firm. But however, for some unfortunate circumstances, that was not the case. We had our discussions. Discussions went on for a year, and I finally managed to crack the client. Now, what I meant to say is, I didn't approach anyone. But I made sure I am approachable, and I am findable. Two important things, people are able to find you, and not just when they find you, they're not just seeing your face. I mean, what is the face without what comes behind the face? The information, the knowledge, and the person who you are. And thirdly, they see what you're able to deliver and what you have delivered. Those are things which are very important, which I feel on this stage. Now, with that, I'd like to open it with my panelists on a few important questions. Now, Harsh, you spoke about outsourcing work. You spoke about LPOs. Now, when I speak about outsourcing, the thing that comes to my mind is LPOs. Now, what would you like to say about those? You said outsourcing is an important component, and I absolutely believe with you. But I'd like you to speak a little more about that, please.
It's important to have first understanding this way, because in further to continuation what my co-panelist said, then I'll quickly come on your question. It's a very thin line between freelancing and the practicing firm. So we have to be very clear in our mind whether I need to practice as a lawyer or I need to be a managing partner of a global giant firm. Based on that, your strategy will come into picture, be it Upwork, be it LinkedIn, be it technology, tax heavy for marketing and so on, and be it referral work. Coming over to now outsourcing and LPO. So accounting and legal, both industries are going hand on hand. So I'll like to quote accounting example, and then we'll cover how as a lawyers can have a LPO in their firm to scale up their practice. So we all might have heard about Big Fours, top 10 accounting firms in the world. They have their back office center in the Asia Pacific region, very specifically India, Bangladesh, Vietnam, Hong Kong, and so on. And the western part of the world, they outsource to certain kind of, be it accounting, bookkeeping, or data entry, and the financial and the tax, which can be remotely being done through that process. It's going on since ages. However, in case of a law firm, this was not common. Everywhere, every country where the law firm was practicing, they were skeptical about, privacy and, more important, attorney-client privilege, and they were reluctant to outsource to any other, rely on other countries' law firm or what, just for a bit of a commercial aspects or for some other. Now, in post-COVID, many of us might have read in news like Wall Street and the London and many other western part of the world. The layoff for lawyers were in big numbers. So where this firm will go? So eventually, the model of LPO started picking up. And LPO not per se for a freelancing and an individual capacity, but for as a firm as a whole. So outsourcing an LPO, it comes on a variety of angle. It can be in a form of preparing a deposition for a US court or maybe UK court and European court, International Court of Justice and so on, in a structured, very vigilant tech environment. Number one. Number two, corporate matters. The corporate modalities remains the same everywhere in the world. One country may have a requirement of 2 director or 2 shareholder, other country may requirement have 1 director or shareholder. But director will be called as director only, shareholder will be called as shareholder. So the modalities will change, will remain the same, just certain bit terms and conditions and laws may differ. So in per se, the agreements of all the such corporate nature remains the same across the world. And that has paved the way for LPO work for a US, UK, not just for the law firm, but also for the corporates like big giants like a Fortune 500 and S&P 500. I was surprised to know that Microsoft and Apple, when any kind of the commercial disputes happens, they need support of at least 500 to 1,000 lawyers, attorneys. So overnight, it's very difficult to have a law firm based out of US to support. And they take a support of firm based out of India or based out of other countries, where remotely the lawyers are working under the purview of their general counsel or maybe US counterpart. And that's one way of doing things. How we do it, we know the opportunity exists. There are reports claimed by world-renowned business consulting firm that the LPO industry by and large in coming 5 years is going to increase by manifold by at least 50 to 100%. How do we tap this opportunity? We know this opportunity now, how as a collectively we do it. So alone, it may be difficult, but when we come together as a network, as highlighted, we can work under the model of a network alliance subject to permissibility under respective jurisdictions where we operate. I'm sure the capability enhances, and with that capability, if the necessary skill set and the bandwidth is there, you will be in a better position to adopt this. So in my personal view, I honestly believe that in a coming time, along with the speciality, the major role factor will play is the how remotely you can efficiently provide the legal support services to the foreign. Those were the days where New York lawyer based out of Wall Street, they can only advise for a fundraising in, or maybe licensing, SEC and so on. Nowadays, be it any part of the world you are sitting, if you have the right courage, a passion and the knowledge drive, you can cater to any clients sitting across any part of the world. You don't need a degree for providing that. That may be a dilemma in any of you. Do I need to be New York attorney? Answer is yes, if you have to be present before the court. But nobody can stop you to provide work which does not require the license. So that dilemma needs to be clear. Come out of the zone and world will have a better opportunity for you.
Thank you so much. Now, Nevin, you mentioned something very interesting, that as we are talking about scaling, it's important to first sustain yourself. You know, it's important to first sustain your existing level and keep a nice base ready. what do you like to say more about like how it's important, like when you have your base ready, you can really put forward and you can grow because you know that you've achieved certain standards.
Yeah, it's the same point that I've raised in the opening statement, is to have your team empowered at any given point of time. They are able to function independently without you. It might be a bit of a challenge, personally speaking, if you think as like, okay, then why am I justified in that role? But then think beyond you. Again, let me make it very clear. The firm that I'm working with, it's not my firm. I'm an employee, I'm a partner, yes. But then from day one, it's a family-run business. I'll just give you the background so that you're able to correlate. And I'm a partner there. They've opened up, other than a family member, first to me because of the level of trust and the credibility that you put in. Now, with that, we have partners in each of the 18 offices managing their own business in that particular firm. Now, coming back to the question that you've asked, so from day one, what I do that, the team is capable enough, and many times I have this thing that you give it to the team, you just shadow them whether they are doing it properly or not, and take them through that stress. And then I empower them in such a way that it doesn't matter whether you make a mistake, but make sure that you are upfront and tell so that we can able to manage it. Avoid the mistake, obviously, in the first place, but if you do not try to cover it up. Because the more you cover it up, I mean, you're not going to fool anyone there because things are black and white there. If not for you, they will transfer the case to some other firm and they will get to know. So, and that's what it comes back to, the credibility. So make sure the team is in line with your vision. I tell 3 years, again, this is something personal to me. I do not compete with anyone. I do not compete with my competitors. IP is a very specialized field, especially in the Middle East. You wouldn't find a lot of IP specialized firms. I'm a patent attorney myself, so having a technical background and dealing with patent, even more specialized here. So what I bring to the table is something unique, and I tell my team members, make sure you compete with yourself rather than someone else. I know Hush have mentioned is like, bring it to a firm where you want to grow. Yes, that is definitely needed, but if you compete with yourself, you have 5 new clients this year, and we put a target, we need 5 more in next year. This is the revenue that you got this year. Let's bring it a 20% more so that each and every team member is aware of the target. What is the vision at the end of the year? What is the vision 3 years, 5 years down the line? So that as a group, we work towards it. And then once they are on board, that's when I spend my time scaling up. Because what is there, as you said, you need something to fall back on. Your existing client is your bread and butter. Then, if that is fine, then you start thinking about scaling up.
Thank you so much. Very insightful. So, Stephen, when you spoke about your growth story or how the story began, what was very interesting was the way you included people along the journey. So, how important is it to set aside your, the self-ego that we all have, that humankind has? How important is it to set aside the facet that we can't do everything on our own? We need people along the way. And how important is it to include people along the way across fields to make sure it's a collective growth, not just a singular growth that we are looking towards, but it's a group of growth that we are looking at.
Okay, yes, well, obviously it's extremely important. I think as you get older, and I'm probably a little bit older than most people in this room, you realise more and more that you need quality people around you at all levels, whether it's within your own law firm. You need to make sure that everybody's, as Nevin just said, on board with the same approach, the same attitude, the same theory. And in my view, you have to be fairly tough about that. Certainly during my working life, I know oftentimes I've been tough on people, but as I've got older and maybe a little bit wiser, part of it's been conscious to shock them, to bring them on board, and particularly I find amongst the actual lawyers, getting them on board with what you're trying to do, particularly when you're trying to deliver absolute first-class service and develop a true, unique selling proposition in your own firm, whether it be law or any firm for that matter. I mean, I always attend the first meeting when we have new clients, and often I'll sit with the lawyer after and say, why did you look out the window halfway through the meeting? What are you looking at? What's out the window that's so interesting? You know, I think the client might like you to talk to them. And so these sorts of things to me are very important. And to go back to your question, to include people at all levels, the same as when we were travelling, and everybody was included. You know, like if we go back and talk about, to divert a little bit, the expo bid. I mean, when we were involved in the expo bid, we won't say who the chairman of that is, we're not allowed to talk about her anymore, of course, or even mention her name, but she did do a great job with that, to be fair on her. There were so many people included, and losing, not winning that bid was just not an option. So we had people at all levels across the whole spectrum, and funny enough, the country I hosted was Belize, which you may know is a small country in between South and North America, south of Mexico, very near to the Panama Canal. One of our briefs we were given by His Highness the ruler was to find out what they wanted to win their vote. So I was talking to the president of Belize, who was here, a lady. So I asked her over lunch what she wanted to guarantee our bid, because we did have another major opponent in Turkey at the time, you may recall. So very quickly, I'll finish the story quickly, but she said a port. We were having lunch, I said, you mean like a glass of port or one that boats go into? She said, no, the second one, like a big one, because we actually don't have a big port. So it's a huge ask, but actually, maybe not so silly, because if you were prepared to give us a 99-year lease to your access to the Panama Canal, we might be interested in this. So there's just an example of course, that involved a whole range of people. There's one small country, but every country, be the United States, United Kingdom, Germany, had one vote. So the votes were absolutely equal. So my job was to get Belize's vote, and I did get it, of course. And they do now have a port, which DP ports, of course, manage. So that's, to go back to your point, that's a sign of inclusiveness of people at so many different levels, and then leading that into coming on board with a cooperation partner, you know, in various countries that shares the same views, shares the same passion. Hope that answers your question.
That absolutely does. I think that more than answers our question. So, Pratik, you mentioned about technology. You mentioned about, you know, the power of networking. What we gauge from that is it's important at this stage. Experience alone is not important. Relevance is important. Yeah. Now, in this time and age, how does one, say a junior budding advocate who's trying to get into the field, or say somebody who's gone to a mid-tier level, at any stage, how does one keep themselves relevant?
Okay, I'll answer your question. But before answering, I'd like to tell you a story. So yesterday I met Nevin, I was talking to him. And our firm was in a very urgent need of an IP lawyer who would help us in filing the trademark. So I am telling this story because I'm telling you an example of networking. So when I mentioned that you should always try to meet new people because that will help you to expand. Now I am planning to expand my practice in UAE. So regarding that, which I even talked with one of our friends, and when you meet with different people, your mind opens a very huge prospect of imagination, a new prospect of development, a new prospect of growth. So that is very important, and that only comes into play when you so one of my seniors used to always tell me that always try to sit in a room where you are the least literate one. So that is the, I think so, one of the most important scenarios which one must follow. And always hire someone who is always better than you, who is more knowledgeable than you, because a person who is actually better than you will bring more on the table and will always act as a you can call it will always act as a line that will increase your overall learning curve. So answering to your question, so I think so one of the most important things which one must follow is the timeline, making a proper routine for everything. For example, if I start with the LinkedIn posting, that's one of the most important tasks. So one cannot get a prominent good reach on LinkedIn until unless he's very diligent about the timings, diligent about the post, and diligent about his routine. So I think so my fellow friend can guide you more on that, and that is very important thing, because I'm sure he must have followed a particular timeline, a particular structure of posting, a particular routine of posting, learning more and more about hashtags. See, being a good lawyer is not only enough to gain that amount of success which you are planning to get. Along with lawyer, you need to be a very good salesman also, because that's a very important part. In order to be a good lawyer, you have to convince your clients that you are a good lawyer. That can only come into play when you are having that amount of knowledge, that amount of growth desire, and that amount of experience of the experience of selling yourself, experience of selling your law firm in front of the client. And I think so today also I was talking with one of my friends in the panelists, and I was telling that MBA is actually very important if you are working as a CEO for a law firm or a partner for a law firm, because law teaches you how to deal with legalities. It doesn't teaches you how to be a good businessman, how to be a good salesperson. Because as a lawyer, I always say, see, doing the good work is not just enough. You have to be a good salesperson also, because once people know that you are doing a good work, then only they will hire you. If you are keep doing the good work and nobody knows that you are doing a good work, how come you are going to get hired? And that's the whole purpose. And I think so I'd like to congratulate one of my fellow mates that he did a very good work in doing that, and he grabbed such a great clientele through LinkedIn. And personally, I am telling you, this has happened with me also, and this works. And this is all about routine. This is all about learning new things, doing more and more courses. So according to me, every day of the life is about learning new things, grabbing new courses, grabbing more towards increasing your overall learning curve. So also, I'd like to point out the pointers which Nevin mentioned, that there was a very famous saying that I can only save you from drowning if somebody is shouting. So until unless somebody knows, so as Nevin was mentioning that key, if you do mistakes, you have to highlight that. You cannot hide that. That is also one of the most important pointers. So in order to grow more, fail more. So that is the motto of the life which I personally follow, and I guess I hope so that it works for all of you also. Thank you.
Thank you so much, Pratik. You as much as summed the discussion so well that I literally have nothing more to say. But to actually sum it up, when it comes down to this main topic that we are dealing with, how do we scale on a global scale? There were some very important pointers which were raised. Firstly, don't lose out on an opportunity. If it goes away, don't fade in. There are more coming your way, but grab it as much as possible. Secondly, have associations, have kind associations around you, because you never know who will be helpful when. Thirdly, there are always problems. The way to go forward is first find the problem, then work on the problem, and you will eventually get to a solution. You can't just find a solution when there is no problem in that sphere. More so, it's important for one to keep learning. The more you keep learning, the more you realize that right now the world is progressing rapidly on a day-to-day. We've got Web3, we've got cryptocurrencies, we've got blockchain, we've got so many new mechanisms that weren't even, there was no name of the same in the last 5 years. I mean, 5 years ago. So it's so important to keep yourself evolved because you don't know. You may think you're great right now, but you may not be relevant to a couple of years down the line. So it's important to keep yourself networking. More so, work needs to be spreaded. You know, you need to keep your clients happy because I've had experiences myself, and I'm sure all of us have had. 4 years, 5 years down the line, an old client, 5 years down the line would give a reference for you, where you've not even been able to keep in contact with them. And how has that happened? Purely through your work and making sure that you've delivered as far, and it's not, a victory is not important, but delivery is important to that effect. And more so, you know, there are so many methods to network and market oneself without even getting into the sales or marketing ethos, because the law does not permit it. So it's important to keep evolving, making use of those things. Now with that, I thank all of you, and I'd like to open this round to questions. Anyone?
We have 3 minutes left, so we have time for one question. Anyone from the audience has a question for this panel? Who agrees that networking is extremely important in your line of work? Say aye.
Yes, I do understand we've delved into various topics, but yes, we do have a question. Thank you so much.
No, he was saying, he was saying aye. But I'm sure he has a question.
This is what yeah, I hope you didn't miss me that much. Sorry, you know, the question is about, you know, whether networking and how that would you connect that to technology, because we've been speaking about legal tech in the morning. If you would like to scale it up, how technology will really help you in scaling it up, and we have the right network across other law firms, across the borders, where you have this networking that can serve the clients in better way and better reach. And whether that network will really serve you, or whether you need to focus, you know, on your internal resources within the location that you are domiciled in.
Thank you. I think that's a very important question, because as we've all spoken about, one person can't do all the work. So there has to be a team which is focusing on driving in, you know, bringing in the relevance while one team is actually delivering. How this works is that, you know, networking is very important because there are so many platforms where they connect the potential customer to the potential lawyers or to the potential problem solvers. Let's not call ourselves lawyers or financial experts, but potential problem solvers. So it's important to be part of such platforms. LinkedIn is an excellent mechanism where one can really open up about themselves, their life, in the professional term. It's the professional Facebook as we all know it. And more so, it's important that, you know, people are aware about what we can deliver on a global scale through global collaborations. As you also spoke about associations, you know, there are groups. These collaborations, how do they help? Because immediately one person, they come to you of a problem which is not in your jargon, but you can now help them through those associations. Earlier you were just referring, but more important than to refer is also try to include those referrals, work with those referrals. Over time you may end up, you know, partnering with such people. You know, you won't realize where you've gone through in such cases. I hope that answers your question.
Thank you very much, gentlemen. We are out of time. Please put your hands together for this incredible
Thank you so much.
discussion. Thank you.
Thank you. Thank you, everyone.
Thank you very much, gentlemen. Next on the schedule, we have Mr. Prashant Shenoy, Chief of Technology at Unicourt, who will share his thoughts on the topic litigation analytics, the process, challenge, and the future. He will be presenting on how organizations can best use the power of analytics to transform their litigation processes. Mr. Prashant. So if we can please set the timer for 25 minutes for Mr. Prashant. Thank you.
Hello. Good afternoon, everyone. How's everyone doing today? Great. How many lawyers in the room before I get started? Please raise your hands. Wow, okay, great. And how many litigation lawyers? Okay, cool. So I'm Prashant, engineer at heart. I've been working with court data, US court data primarily, for over a decade now. I also work on related public data sets. Hopefully this presentation is interesting to you all, and I would love feedback at the end too. I co-founded Unicourt 8 years ago with Josh, who's now my CEO. And we primarily run the engineering out of India. We are about 140 engineers there and about 175 globally put together with all business operations. Unicourt is primarily a legal data as a service platform. And we provide real-time court access to lawyers and law firms. Our primary audience are AM 200 law firms in the US, and a lot of corporates and insurance companies who use legal data day in and day out. And the way they primarily access it is using APIs. So litigation analytics. So I'll start with what is litigation analytics? Okay. Being able to visualize litigation in the form of a knowledge graph and being able to query for information across cases through connected data points. This is how I would like to call litigation analytics. Okay. Now, I'm pretty sure everybody, all lawyers do research, or at least their associates do it for them. So litigation analytics is more of, you can think about it more of as a tool. Typically, you're used to doing text-based search on the data set that you internally have or the platforms that you use with. And in litigation analytics, typically the way you can think about it as another research tool, but the way you would go about doing your research is instead of just doing a text search for a party name or a lawyer name or a judge name or for a type of a matter, you can basically select entities from a list of entities, look at a macro view of things, and then probably drill down into what you're exactly looking for. Now, here, what are connected data points across cases? Lawyers, law firms, judges, parties, jurisdictions, courts, case types, outcomes, and motions, right? Typically, these are called as connected data points that connect across cases. Okay. Now, I'll try to first explain what litigation analytics can help you do. Now, here, what you see on the screen is Robert Scott, an attorney. What practice areas does he typically have his expertise in? And here you'll see its contract is sort of the predominant one. You can also see the number of cases that he's handled over the time period. You can see the judges that the attorney has faced. And this attorney primarily practices in California. So you see the different courts that the volume of cases that the attorney has handled. So spread across courts. The same litigation and trends you can also see from a party perspective. Now, Amazon Inc. Here, Amazon, you'll see that is involved primarily in intellectual property cases. The number of cases that's filed, you'll see an upward trend. The judges that have seen Amazon's cases, and the practice area, the jurisdictions where Amazon, he's being sued or is filing a lawsuit, right? This is at the federal court level in the US. So you'll see the spread all across with primarily in the East Coast. Okay. Another example of what litigation analytics can give, there are various things that can come, but I've just focused considering the audience from a lawyer's standpoint. What motions were filed by a lawyer? How long did it take to reach an outcome? Was the outcome a win or a loss? How does it compare with other lawyers? Now you can kind of drill down which are those specific cases that you want to see, which were the specific motions, the specific documents, and how many similar motions or documents resulted in similar outcomes. These are the kind of things that you can get to with litigation analytics. Now, let me talk a little bit about the process here. Okay. This is how you typically go about generating litigation analytics. So for any analytics to be generated, you need data. And the data comes from the source, and in this case, the source are the courts. Now in the US, unlike in the morning panel how Dr. Karim was talking about a single app that kind of gets you all the information, in the US it's every court has its own website. There are over 3,000 counties in the US, and each county has its court system. Most of them have their individual court websites. So data aggregation itself is a challenge. And we spend a lot of time doing data aggregation. Now, once the data is aggregated, it needs to be standardized. And once it's standardized, there's a process called as entity normalization that takes place, which I'll talk about a little more in detail. And these entities are law firms, judges, any of those connected data points across cases. Okay. Now, once the data is normalized, it can be stored in an analytical database. APIs make this data accessible, and then you can render it into dashboards and applications. Now, data aggregation. So if I can point the laser, okay. So this is a court case page from Los Angeles Superior Court, which happens to be one of the largest courts in the world in terms of the volume of cases that it handles. Okay. This is a typical case. This is public access. You'll see here, this is the case number, the name of the case, the filing court, filing date, case type, the status of the case. The information about the parties involved in the case. You'll see here on the left-hand side are all the parties and attorneys listed. You'll see the role of the party, defendant, plaintiff, and if you see somewhere here, you'll find an attorney, D. Luca Philip P., who's an attorney for plaintiff, but it does not mention for which plaintiff. Okay. Register of actions, what proceedings have happened, the dates, and the legal nomenclature for what's happened. Even though it's English, I mean, from a technical standpoint, there's a legal jargons and legal grammar to it. What documents were filed, on what dates. Now, this is the source. Okay? And from technical terms, we call this unstructured data. This is from one court, and if you went on from court to court to court, it just gets different. Every court is different. That's one level of data. Then you have all these documents that are filed in court, right? Complaints, the one you see on the left-hand side. This is what a typical complaint would look like. This is what a judgment would look like, right? So, to build any product, the most important step for us is once you have this data accessed, to standardize it. And standardization is a process on its own because ultimately, it needs, no matter what the source is, it needs to be structured very well internally, right? I'm not sure how clearly you can see this, but this is typically a case object which is structured across courts would look like. You would have, from what you saw earlier, we would try to standardize this information as specific attributes, court location, case type, charges if it's criminal, when was the case filed, who the parties are, and the party would have its own object, which is very, it's quite structured on its own. So it would have the name split out if it's an individual, the party classification, whether it's an individual, whether it's a business, and then which attorneys represent that party, right? So once the data is standardized, it can be now visualized pretty easily. So this is how a dashboard for visualizing a case, no matter what source it comes from, can be done. So if you see here, this is very well structured. So from the typical research that you do, there's a lot of process that probably internally goes to just making it standardized. Okay. This is a case metadata information, the parties, attorneys, and which party is that attorney representing. The register of actions now comes in a very visualized form. So the first step is aggregation, the second step is standardization. Now comes the entity normalization. So let me talk a little bit more about this. So entity normalization is a process of identifying specific entities and clustering together different variations of the names or text to represent a real-world entity. Okay? And I'll try to explain this with an example. But the entities we identify which are common across cases are your lawyers, the same set that we saw earlier. Okay? Let me try to explain this with an example. Okay? Now, what you see here is Philip Paul De Luca. Now, this is he's an attorney. This is a normalized entity with a specific identifier. Now, you'll see here, these are the different variations where this attorney has come in a lot of cases. Okay. Now, I had to limit the number of entries here because I didn't want the list to go beyond the presentation slide, but it can be a lot more. Okay. So let's try to see some of the problems that we try to solve for here. Misspellings. So if you see here, there's double L. If you see here, it's actually De Luca, and there's no space here. And you'll see more and more problems as you see go down. Right? Inclusions of middle names. So the middle name is Paul, but if you see in various places, the middle names comes up there. Title, Esquire. Firm. So the firm name also comes up in the name. So this is how you see, we end up seeing this information from the source, right? And the process by which we try to say that this is an actual individual in the real world entity and this is that person is the process of doing entity normalization. And so entity normalization is sort of the base for us to generate any analytics, for us to be able to provide tools so that research can be done in a whole different way than just a text-based research. Because now you can actually look up for this particular attorney with an identifier from a list of attorneys and try to find all the cases that that attorney has been involved in. So let me come to the challenges. Now, for us to generate analytics, we need data. And this data is hard to access, extremely hard. It depends from source to source. Sometimes it involves grabbing it by crawling this information. Sometimes it requires working with the courts. Sometimes it comes in data dumps. You'll see that even if you're looking at a case, some of that data will be in the HTML, in the browser that you see. Some of it will be in the PDF. So extracting all this information is extremely hard. The second, data voids. So even if we get the data, most of the time, the data is incomplete. So the amount of effort that we put in to collect the most complete data set is also a huge challenge. So this is the problem, this is one of the problems in data collection that we face. Now, challenges in normalization. Name inconsistencies. So you saw some misspellings previously. You'll see abbreviations come up. name changes, attorneys can go through name changes, law firms can go through name changes, and all this has to be accounted for in the normalization process. Confusing and transposing names. Now, if you see this here, Steptoe and Johnson Professional Liability, Limited Liability Corporation versus Steptoe and Johnson Limited Liability Partnership. These are two different entities. So if we try to use some algorithms to catch for misspellings, this can be accounted for as the same entity, but then we have to distinguish them as they are two separate entities. Michael and Associates, Michelle and Associates. Two separate entities, just one letter difference. Some other challenges. Entity inconsistencies. Now, if you see this law firm here, Eisner, this is how the firm is right now. But when it started in 2002, it was Michael Eisner. Okay. And in 2009, Frank joined the firm, and Kahan joined the firm. But Frank ended up leaving in 2011, and Gauri joined the firm. In 2013, Kahan left. Chapman, Ross, and Jeffy joined. So you see the amount of changes that happen. The firm goes through a lot of changes, right? How do we represent this? I mean, detecting this is one thing, but how do we represent this? If you're looking up for Eisner today, should all these change variations account for all the cases that have to be related? So law firms can merge. One law firm can split into three, while one firm retains the old name. Entities frequently split, merge, acquire other entities. Name changes due to partners' involvement. Their names may change in the process and may be related to previous entities. Different users may subconsciously make different assumptions when they use analytics. One other issue, when it comes to parties. Wells Fargo, huge conglomerate, right, has different entities involved. How do we represent this? Because when they are registered as separate entities, somebody might want to see it this way versus somebody who might want to see it from a Wells Fargo, the holistic way. Right? And trying to identify that they are actually a parent holding. So that brings us to sort of all the challenges, but what does the future of litigation analytics hold? So LLMs, large language models, are a huge game changer. GPT-3 is out there now. The way you can do machine learning has changed significantly over the last couple of years. Computing is getting extremely cheap. It's going down and down, right? The prices are going down. So training models is easier. Performing inference is easier. Data storage costs are going down. But there's a catch. Analytics is only as good as the underlying data. Normalization is not fail-proof. Data voids need to be considered. And over 70% of the time is spent on data cleansing and data preparation for ML. So in conclusion, easy accessibility to core data can ignite a lot of innovation in the legal tech. This can lead to an ecosystem of tools for lawyers, and it can bring in significant improvement in the justice system. With that, I would like to conclude my talk. Thank you.
Thank you very much. Any questions for our speaker today? I guess that's
Yes.
it. Yes, there is? Okay.
Thank you very much, Prashant. Very interesting. The question is, because the problem is coming from data as, basic point. So what do you think about, how technology actually will help in eliminating or reducing the problem when it comes to data, especially, let's say, in pre-filtering exercise, including using blockchain or AI, that will be the first process actually to identify the data. I came across actually personally towards certain contractual systems that will identify, certain issues in contracts that will tell you using AI that there is the problem in those clauses, avoid them. Those clauses need to be incorporated based your policy or your standards. And I'm actually trying to implement that part in contract cycle. So for litigation and data gathering and collection, maybe it's not the same as easy as contracts because that will be at the start, it's not at the end. So if that's a solution that could identify those issues, with the pre-filtering system that will, we evaluate, and if you link this to if there is a centralized, let's say, database in the country, for example, in KSA we have a national address. So if somebody changes his address, he needs to amend that within the system. Other than that, the national address will be recognized within data collection and for any case filing recognition. So just an example to be considered. So what do you think about that, Prashant?
So if I understand your question correctly, how can you use AI or other systems in the pre-filtering process to identify problems that could probably exist? Yeah.
So what I'm doing as of now, that when there is a contract, okay, and there is, key words, it comes liability cap, okay? So the contract will tell you that this contract is exposing you to liability. So you need to monitor that. This contract is not addressing your standard templates, and he'll just, using the OCR, he'll bring your standard template or standard clause and bring it to the contract. You use this, don't use that.
Yep.
So just an idea if that comes.
Yeah, I mean, using the applicability of technology in this different, on the contract side of things is a whole different topic on its own versus this one. In here, we could definitely use some systems to identify what the voids are or where the problems are in the data. One of the things that we try to do is we know that we can never get a complete data set. And we know that normalization is not fail-proof, so we try to convey that in our solution to our customers. So let the customers make that decision of trying to understand how internally our systems work and try to adopt for it. For example, if we say this is one entity, and but we are not sure whether these two entities are the same one, we try to give some confidence scores in there for them to understand that. On the contract side also, I know there are several companies that use AI in sort of going through the contract and understanding where the problems are, or the typical template should be like this versus they are missing certain clauses there. So there are definitely places where AI can be used even in pre-processing to figure out problems, but that is not the solution, but to just recognize what problems do exist.
Then what do you think about then the automation actually of the platform? And one of the examples is to make sure that you have the e-platform that will contain all the stuff of the people, including their personal identifications, title deeds, addresses, so names. So all of that, when you have this connectivity related to this platform, so you can just generate from the actual resource and don't rely on other resources.
Oh, that would be perfect. I mean, that would be the ideal world to live in. I think one of the last points that I had put up on my slide was we spend 70% of our time in data cleansing. So if the data was accurate and readily available in one platform for us to use, I mean, the amount of innovation that could end up happening for building the necessary tools to make the legal system better or build better products would be huge. The cost of the product would also go down. Just imagine about that. Exactly. I mean, engineers are not cheap. ML engineers especially are expensive. So if we can reduce if the data consistency, standardization exists for us to build what products we can build, I mean, it would be a much better world to live in.
Yeah, exactly. Thank you very much.
Thank
and
you.
by the way,
very much,
lawyers are
Prashant.
more expensive. Thank you.
Thank you, Prashant. That was excellent. Thank you for all the insight.
Thank you,
Please
everyone.
put your hands together for Prashant. Thank you. All right, ladies and gentlemen, we will now head downstairs where the photographer awaits to take our photos as a group and have lunch. So we shall reconvene here at 1:15. Thank you very much. I'll see you soon. Testing. Testing. Is the camera ready to go, sir? Yes? Camera? All right, everyone, welcome back. I hope you enjoyed lunch. It was delicious indeed. Let us move on to our next fireside chat session. The LIBOR extension is a welcome reprieve to many corporations, but as LIBOR rates fluctuate, will corporations still have a stable benchmark to rely on? In this fireside chat, even with the extension, corporates struggle with LIBOR transition. For this chat, please welcome on stage our speakers, Ms. Edith Normand, Managing Partner and Attorney at Law for ACG International. Welcome, Edith. And Mr. Ashish Jain, from Lunia, founder of Lunia Savindan Attorneys at Law. Welcome to both of you. And so you'll have 25 minutes, and you can leave the last 5 minutes for questions from the audience. Just put it upwards.
Yeah, yeah.
Okay.
It's already upwards. No problem.
Good afternoon. We are here to chat about LIBOR. So I see the first row with a lot of bankers wanting to know what happened in LIBOR and how LIBOR today is scrapped off. So a short history of what LIBOR actually is. It's the London interbank offered rate. So this is the rate based on which banks in London offer for credit, loans and advances. This has been a successful model which has been going on or being used for a large number of years until a few years back, where the statutory authorities in London discovered that there is some hanky-panky going on with respect to how those rates are fixed. Principally, these rates were fixed based on inputs from large bankers who used to advise that this is the lending rate. Unfortunately, a few banks decided to form a cartel, and they fudged these rates in order to help them make more money by pushing the lending rate up. Therefore, it ended up affecting a borrower, where his mortgages went up, the rates at which he was able to avail loans and advances went up, and this in turn was a demoralizing situation entirely. Number one, because a cartel was behind this. Number two, it didn't help anyone except these banks who were involved in all of this fudging. Come 2019-20, the British government decided to scrap LIBOR, and they brought in place the secured overnight financing rates. So this is going to take over LIBOR. The difference between LIBOR and SOFR is that SOFR will be decided on a real-time basis based on what the lending rate is currently being offered by banks, and not a future outcome of the rates that was followed in LIBOR. With this background, I'd like to highlight how certain banks mistook the freedom that was given to them to fix rates or recommend rates and fudge the market. This overall activity which was carried on by these banks narrows very closely to nothing short of money laundering. When banks are involved in fudging these rates, this resulted in a catastrophic loss to the government, the exchequer, and caused a number of lawsuits to be filed. Eventually, the courts decided that a $9 billion fine would be imposed on these banks, and they coughed up the fine, they paid the fine, and now the public at large is going to be benefited by the new legislature, that is the secured overnight financing rates. So what I'd like to chat with Edith about is how such practices, this is, LIBOR is just an example of how certain banks misused the leverages that they had. So I'd like to chat with Edith how LIBOR and related transactions border closely on money laundering, or what do you think should be the steps that we need to take today to prevent money laundering? So could you please highlight us on any of anti-money laundering laws? What are the systems in place today, and how are we protected from such activities?
Well, thank you very much, Ashish. Money laundering, I mean, anti-money laundering is really something that I care about. So nowadays there are, as you said very rightly, not only in LIBOR, that's of course the transitioning period that we're in now, where especially the institutions themselves are busy in rewriting and changing the contracts, which is a lot of work and a lot of manpower being used to get away from everything where LIBOR is still included. With respect to anti-money laundering, that is a huge problem nowadays that we face, and we have worldwide accepted that this is one of the focal points to fight money laundering and counter-terrorist and terrorist financing. And worldwide there are AML regulations in place. And of course, in every country and in every zone, the regulators are and the legislatures are trying to make it even harder for institutions. And one of the things that, because we're talking about LIBOR, banks, and all these kind of institutions, one of the main topics there is the gatekeeper. And financial institutions like banks are gatekeepers with respect to anti-money laundering, and they are having a hard job because it's of course not the banks that actively launder money, but they're being used to launder money by people who do it deliberately. But as the gatekeepers, they are the ones that pay the price. But not only the banks are paying the price, also the customers are. Because the rules on financial institutions with respect to anti-money laundering, to the gatekeepers, are so hard and the fines are so high that they are very strict with their rules on who they admit as their customers. Their regulatory costs to that, I mean, in the Netherlands, for example, one of the biggest banks, ABN AMRO, a system bank in the Netherlands, 1/3 of their employees is just busy with checking on AML and other related checking of clients, KYC, client due diligence, and so forth. So one of the sectors that is really hit by that are SMEs. I would be very interested in hearing from the room who is facing the same problems, because what we see is that because the banks are facing these high fines, they are actually banning some high-risk customers who are high risk because they are in the business to the B2C and therefore accepting cash, which means that they actually exclude that group of people, whereas they're not allowed to. Which also means that SMEs have to turn to other sources of finance, which makes it more expensive for them and shadier on the other side as well. So I would be interested in hearing in the room, are there any people working for banks here? Yes, sir. Could somebody get a microphone to you? I would like to ask you, because it has been very hard on the banks to work on compliance, to have a lot of costs, and therefore, with respect to compliance, it's difficult for SMEs to get admitted to banks, and how you handle that with respect to the high compliance costs as gatekeeper. Thank you very much.
Is it on? Yeah. Michael Slater from Northern Trust. So I would say, is it more difficult for SMEs? I don't think so, truthfully, as I look at it. I think if we look at the risk-based approach that Northern Trust takes at it, it's very methodical in how we look at it, whether that's by country, by sector, and by the boards and individuals. It's kind of a very systematic approach. So whether you're an SME, a single individual, or a corporate institution, we're following those same checklists.
Okay, thank you. Thank you very much. There has been an interesting case in the Netherlands lately. I don't know whether it was followed from abroad. With respect to onboarding of customers, the KYC process of an online bank. The bank was called, is still called Bank, B-U-N-Q. And what happened, the case was as follows. Our regulator, the Dutch National Bank, stated that because Bank is an online bank, and with their private customers, they said, you know what, we are creating a model of the average private customer, the retail customer. And in general, these retail customers are all the same, and they are behaving the same, so we just make one model. When somebody's onboarding, we don't do KYC individually, we onboard them with their details that they are sending us. And only once they deviate from normal behavior that is expected from them and that we know from the normal customer, we will do our KYC process on that specific person. Their way of looking at it was, well, if you want to see if somebody is speeding on the highway, you don't have to stop every single car. You can let them all go and just stop the one who is speeding. That was their principle. So the Dutch National Bank said, no, our regulation in AML is you have to know who you are onboarding. You have to check every single one of them before you let them in. And they went all the way up to the Supreme Court in the Netherlands. And the Supreme Court in the Netherlands ruled that it was not a breach of the law to have such a system for retail clients. I must say that this is not a green light for everybody to do that, because what happened is that the Dutch National Bank, in my humble opinion, didn't do a very well job in preparing that, because they thought it's a no-brainer. If it had been my job to do it for them, I would have asked them to test the system, because if you can see that the system is not working, the AI that they use on the private clients, they use a system, one size fits all, then they have AI in place on their online banking, and this AI flags every client that speeds, to say it, to use the same example, and then they check that client. So our highest court has ruled that in principle, this is possible for private clients. So there will be an interesting follow-up on that, because that has been a recent judgment. And this is not the way out of having your KYC and client due diligence, but it is interesting to see that one of the highest courts in Europe has decided that the traditional way of onboarding and doing KYC is not necessarily the only way. It would save a lot of manpower, but it should be done properly. I see you are very critical about that, and I agree.
Well, before I take that, I think what our principal concern is today, there are a number of contracts that have LIBOR embedded in them. So what we are struggling with today, or what business houses and corporates are struggling with today, is trying to understand how this transition is to take place. Because the basis on which these rates were fixed, the LIBOR, is being scrapped off. And a new method, a new mechanism is being put in place. It was required in order to cut down this cartelism carried out by banks in order to benefit themselves. This has resulted in a lot of corporates facing issues of negotiating, renegotiating, restructuring various contracts that they had with LIBOR as a base. So the way forward is a little tricky, but this had to be done. We can take the question now.
Sorry, I'm still going to go on with the email. Yes, please.
Yeah, sorry, I want to come back a bit on what you were saying.
Yes.
You mentioned the Dutch banks. So most recently, I did a transaction, cross-border transaction, to acquire an SME in the Netherlands. I'm based in Switzerland myself. My holding is in Switzerland. And it was a nightmare, the biggest nightmare in the world, to be able to do all the KYC with the Dutch banks, because we have international shareholders, essentially single family offices. And it's an asset class which is not very standard in the Netherlands. So the big banks, for the acquisition financing, have taken ages, literally many months, until they were able to provide feedback. Unfortunately, so we had to move with the Swiss bank to be able to do that, because they lacked, in my opinion, a lot on the level of agility. In Switzerland, they also require the KYC. They want to know your customer, etc. But they would do it in a more pragmatic way. After the transaction was closed, so I got the acquisition financing via Switzerland. But after acquisition was closed, it took us more than 3 months to have the KYC completed by the bank for our business, so that we can have, the authority to change the documentation on the e-banking. So it was good that we took some interim provisions to be able to continue the payment. Otherwise, we would have not been able to do that, because it took them a couple of months. So, I mean, maybe I was hearing a bit what you were saying, so I'm pretty new in the Netherlands system, banking system, but my experience so far has been quite challenging from that standpoint, despite the fact that most of the shareholders are pretty solid shareholders from different jurisdictions. So I wanted to bring up this comment.
Thank you very much. This is a very good example of how it should not be done. I mean, you did the right job to going to Switzerland. I'm from Switzerland originally, so I'm fully with you. But the thing is that indeed there is a discrepancy between for example, well, I know the examples of the Netherlands quite well because that's where I'm situated. They want to attract foreign investment, and not only foreign investment, they want to propagate themselves as the gateway to Europe because it is a very international country with a lot of outlook to international, very, has been in commerce all the time. And the problem that is there is really opening a bank account because of KYC, because of these processes that take too long. And what I really admire Bank for having gone all the way to the Supreme Court, because one of the problems is that there are more regulatory restrictions on banks and other financial institutions, where the Dutch National Bank just tells them, no, we think it's that way, and we are imposing a penalty or anything else of the whole toolkit that they have. And one of the problems is that the institutions that fall under the regulatory, under the Dutch National Bank, is that they do not dare to step up against their regulator because they have to deal with them every day. And the Dutch National Bank is quite close, opposite to the AFM, who is regulating the rest of the sectors. So a bank was really very brave in going all the way, and everybody was very interested in seeing the outlook. And the Dutch National Bank has said, and that is really something that has come out of this, we are looking at it. We have to do something about it because it's out in the world and in the open now, that apparently the way we were not only preaching and teaching it, but also punishing it, is not the only way and is not necessarily the right way. So there has been a consequence insofar as that the Dutch National Bank has said, we are looking into that and we might be changing our outlook. Well, we still have to see how this is going, but there is some change in applying, because this morning we were also talking about what about legal tech, what about AI and all these kind of things. Apparently this bank, because it's an online bank, they dared to use AI and a overall profile for their KYC process, and they went all the way up to the Supreme Court to test it. And therefore it is worthwhile to have brave companies and individuals and lawyers who dare to, go through the process and see whether it really works. Because as mentioned earlier today also, we need to bring that change to use these tools in a way in which it is not only done as the way it has been done before. Yes, any other questions or remarks from your side?
Yes, I think just to add to what Edith has to say about AML, India is also facing a similar situation where we have a lot of money that has been laundered abroad, and there were promises made which were more electoral of bringing this back. I think we are yet to see the end of the tunnel there. AML is a very large issue that is affecting not only jurisdiction within countries, but also across the globe. There has to be a very uniform legislation where all the countries agree with respect to funds moving out of the country, funds being brought into the country, and it could be one of the steps where we are able to control or at least put a cap, keep a check on AML. This being said, I think the consensus for the entire globe or all the countries to come together is largely difficult, and countries within certain regions need to work in order to avoid any form of AML. Unfortunately, we've had large corporate houses, history has had large corporate houses, large banks get themselves entangled with activities of AML, and there are a number of legislatures in place which attempt to control this. I think, Edith, if you could highlight a few of these legislatures which are in place to control AML, and how successful have they been?
Well, we have, of course, the FACT, the FACTA that are having our overall rules worldwide, and from there, the national regulations are being taken in place in every single country. And it works quite well, in a way, but it imposes a lot of penalties. And I really hope that by using new ways of the onboarding process, we can save a lot of money in using it and workforce, because we are all short of people, and 1/3 of your workforce having to be used for these processes is just too much, and we can use these people for something better, and try to use AI where we can, and use the people where we can really need their human touch and intelligence.
So to conclude, I think what could be a possible solution is to start at the very roots of how banks operate. The first step is the KYC, and if we are able to automate the entire KYC process using artificial intelligence, using machine learning, I think it would be very, very beneficial to keep in check people involved in these banking systems and how these transactions take place. Now, Edith, would you like to take some questions?
No, actually, we have 1 minute left. So
I'll take that minute. I'll take that minute. So, so the thing is that I do have to make this remark that the case that was on it is for private individuals. For businesses, so far, this is just too complicated. But it is certainly a sign in maybe a change in that direction, and new opportunities opening up. And with having said that, I'll give you 30 seconds for the next panelists to have.
Thank you very kind of you, Miss Edith. Thank you very much to the both of you. Please put your hands together for this fireside chat on corporate struggles of labor transitions. All right, next we have a panel discussion. So we will have 3 chairs added to this, as well as some microphones, please, Mr. Sai. Okay. It's no secret that resolving conflicts within the cultural and creative industries can be tricky, especially when there is a misinterpretation of what was initially agreed upon by both parties. So let us invite our panelists on stage, as well as our moderator. The panel discussion will be on dispute resolution in cultural and creative industries, how to improve this process. I would like to call upon Dr. Fawaz Alami, Chairman, Global Trade Consulting Office. Welcome, sir. Next, we have Mike Hindi, Chairman for Green Logistics Groningen. Welcome, Mike. You are the moderator, so the first chair. Yes, please. Next, we have Mr. Roar Thun-Weger, CEO and founder and facilitator for Weger Negotiation Institute. Welcome, Mr. Roar. Microphones. David Lagziel, CEO of Conflict Team. Welcome, David. And last but not least, Prashanta Kumar, Senior Partner for Fox Mandel and Associates. Welcome, gentlemen. Yes, you can bring them. All right, so now we shall set the timer to 40 minutes, please. And the last moderator, the last 10 minutes on the...
Thank you. Thank you very much for the conference organizers. This is going to be a dispute resolution in cultural and creative industries panel discussion. The panel discussion is part of the conference main theme, which is redefining the future of finance and law. Please welcome the panelists, and the first experts on this will be Mr. Rohr Weiger. He is the founder and CEO of Weiger Negotiation Institute in Oslo, Norway. He works as a facilitator, advisor, and mediator, and conducts facilities. He was the first SIMI accredited civil commercial mediator in Norway before he decided to establish WNY. He worked as an employment and labor law. He is the chairman of Sport for Understanding, an NGO he co-founded in 2020. Rohr will talk today about how the clients can improve the process by considering what kind of lawyer they want to be represented by. When they consider assistance to settle in business dispute, would the client choose one who was completely partisan toward their point of view, or one who acted as a mediator and saw both sides of the conflict? Please welcome Rohr.
Thank you, Mr. Favas. And it's delighted to be on this panel together with all of you. And yes, I wanted to talk about this topic, to find the best possible solutions for the clients that's hiring the lawyers. And what I wanted to focus on was the value of hiring a lawyer with mediation training and experience. And the reason is that I want to focus on how the clients can improve the process. The client can improve the process by considering what kind of lawyer they want to be represented by. And as Mr. Favas just said, when clients consider a lawyer, would it be assisted by a lawyer that is completely partisan towards their point of view, or a lawyer who acts more as a mediator and could be able to see both sides of that conflict this client brings to the table? So I focus on this because I think with a better focus on this from the lawyer side, they could be a way of improving the process on behalf of the client, as one way, as my co-panelists also would consider other elements. But I want to make a short analogy to the basketball star Kareem Abdul-Jabbar. He was a great basketball player, and he was well known for his sky hook skill when he jumped to the basket. But the important part, in addition to this, he used to practice yoga. And he practiced yoga to be extended his flexibility when he perfected his skyhook. And this is why I wanted to make this an analogy, because lawyers who develop mediation skills, they strengthen their traditional legal skills. So by doing that, they are able to bring a broader perspective into the table in one of the most challenging negotiations that we often do with our own clients. Because they come with the best case, most obvious case. And this is the dangerous, because we could easily be very biased, unconscious bias towards that client. So we could provide more objective advice, more accurate forecast of the outcome, and promote a more collaborative negotiation to create value into this. This is backed by research that we could see different places. So this was briefly what I wanted to start with, Mr. Fawaz, and I would like to give the floor to others, and maybe I can be able to come back later.
Thank you very much, Sharor. And I want to actually mention to the distinguished panelists that we have 8 minutes per person. And as Mr. Rohr was kindly applying this rule, I would appreciate if they all apply the same, so that we can leave a little bit of time, about 5 to 10 minutes for Q&A. The second panelist I would like to honor, and I would like to have the honor to introduce to you. His name is Mike Hindi. He's sitting next to me. He is an experienced leader in business transformation, post-merger, restructuring, and integration. He has been essentially focusing on healthcare, supply chain, startups, and financial services. Most recently, he stepped into private markets and partnered with groups of investors, mainly single-family offices, and has completed a cross-border transaction to acquire Green Logistics, Groningen, and end-to-end global logistics services. He holds an executive MBA from Oxford University with distinction, a Master in Management of Technology from ETH Zurich, and from the Swiss Federal Institute of Technology, and a Bachelor in Mechanical Engineering from École Polytechnique Fédérale de Lausanne. He has also completed exchange semesters at Stanford University. Overall, he is globally minded leader, speaking 6 languages, among them Arabic, because he is from Lebanon and France as well. And Mike will be talking about cross-border M&A transactions and the impact of culture and managing global stakeholders and negotiations. Please welcome Mike.
Thank you very much for the introduction, Fawaz. Hi, everyone. So basically, as Fawaz just mentioned, I come from the corporate world and decided to pivot into private markets. So 6 months ago, exactly, I completed a transaction to acquire a company, Green Logistics Groningen, based in the Netherlands, which is an end-to-end logistics service provider. I'm based myself in Switzerland, so basically it was a true cross-border transaction that has happened. And there is a lot, to share around the culture elements, the best practices also in terms of bringing on the right stakeholders, the right support, the right lawyers around the table to make sure to have a smooth type of process, but in the same time be able to manage any potential conflicts that can come with time. That's from one hand. But then there is also a second angle which I want to bring to the table. Having myself been for many years before this new entrepreneurial journey in the corporate side, in the pharma industry, negotiating multi-million contracts globally. So, the element of stakeholder management of people and making sure that there is the right governance in place is an element which is critical for me to make sure that the level of partnership is properly being applied. And I truly believe in long-term sustainable partnership. And in order to do that, I believe that it's essential not to have only the right people on board who are able to, cross the bridges culturally, but also on the content side, as well as bring to the table people who have, values of trust, of integrity, and who think not in the zero-sum game, but rather how to explore partnerships to increase the share of the pie. Because I strongly believe that everybody can be, winning something if they apply a true collaboration. And so that's one of the reasons why, when I was asked if I want to join this panel, I felt that it's something that is quite close to my heart, not from a legal side, but more from a financial and from the other side of the table perspective. Thank you.
Thank you very much. And now I would like, with great honor, to introduce Kumar Prashantha, who with over 20 years of legal expertise, he has steered the firm's real estate and infrastructure practices in Bangalore, Mumbai, and Pune to new heights. His results-oriented approach and pragmatic solutions have struck a chord with every client, enabling him to be consistently recognized as a notable practitioner by leading publications including Chambers, Legal 500, and Asia Law. He is proficient in setting up SEZ and EOUs and statutory compliance pertaining to STAR classification for hotel and hospitality establishments. Further, his experience in litigation relating to real estate, civil, criminal matters arising in connection with partition, property, acquisition, succession, debt recovery, disposition, etc., has given him an upper offline platforms. Mr. Kumar will be talking about dispute resolutions in the era of millennials and Generation Z. Please welcome Mr. Kumar.
Thank you, Fawaz-ji. Good afternoon, Dubai. I know, it's a post-lunch session, and it's not easy, and the topic which I'm going to speak is the dispute resolution mechanism with respect to Gen Z as well as millennials. Before that, I want to understand, and I want to tell you guys, the nexus between culture and dispute resolutions. See, I'm an anthropologist. Let me also speak something about the evolution. The disputes are born out of differences. The disputes are born with human beings. So we cannot avoid disputes. Only we can manage disputes. The question comes, when we start evolving, we were a simple society and our problems were simple. Today, where are we? So we have traveled from simplicity to ultra complexity, and today our problems also have become from simplicity to ultra complex problems today. And the mechanism to resolve it has also become complex and ultra complex.
Today we are all stuck wherever you go. Litigation, dispute resolution mechanism. How does it work? One is high cost. Second one is time. We have created so many things. Conventional judicial system, where you go to court, start filing the suits, and look for the resolution. When everybody started feeling that that may not work or that is not yielding the expected results, then we started thinking beyond. What's that? ADRs. Alternative dispute resolution. Okay, let us see, can we try with arbitration? Can we try with mediation? Can we try with conciliation? Is it enough? Are we really feeling that, yes, these mechanisms are enough to resolve all our disputes, or not? If not, what next? What next? See, that's what. See, what happens is, and actually culture plays a very crucial role, especially in dealing with disputes. As I told you, evolution, it started with Homo sapiens, and it started evolving with our culture. The culture has an element of dispute resolution mechanism. Only thing is, what we need to do is, we need to bridge between the culture and the dispute resolution mechanism. That is where, because we cannot apply one solution to all our problems. There is no one road to justice. All road needs to justice. So we need to see that which are all the mechanisms that we can apply for getting out the resolution. Today what's happening is, bigger problem, the solution also needs to be bigger. This is the most expected thing. We need to understand a simple resolution can resolve the bigger problems. So that is where we have to go back to our culture and see where are these mechanisms, how we can adopt. You have to rationalize these mechanisms and see that whether we can find the resolutions in this mechanism. Today, see, the fault lies in our evolution. Whatever we have achieved today is by trial and error. And today we are sitting with a couple of patterns, which we are calling as, by this pattern I am able to resolve it. But the lot of innovation is required with respect to dispute resolution mechanisms are concerned. We need to understand, when it comes to the new Z people and the millennials, will these guys be able to, withstand the current system, or what is their expectation? Because when we speak of futuristic litigation, we also need to think of futuristic mechanism. The current and the prevalent methods may not work in future. The millennials and the Generation Z people will not appreciate. They don't have a time. Because if you see, everybody might have undergoing, whenever the matter comes to you, it's always comes to you with a tag as an yesterday. And just imagine what your next generation is going to face. Time is everything. They will not have time. We need to be innovative, and we need to think beyond the existing methods and the mechanism to address the needs of the futuristic millennials and Generation Z's dispute resolution mechanism is concerned. Along with my other panelists, I would like to, as we go on discuss, definitely we'll try to explore as much as possible.
Thank you, Mr. Kumar. Now, the last panelist, but not the least, Mr. David Laxiel. He is the CEO of Conflict Team, which is a tech algorithm-based platform that provides an online solutions for dispute resolutions without intervention from another person or entity. He has more than 20 years of expertise in creating information systems and integrating technology with the goal of resolving legal disputes. David has conducted an extensive study and developed ODR systems based on models of algorithm and integration computer. David will be talking now about Conflict Team and how they are solving disputes with the technological and the profit of it, not only for both sides, but also for the legal community. Please welcome David Laxiel.
Hi, thank you very much. So, Conflictim is a part of the online dispute resolution system. For example, if you know about these kinds of systems, you have the European Union that they have a dispute resolution system that using the third part, such as a lawyer, in the to try to solving the dispute in their cases, in their systems. But we are trying to do it without the third part in the system to solve the cases in our system. What we are trying to do is to bring models of technological system that try to learn the behavior of the both sides and how we can try to bring them to compromise in our system and into the dispute case, to bring them to the solution to the case and for the dispute. We are not trying to build any kinds of arbitration system. This is not kinds of models that we are thinking about it, but yes, we are trying to build a compromise systems and compromise models to solve the dispute. What we are trying to do, it's like a bidding system that they are offering their offer of how much they want to compromise. And when they are entering to the system, they must understand that the system is not trying to do the arbitration, but only to bring him to compromise the settlement. And if the system will not be able to solve the dispute, we actually we show them the lawyer list or mediator list how we can say it, the system and the technologic, we will not able to solve the case with our models. So we actually bring a work and cases for the lawyers and for the mediators to start to solve the dispute and take it to the court systems and to continue on. So this is what we are trying to do in conflicting system, and it was very hard to build it. It took us something about 3 years to figure out, and in the pilot, when we started to do the pilot in our system, I can tell you it take us about 2.5 hours to solve a case. And when the case was open, it took us 2 hours and 50 minutes to close it, without using the third party in the dispute. So we didn't use any kind of mediator or lawyer. We actually closed it with our models. But when we closed the case, we asked both sides if they want. We are giving them a single contract to sign on it, but we're asking them if they want the signature of the law. There is the list of lawyers that you can go to them and to close it with the lawyer, and he will give you the signature. So we actually bring a cases for lawyers and mediators to continue on and helping them to solve the dispute. This is what we are trying to bring to the law community, to the lawyers and to mediators. We actually have online cases of dispute that they need to solve it. If our models will not be able to solve it, we actually need hundreds or thousands of lawyers and mediators to solve it. So this is what we are trying to do in conflicting.
Thank you very much, David. I would like, honestly, to thank the honorable panelists for saving 5 minutes in our discussion today. So we actually have 15 minutes for Q&A. I would like, if possible, that we address the panelists who you would like to pose the question to. And thank you very much. We were honored by your presence.
Fawaz ji, before we open up a Q&A session, I mean, a few things I just like to actually, along with my other panelists, I would like to discuss. See, as we see that actually, as we are discussing about Gen Z, millennial, and an alternative to the alternative dispute resolution mechanism. I see that yesterday, I think a couple of sessions where we talked about legal issues, not only the legal issues, all issues matters. And David is with me, and where David is also speaking about a private entity dealing with online conflict resolution process. So we need to understand to which extent it is accepted. See, what is crucial is one is acceptance and the second one is a sanctity. It means that each government should give a sanctity to any of the mechanism that I think whosoever is coming up with the mechanism. As on today, what has happened is each country has its own set of law and they have recognized only particular patterns as a dispute resolution mechanism. So I was speaking with Roar yesterday when he said that actually enablement. So what happens is when we train our own clients, let us say that we have a company X, Y, Z as your client, and when we draft contracts, so what we need to do, we need to anticipate, okay, there could be, because today I'm drafting it, but it is read by somebody else. In general, I mean, I always say that whenever I draft a contract, I always say that contracts are always drafted by a friend and read by an enemy. So I need to anticipate what happens in future. If what is that somebody is misinterpreting my contract, so that will lead to a dispute. So I think I want Roar to address this, that how we enable whenever we draft the contracts. And second thing is each advocate will have a doubt that if I enable him, what happened to me? See.
Okay. I start with, first of all, I want to be a client of you, Mr. David, so you can send mediating cases to me, and not solved by the II. And to Mr. Kumar, I will say part of it will be the perspective taking. I think that was what I left when I gave the word forward. I think it's very important that lawyers take the different perspectives, step in the other party's shoes, because then I think it will be more easy to create those contracts with the eyes of the enemy. And I think that to challenge your own clients is one important part of building that trust that Mike talked about. And last comment I would like to make is back to what you said, Mr. Komar, about the complexity. And I think it's important for us to help the clients to create processes and walk in the door they want to seek best possible for them. And this came up from a professor at Harvard Law School in the 70s, and he called it the multi-door courthouse. You know, we normally step in the courthouse door, but why don't we, before that, look into what could be done in arbitration? Before that, what could be done in mediation, or in negotiation, conflict resolution, or we come down to David, and we use the AI to see what have been predicted in that relations. So that complexity, I think we need to be aware of and use the skills that we have so more clients will come earlier to the lawyers before the conflicts have been coming too complex.
If I may add something, basically based on what you just said around basically putting yourself in the shoes of the others. I think this is extremely critical. In all cases, because you have to put yourself in the shoes of your customer. I myself, I'm mostly on the customer side. You have to put yourself in the shoes of the other party who's negotiating with you. And I think it's very important, based on what you both said. I sometimes struggle because I feel that my counterpart on the legal side lacks on the possibility to understand really what we're saying, what we want. And this becomes exponential further when there is more multi-parties, and especially with multicultural and multi-jurisdictions in place. So it's all about stakeholder management, in my opinion, is trying to understand, to put yourself in the shoes of others, but also bring to the table the right people who can eventually be the people who will translate these cultural elements, who can help you understand these things. Because also sometimes, by the way, especially in my case, for example, in the cross-border transactions, the language is an issue. So even though most people speak English, maybe the words have a completely different meaning in another language. And it's very critical to keep these things in mind. And I think, so I had my budget I had to manage. And at the beginning, I'm an optimizer, so by tradition, I was trying to cut down costs. But in this transaction, I said I'd rather have the best people around me pay more, but I want them to clearly understand what I want. I want them to clearly make sure that the other party understand also what he's getting into. So at some point in my transaction, I have advised and even convinced the sellers to bring on board an M&A transaction lawyer to make the discussion more easy. So, and honestly, I would, if I had to step back into this situation, I would do it again and again. So I think it's very important to always keep in mind putting ourselves in the shoes of others, understanding the cultural differences, bringing the right capabilities and talents to the table, and again, hoping that people come with the right value, with the right ethics to the table as well.
And as, David, please.
No, it's good, it's good.
I just actually, as we are discussing about culture, I need to actually take some cue from our moderator, Fawaz, Mr. Fawaz, because as he's an international negotiator and a peacemaker, and you deal with different countries, I want to understand. So when there is a difference between two countries, what is that you look into it and how do you negotiate? Yeah, I mean, few cues. So what happens is we can...
He's the master, you know.
Yeah, I think.
As a trade negotiator, international, global, I'm quite happy to see trade wars, because then I can negotiate and I can make money and stop the war. So I'm totally different from what you are. You are negotiating and trying to find solutions between one person and the other, between one entity and the other. I have 2 billion people in Russia and India who do not like what the USA is imposing in terms of duties. They don't like what Europe is doing. So I can always find a job for myself internationally, thanks to Russia, China, Japan, and the rest of the world. Thank you.
Gentlemen, we have a few minutes left for questions from the audience, if you would like to
before
take some.
Before we go to questions, I think David wanted to make some point. David, please.
Yeah, I would like to say something about the arbitrations. As a technical man that know how to build these kinds of system, we had the point that we had to decide which way that we are going to do it. If we are trying to solve the dispute by arbitration models or by the models of the compromised models. And we think about it, if the system will get to the parts arbitration models, so one of the part will win the case, the other one he will lose the case. He will not believe to the system. He will not. He will say, "No, I don't want to. I do not want to solve this dispute in the system. I want to go to the court." So this is why the reason that we go to the compromise and to try to bring them with the models of the compromised, not with the arbitration models. So this is one of the reasons that we not, as a tech man, I do not believe in arbitration models.
Thank you very much. Just to add, we need to give the audience, if you don't mind, Kumar, if they have any questions. Do you have any questions in the audience, or would you like to listen a little bit more to Kumar? Go ahead, sorry.
Yeah, good afternoon. Just to make a change, and somebody's asking from the audience. So is there any, let's say, industry specific, shareholder specific, that may warrant actually different dispute resolution culture, creativity in industry, addressing that in different way? Is that, you know, is there examples that you can think of, situations that you can suggest, any recommendations top of your head? Sorry, this is general question, so I'm not quite sure to whom I should address this within the panelists, so feel free, you know, any one of you gentlemen.
So, generally what happens is, what you said is actually a sector-specific dispute resolution mechanism. Most of the contracts, I think, we are doing, what's happening is today, like, I'll just give you the example of India. If you are drafting a contract, so what we do is, we will insert arbitration clause. So we also have a habit, not all the contracts, some of the contracts, they will also name the arbitrator. So we have a sole arbitrator, we have an arbitration from both the parties, and both the arbitrator will appoint a third arbitrator. So once you choose them, it will be more or less, you will choose the person who has an industry expert, who has that knowledge, who has that domain. That's very crucial. One more thing I want to see, recently we have tried up with something. Before we start arbitration, before we start negotiation or conciliation, mediation process, can we have something in our hands? What's very crucial here is the life of the contract. See, if the contract life is 10 years, 5 years, 7 years, it means that more or less the creator is alive. I mean, in 90% of the cases, the creator of the contract will be there, and the parties who have inked, who have signed the contract, they also will be there. So in those kind of cases, it will be very easy for even anybody who has onboarded as a mediator or a conciliator to resolve the issues. Second thing, what we have done is, we have, in one of the contracts, we have tried to have an internal dispute resolution committee even before engaging a third party. So as actually yesterday, I mean, when Roar was speaking about the enabling, here in a contract itself, you can educate your client. And if your contract is transparent and comprehensive, and if it is a balanced one, where you have considered both the parties, it is in the hands of the draftsman, definitely the chances of breach would be less. Chances of breach means you will have a less litigation. In the event of issues, interpretational issues, then the internal committee can take care of it. They can sit and they can resolve. Only beyond this, you have to go to the third parties.
Kumar, let me try to bring some completely different angle to the table, which has nothing legal to do. So I mentioned partnership, right? And so basically, a couple years ago, when I was in the corporate world, I was managing a couple thousand of suppliers. However, obviously, you cannot manage them all in once, so you have to split them into different tiers group. You had the strategic one, which were very limited, around 15, and then the tier 2, and then the tier 3. And to be honest, I want, as a business person, I really want to avoid getting into the discussion of the contract. I will do everything in my best to avoid bringing the lawyers. If it's a partnership, we should be able to sit down to the table together, discuss these things together before getting to any law. Otherwise, it will become transactional. It will not be a partnership. So I remember, with our key stakeholders, with our key partners, we had some governance in place where we would meet on a regular basis. Same as what I'm doing at Green Logistics today with my key customer. I'm speaking with them on a regular basis to understand what is it that they like, what is it that could be improved, how can we align interests as much as we can and resolve differences whenever there is. In order to avoid being in a situation where we have, we're opening the legal contracts and then we are having disputes. Otherwise, it's a never-ending story. So I, on a personal level, as Mike, And the way I've been dealing with my stakeholders globally is to really be in a situation where there is a process in place. And in many cases, it depends also on the size of the businesses, on who is in front of you, who is your stakeholder, what do they want, how do they want it. And and this is going back to what Rora was saying, putting yourself in the shoes of the other. When you are able to really understand who is this person, what do they want, how do they want it, with which key information do they want it, then we can manage that in a better way, and it requires some level of agility to be able to avoid getting to the situation where we're in front of a court or with a legal suit, for example.
Just final remark in relation to this. Sorry, there is, Mike, in relation to partnership, there is recent trends, actually, that certain countries adopted. I'll give you examples from the region, KSA and UAE. For family businesses, family companies, what they have imposed now, that you can have family charter where all your disputes will be resolved as dictated by the family. That means you can resolve it outside court, outside arbitration, maybe by family member who can decide how the dispute will be resolved. So this is one of the things that maybe could be expanded beyond and go to partnership and others where it could be resolved outside, the normal litigation and arbitration system. Thank you very much.
Thank you very much, panel. That was a fantastic discussion. Gentlemen, a lot of synergy there, and not an easy topic, obviously. Conflict resolution, dispute resolution.
One sentence, can I make? One sentence. One sentence.
Thank you very much, sir. I'm sorry, sir. I'm sorry. We are finished as a respect for the following panelists. Thank you so
guys.
much.
Wake up.
Yes, sir. Oh, you'd like to take a photo? Go ahead. Say cheese. Thank you, gentlemen. Thank you. Thank you, Doctor. Fantastic moderation. All right, ladies and gentlemen, let's keep the learning momentum going with this next session. As AI has been generating buzz and driving excitement over recent years, but has it also increased concern for IP paralegals and lawyers? Our experts, Esther Ong, Senior Partner at Messer, and I'm sorry, I'm going to rephrase that. Our panelists for the next discussion, Ms. Esther Ong, Senior Partner, Monsieur Esther Ong Tenku, and Saiful and Sri. Welcome, Esther. Mr. Ray Vikramnath, Founder and Partner at Aretha Legal. Welcome, Ray. Ms. Vanya Mejevan, Founder and CEO of Lawrence Legal. Welcome, Vanya. And Doctor is not present today. All right, so ladies and gentlemen, the floor is yours, and the panel discussion will be on, is IP law prepared for AI? Go ahead, ladies and gentlemen.
Good afternoon, everyone, once again. I hope you're enjoying the conference so far. Thank you very much for having us today. So I will be acting as the moderator of this panel. And I would first like to introduce you to Mrs. Esther Ong, Senior Partner at Esther Ong Tenku Saiful and Associates in Malaysia, Kuala Lumpur. Esther, you're a lawyer of 26 legal standing, and you're Senior Partner of your law firm that you founded at a very early age. Your primary areas of practice are in intellectual property, conveyancing, corporate matters, franchising, civil, and corporate litigation. You frequently appear in court for litigation matters, and you even appeared in the Federal Court of Malaysia on numerous occasions. Your experience includes a variety of tort matters, including and not limited to defamation and negligence cases and family disputes. You always have the passion and development of franchise businesses. You provide advice on setting up of a franchise business, creating a master franchise, sub-franchise, registration of franchise with the relevant authorities, and so on and so forth. You have successfully assisted entrepreneurs to expand businesses into a franchise group that has grown throughout Malaysia and overseas internationally. You're also empaneled as an arbitrator and adjudicator with the Malaysian Institute of Arbitrators, the MARB. And you're the legal counsel with the ASEAN Retail and Franchise Federation. Your latest achievements include being named as the finalist for the Woman Lawyer of the Year Award by Asian Legal Business, ALAB, Malaysia Law Award 2021, and finalist South Asia Legal Firm of 2022. Congratulations to that. You've also been invited to be a speaker in numerous legal talks by many associations such as Brand Association Malaysia, Malaysia Dutch Business Council, Asia Business Forum, etc. So, Esther, actually, after this wonderful introduction, I thought you could start by explaining us, as you have over 20 years of expertise in intellectual property law, could you remind us maybe the fundamentals of intellectual property?
Testing. Thank you very much for this kind introduction. Yeah, perhaps, I would like to start off with, in fact, the very basic of what intellectual property is. I think all of us know intellectual property is a creation of mind, whereby the artistic work, or the literary work, or the logo, or the design, or the symbol can be actually properly registered, and therefore you can given the rights to protect it. That is the basic of intellectual property. Perhaps we want to look into three aspects today. We want to look into the copyright, the trademark, as well as patent in comparison with AI. All of us know that copyright, there are three elements to copyright. That is to make sure that we have the original work, right? It is reduced in writing, and of course, it belongs to the types of work. Then that part of the work can be copyrighted, right? Of course, perhaps later on we can discuss about the AI of copyright. Then the second part I thought we would like to discuss is in respect of trademark. I think all of us know what is trademark is, right? We can register trademark if it is a symbol, or it is a mark, or is some kind of words that you want to register it as a trademark. Of course, later on, we're going to discuss about the infringement of trademark. How does AI come to the picture in terms of infringement of trademark? And, of course, patent. Patent is, of course, the invention. There are three elements to it. All of us know that, okay, the novelty, that means it must not be put to public before you register it. The inventive steps, as well as the industrial application of it. So, of course, these are the basic of intellectual property, and we want to now venture into the AI part of it. So back to you first.
Actually, I had maybe a second question for you. So these three fundamentals, meaning copywriting, patents, and trademark, AI could apply to all three of them. And in your opinion, what differentiates AI application within these different fundamentals for intellectual property?
Okay, well, the fundamental difference between AI and the usual intellectual property in respect of these three aspects is, of course, a human factor. When it comes to copyright, definitely, okay, there is a human factor. There must be an author to create that kind of copyright. For example, song, right? There must be a songwriter. The human factor is there. Whereas AI is something where we know, okay, it is something where, yes, there is a human factor in terms of putting in perhaps the software, the application. Like, for example, there's one case lately, I think it is called the Rembrandt. There is a new piece of art that has been actually produced, quote unquote, produced by AI. How does it happen is that AI have actually analyzed all the past works of this 17th century Dutch painter, right? And come up with a new painting called the New Rembrandt. So question, of course, is that who owns this copyright of this new painting, right? Who owns it? Because it is definitely not the painter who have come up with this new Rembrandt painting, but it is AI who analyzed thousands of his works and come up with this new painting, New Rembrandt. So who owns the copyright of this painting? Well, in the German court, right? They are still very conservative. They say that no, there's no human factor in AI. Hence, okay, the programmer is not able to own the copyright of this new painting. Whereas in the UK situation, I think we know that there is this act, the CDPA, Copyright, Design, and Patent Act, right, has a section that actually defines what is computer-generated piece of work. For that, they say that as long as there's a computer-generated piece of work, even though there's no human factor, it is recognized as a copyright work as well. So there we are. We have two jurisdictions. The German still feel that whenever there's no human factor, there is no ownership of copyright because there's no human factor. Whereas in the UK situation, there is a section under CDPA that says computer-generated work can be accorded copyright. So that is a part on copyright.
I feel actually we should take a bit more time to discuss this ownership a little bit later. But first, I would please allow me to introduce you to Ray. Ray Vikramnath is a founding partner at Arita Legal in New Delhi, India. Ray, you have a unique mix of 5 years of litigation and over 14 years of experience in cross-border transactions, advising on joint ventures, mergers and acquisitions, private equity, and general corporate and commercial matters. You have advised Indian international companies extensively in sectors such as private equity, IT, ITES, fintech, manufacturing, robotics, energy and infrastructure. You also advised on regulatory frameworks concerning foreign direct investment into India, food safety regulations, data privacy, and labor and employment laws relating to day-to-day functioning for the client and companies. Before establishing your law firm in 2019, you spent time with top-tier law firms in India and in Japan. And Ray, in your opinion, and given your broad knowledge of these international laws and data, actually, is current IP framework, international framework, capable of handling the risk related to AI-driven softwares and machines? And how do you measure this risk? And what can you tell us about this risk?
Thank you so much for that great introduction, Vanya. And I would also thank Esther for setting the platform to discuss and build upon the conversation on AI. Vanya, before answering your question, I think we need to also understand what are the risks involved with AI. And, you know, as AI is a very, very new phase of technology that we are all facing around the world. So, as you know, law generally is a reflection of what happens in the society and not the other way. So law has to catch up with this new artificial intelligence and the risks involved with it. So we need regulations around artificial intelligence. To me, what are the risks? I would think that, you know, I look at this wonderful technologies and, you know, like Tesla coming up with self-driven cars, or for that matter, any artificial intelligence which would tell you or give you solutions out of the algorithms that it can have. But what happens if the self-driving cars, they go and they bang onto some person coming from front? Whose liability would it be? Would it be the machines? And if it would be the machine, then basically you can't punish a machine, or you cannot. So would it be the owner of the software which is produced by, let's say, the company, or would it be the person sitting behind the cars? Because practically there's nobody sitting behind the cars in a self-driven car. So to cut the story short, I think what we need to understand is the risks which are involved with artificial intelligence is something which we are still in the process of learning as the AI, as we grow with AI. And since we are growing with AI, to answer your question in short, no, the IP laws are not equipped currently to handle the risks which are involved with AI, because we don't even know the extent of the risks which are involved with AI. yes, over a period of time, we will be able to analyze better what are the risks which are with AI, and then we will be able to build around regulations which would protect the users of AI. Of course, I also feel and I perceive that in the future, the option would be with us to use, in the future, the option may not be with us to use AI because, today we may have the option of using AI or not using AI. But in the future, as we go deep with AI, with machines, with machine learning, we may not be in a position to have that option. That's when the laws to regulate risks would come in. That's my take on this.
And what about the risk of false data? As you know, algorithms mainly use data in big data sets, rather questions, answer, or even personal information, patient information. So what if this data, collected data, that is then used to feed an algorithm is false, and how could maybe the scientists or people that collect this data can be liable for false data collection?
Yeah, that's something, from the Indian perspective, I can tell you, I don't have the exposure what happens in other jurisdictions, but from the Indian perspective, I think if you're collecting a data and the algorithm, I type a question, and typically the algorithm would go into the repository it has, and it comes up, it throws upon you certain certain answers based on the repositories, then it would ideally, basically the company can get sued for that. But this has to be really challenged. As of now, in my experience, for instance, in India, nobody has come up with nobody has sued a company for this, these kind of answers.
There's a lot to be discovered still. As we all know, whenever there's a new creation, there is an owner of the creation, a piece of art or a value added to the creation. But today with AI, the ownership can be discussed. Who is the owner of a work of art or whatever document that is generated by AI, machine learning, natural language processing? Is the machine the owner? Is the AI the owner of the new piece? Is the founder or the IT company that actually developed the algorithm the owner? Is the data recollection parties the owners? Who is the owner, Esther, in your opinion, of a newly generated piece of art or document when the owner and the creator is actually AI powered?
Okay. Well, just now I mentioned, right, the law is still very strict, especially in the UK side, just now the Germany side, just now I mentioned, they still insist on the human factor. If there is no human behind the invention, copyright rights will not be given to the person. In fact, just now I mentioned there are 3 parts, copyright and the patent. For patent, in fact, it is more strict, okay, right? In fact, lately there is one case called Dabu's case, right? The court still interpret that, well, the AI cannot be the owner of the patent, okay? Even though there is this computer programmer, Dabus, who wanted to, of course, claim ownership of the patent of the quote-unquote invention, but it is not successful because it is still not a human factor behind. So personally, I agree. Yeah, because you see, we go back to the basic. The basic of patent means you actually give rights to the inventor, someone who actually invents something new. The novelty must be there, right? Yes, I respect the programmer who come up with very fantastic way to do this algorithm to be able to really help. I know there are a lot of AI-powered device or machine that helps the doctor to even diagnose the diseases in patients. Well, I know of that. In fact, personally, I also lately went for some checkup, and I was amazed by the device that the person uses to really check what kind of, perhaps some kind of, he told me as some bacteria or some parasite that can be detected by that device. And I asked, what is it all about? And he says, using AI, right? So I respect all that. But if you ask me personally, I also feel that, well, the science behind the invention must be from the person who first created, who first invented, who first discovered, right? That's the essence of patent. Patent means the person who first discovered, first invented. So that patent rights must be accorded to the individual, that human being. But any AI subsequently to detect or to help, or a tool to help the doctors, or any person for that matter, to me, that is still something whereby it cannot be patentable. It is the patent rights still cannot be given to that computer programmer, right? And in fact, the law as it is now, it is still, the human factor is very important. Without a human factor, the law as of now still do not recognize the fact that that machine can be patentable, or the computer programmer can be the owner of that patent as of now.
Thank you very much. Yes, thank you, Esther.
Add something on that, what Esther was talking about. I think the reason why we keep going on to the basics, and in the case of artificial intelligence, is mainly because there's a vacuum in law when it comes to artificial. I mean, do you agree with that? And that's my question number one. Question number two would be, and because to me, I think we always go back to basics in any law. I mean, let's not talk about IP. In any law is only when we falter in getting a bespoke law for that exact thing. That's why we think, oh, okay, we don't have laws for this. Let's go back to the basics. What is it actually? So I think to my thinking, and that's my maybe personal thinking, in AI, as I said, law is a reflection of the society and not the other way around. We have progressed, science has progressed, but law has not. Law has, we talk about copyright, written things, or patents, we talk about inventions. So I think that's been going on for centuries. And then the laws were built around it. I think in the case of AI, that's not the case, right? I mean, we are struggling to go back to basics every time we talk about AI, because we don't have laws around AI, specifically AI. Second, so that's question number one, I mean, thought number one. Thought number two, you were just talking about, going to the person who actually invented something and giving the ownership to that person. Now, ultimately, everything has come from natural resources. So what I'm trying to say is that if a creation is done, which is completely different, but based on many things which have been done by many other people. So we are talking about an algorithm in artificial intelligence which can create a completely new thing, but which would be having parts, millions of parts of things created by some other person. How does that ownership would come there?
I still remember, I think in the morning session, there's one speaker who said, AI is as good as the input of the other. Yeah, you may be right. And remember, in the morning, there's one speaker who said that AI is still as good as the input of the other. Yeah, you may be right to say that, well, completely a new... In fact, there's once a song called it Beyond the Fence. It's also completely, the lyrics was written completely by AI, okay? But the German law, the quote there says no, okay? Even though the lyrics was produced completely by AI, the copyright of that song, Beyond the Fence, it still doesn't belong to the computer programmer, the AI, okay? They still need the human factor. So that's why back to my personal opinion is that, yeah, back to basic, right? I mean, law, what does law do? The basic law is to make sure we defend rights, the truth. We want to give justice, right? So I agree that, okay, the person who composed a song must be from a human being who have a creative mind. Whereas AI, no matter how smart AI is, it is still a machine. In fact, this one I personally have the experience. I actually was late yesterday because my flight was delayed. My flight from Malaysia to Dubai actually took 6 hours, but it took me more than 12 hours to come here because the flight has to go to Bali, from Bali to Dubai, more than 12 hours for me to come. And lo and behold, my luggage was also stranded in the airport, okay, right? So what happened, of course, I need to call and find out where my luggage is, okay, right? And you know what? Okay, when I text them, or rather I call them, you know, they say, no one pick up the call. No one pick up the call. Then they say, oh no, don't worry, you know, when I go to the website, they say, you can actually have a live chat. Oh, I was very happy, okay, right? So I text, okay, I give my ticket number and all that. Okay, definitely behind it is AI because it was so quick to answer my question. But you know what? As my question progresses to a bit more different, okay, I say, now what happened? Where is my luggage, okay? You know what? No more reply from it. Standard answer is that they will ask, what's your ticket number? Where's the destination? Oh, that was very fast, you know? That means it's AI behind, right? So you know what? It was so frustrating that I need to actually go back to the airport, sat down yesterday, so I got to leave early, sat down in front of the officer there and said, what happened to my luggage? Okay, how come when I call the airport, no one pick up? So to me, it's all because they rely too much on AI. I mean, from my analysis is that they thought that the AI could answer all the questions, but they couldn't. Because when I asked when, where is it, where's my luggage, they couldn't answer. No more answer from the AI, from the live chat. And when I called the airport, no one picked up. So I guess they relied. They thought that, oh, the AI will answer the question. Don't tell me, oh, Dubai airport, no one answered my phone. You see, I got to actually, from here, took a cab, went back to the airport, sit down there, ask the officer what happened to my luggage. Okay, in front of them. Then when I could get the answer and took my luggage yesterday night only. You see, so to me, it's that it's still AI. So personally, I still feel that the patent rights, copyright must be accorded to human factor. That is still something I will still strongly believe is no matter how advanced AI is. Well, another thing perhaps to answer your question as to, you know, I mean, it'd be fair to say, you have done so much work, right? To me, why not we give them the benefit? Like, for example, I know NFT, right? A lot of people now buy and sell a lot of NFT. So instead of you come back and claim copyright, why not? It is a buying and a willing buyer, willing seller situation. In fact, a lot of people say NFT, why spend so much? Yeah, then go ahead. You feel that the NFT have done a good job, you like the NFT, go and buy it. But don't come back and ask for copyright ownership, patent right. Yeah, it's a willing buyer, willing seller situation. Your benefit you derive from paying. That means you sell it, wow, there's a willing buyer who's willing to pay you for the NFT. So to me, I take it that way. That's a benefit that you can derive from the AI that you churn out. But don't come back and get the IP rights. That is still my take.
Thank you very much, Esther. This was very, very interesting. I still have 2 questions, actually, and I think you also might have a couple of questions as well. As I told you yesterday morning when I was presenting, I developed a couple of years ago this legal tech company, the first legal tech in Switzerland, actually, which is basically acting a bit as a I don't really like calling it an Uber for legal services, but it's a platform where clients can ask their legal questions and receive in a very short amount of minutes preliminary legal orientation, almost for free, telling them actually which is the right legal process, what is the solution they're seeking for, what could be the path to take, how much it would cost them with said specialists, how long and how much time it would take them. So these preliminary legal answers are actually given by an algorithm based on a data set of answers previously given by specialized lawyers upon receiving questions from clients. So basically we received thousands and thousands of questions of clients. All these questions have been answered previously by legal specialists. So now when a new client jumps in and comes with a legal question that might be similar to another one that was previously answered to, then the algorithm sets the data. This data recollection process, and I don't want to go in depth into the collection process of data, but this took a long time, and a lot of people behind it to actually make sure that the wording that was used was the right one, that the wording that was used to answer was the right one as well. And today, in science, for instance, all this data is supposedly belonging to the community and not actually the people that took so much care and so much time to collect it. And I would be very interested to have both your opinions as lawyers and legal specialists. Maybe one of you could act as the defense lawyer and the second one could act as the opponent, because I find it such an interesting debate to know, especially in science, for instance, beating cancer and doing research on cancer, and medical clinics and privately owned clinics are seeing a great amount of patients. This is a great collection of data. They come up with fantastic results. They might even come up with algorithm that could actually even see in advance when a cancer should be treated or not on this patient that has maybe some symptoms that were preliminarily discovered with another patient. And yet, these privately owned clinics do not own the data as it's meant to belong to science and general community. And how do you feel about that? Is it fair or unfair for these clinics, or for me, for instance, that took so much time to collecting data of clients? And how do you see the future of this data collection process with within the interest of intellectual property laws and rights? And sorry, my question was really long, but I'm sure it's an interesting debate.
I think data collection is a very tricky topic. I can go on and on data collection and how how to use it, how to collect it, and how to process it. But if I limit my answer to intellectual property, then I think we have to reach a certain stage where, for instance, patent laws, beyond a period, it becomes public knowledge because it is for the greater of good, greater of larger number of population. In certain cases, life-saving drugs are not patentable because you need it immediately. For instance, if it would have been patentable immediately, then we would not be having COVID vaccinations so quickly and for 6 billion people around the world. So I think it's something to do with for the purpose for which you're collecting the data, and and coming to intellectual property, I think it has to be viewed in the same manner as I just explained, depending upon what that data is for, and if it's for the larger good, then I think you need not save it. You can spread it around, but credit should always be given. I think that's where we lack, because I see a lot of, we're all Google doctors, we go on to Google and we put our symptoms down and Google comes up with, but I think credit mechanism is not very good when it comes to such algorithms giving answers to collected data. That's where we lack, and that's my view on this.
And now maybe could you, Esther, tell us a bit, maybe if you had to defend a clinic that came up with a fantastic research, but actually that had to give this research almost for free for the good. Obviously it's a very generous offer, but how would you proceed defending this clinic?
I would definitely defend the person who put in so much of effort, time, sweat, or even blood in to do all the research. In fact, just today is December, just October, I was involved in a fundraising exercise. You know what? To raise funds for artists. I think sometimes we look at artists like, wow, they're always in the limelight, they may be earning a lot of money. But you know what? For the past 2 years when COVID pandemic hit them, artists, they were actually no income, right? The songs that they have written, sometimes, the copyright money that's supposed to pay them never goes to them, right? So to me, that is the essence of copyright. Why copyright first comes into picture is because we want to recognize the effort that they have put in. So we need to pay all these people who have actually come up with songs writing, right? Do all the research. Yes, data can be made available, but please go back and give them the credit, right? I'm sure, yes, all of us, okay, will be very happy to share the knowledge, to share the data, especially for the research, like just now you mentioned the clinic, the doctors who have done all the research. Yes, those data can be shared, provided give them the credit, or perhaps even have to pay them, right? So to me, that's why intellectual property is all about. IP is to protect those people, human, who have put in so much effort. That's why it's intellect, that intellectual property, their rights, their time, their effort to come up with certain things, right? We need to actually give them that right. So not just because of AI come into the picture, right? That yes, of course, just how you mentioned about the fact that the algorithm is such that they're able to search those frequent questions and then the frequent answers. Yes, I give credit to those programmers who are able to detect. In fact, I also like how now even the translation happens in Google. In fact, they have done a good job already. Google Translations is doing a good job. But all these are still programming. So, well, pay them accordingly. Give them the benefit. If just say the programming is such that they do that part of the work where they're able to select or to identify or detect the similarity, yes, pay them. That software is good. In fact, I use a lot of software in my legal firm. I love software, right? Then we pay the software company for all the hard work that they have done, but not to get IP rights for those invention, for those story they have written, the songs they have written. So it's totally different thing. To me, it's quite clear. AI is AI, right? IP belongs to the owner, the inventor, the songwriter. AI is a programmer. So then you can sell because you've done such a fantastic job in writing the program. Hence, your company can sell the software very well. I will go for it. I will buy the computer software from you. You earn from your profit of selling the computer program. Yeah, but you don't claim AI, or you don't claim IP.
If I can just jump in, because this is a very interesting question that just rose in my mind. Algorithms are meant to change, if not daily, weekly, monthly. So how, if I create an algorithm that I want to patent or trademark, how am I going to ensure its protection from intellectual property point of view, if this algorithm is meant to change in 5 days' time, 10 days' time, 10 years, like not 10 years, but 1 year time, how is the same algorithm going to be protected under my name?
It doesn't come under IP. IP is very clear patent. Patent has been invention. So the doesn't come under IP, doesn't come under patent, doesn't come under copyright, doesn't come under trademark. So that's why that is just your yeah.
Exactly. So
that's not IP. Yeah.
So there's actually no big
Correct.
change.
Yeah,
in
you
your
can change.
opinion.
You can change. That's why, in fact, your company then comes up with a very good way to detect. That means your company can sell that software above other competitor. That means your software is better. Right? In fact, my company have changed using one legal software. Then when another salesman comes, oh yeah, yours is better. Because when I do convincing work as well, right? Yeah, they're able to detect. They're able to come up with a template much faster. I go for that software. You see?
Yeah, but I think to answer the question, I mean, for instance, in India, you can, there's a source code for every software that can be copyrighted. That can be copyrighted.
Panelists, you have 4 minutes left if you'd like to take a question.
Sorry, no, there's a last question that actually I wanted to ask you, Ray, if you don't mind, and then we can obviously answer the questions. It has been notoriously difficult for creators to capture the value of their work in the digital environment. And so, in your opinion, will this new wave of digitalization compound the problem? And yeah, what's your opinion on that?
I think for sure, as a lawyer and as a litigator at heart, I love disputes. And as much as all the panels have been discussing about dispute resolution being shorter and shorter, these notorious people, they always come up with ways of creating confusion and creating disputes. So I think it's on the rise, and you would see above all disputes, cybercrime and cybersecurity would be at the top in the next, if not already, in the next 5 to 6 years, across jurisdiction.
Fantastic. Thank you both so much for answering my questions.
Thank you.
Thank you.
Thank you.
So
Okay,
maybe
so
we
we
can-
have 2 minutes left.
We
and
have
a
3
half.
minutes left for questions. So if anyone,
Hi,
good
thanks
afternoon, sir.
Thanks a lot for the panelists for throwing a lot of light on this. It looks like from the discussion that currently the law is really lagging in capturing the fast-growing technology that's happening in AI, right? So you're talking about the human touch, right? So 100 years or even before that, we came with a corporate wheel in the corporate law where the company doesn't have a legal form, or rather even, it has a legal form, rather it doesn't have a physical form, right? So we could create in law a corporate entity without any physical structure. We created a common seal for that, and we call that's a signature of the company. So now that AI is turning out into be even robotics, right? So when tomorrow we have a robotic doctor, and we have a physical doctors like you and me, before the physical doctor would diagnose the patient, there is also a screening done by an AI doctor, and that AI doctor should be patented or can be patented in future. So I think the legal system has to catch up to the technology growth that is happening, especially in this field. So what is your call on that? Because we cannot keep telling that human touch is the only thing that can be patented. There are human touched and created technologies which act as equal or sometimes even better than the humans, because there is something called machine learning, and that's what next 20 years, 30 years afterwards, where this machine learned, self-learned, artificially infused robotics or whatever mechanisms or machines will be far better than the collective knowledge of doctors, right? So how come we can just escape from this particular thing, saying that only human touch can be so-called within coming the purview of law? Don't you think we are really lagging on that?
Maybe Ray, you would like to jump in?
Yeah, I think I'll briefly, just in one line, and then I'll let Esther talk about it, because Esther would be having much more experience in this. But you're right, absolutely. We, as I did mention earlier, there is a vacuum in law when it comes to AI. AI is developing very quickly, and laws are, how laws change, they take time. It's a democratic process. So yes, AI has to catch up with, the laws have to catch up with the changes in AI. And,
if I can just jump in, I know that maybe European regulations you're not so familiar with them, but the EU and Parliament and Commission have come up last year in April 21 with the AI European Act, which is now being actually under inspection, and which is most probably going to set a very interesting benchmark, international benchmark, like GDPR did in 2018. Now the AI...
I'm always envious of Europe. They always come up with these standardized...
I think they actually need it, to exist internationally at such wide level, because worldwide we cannot compete against China, India, all these fabulously advanced countries in terms of tech. So in order for them not to be eaten, in a way, European countries and European Union is actually acting as a bit of a forward thinker, auto-proclamated, by the way, because no one has asked a European Commission anything, and yet whenever there's a new invention, blockchain, NFTs, European Commission and European Union has, and governments have to put their nose in there and start to regulate. So yeah, apparently this EU AI Act will become a major benchmark for the international AI, not only legal tech, by the way, but like artificial intelligence and fintech and all different kinds of, yeah. So maybe Esther, you know. Time is up. Okay. Thank you
so
very
much,
much both
panelists.
for such amazing.
Thank you.
Thank you.
I think
introspection,
the
reflection.
UAE law would have been also included the AI process in framing it, right?
Thank you very much. panelists. Thank you. One photo, please.
Yes, of course.
Thank you. Thank you. All right. Next, we have Kaushik Mukherjee, President of Legal at Indiabulls Housing Finance, who will share his insight and his thoughts on the topic, the importance of being earnest in the financial services, a legal perspective in governance. Give a huge round of applause for Kaushik.
So, hi everyone. I'm back again. So today we are going to discuss corporate governance and how it has evolved over the last few years in India. So before we actually start talking about corporate governance, it makes sense to take a minute to try and understand why we need this. Now, essentially, historically speaking, it has always been the forte of companies, basically the aim and the objective of companies worldwide is to actually maximize profits for its shareholders, for all its various stakeholders, and that has been sort of the principle, the guiding principle behind companies and how they function internationally and in India. Now, of course, however, in the last 10, 15, 20 years, we've seen that people are actually thinking more about governance, about how to run the company with certain larger, more social, more moral principles in place, rather than sticking on to just maximization of profits. So let's just try and let's go back to the basic and let's see what OECD says about corporate governance. It says that it is a set of relationships between a company's management, its boards, its shareholders, and other stakeholders. Corporate governance also provides the structure, very important, it provides the structure through which the objectives of the company are set. So, let's pause here for a second. Let's think about this. So what we are trying to put in place is a structure based on how and principles based on how the company will be run. And that is the most important principle of corporate governance that is essential for companies worldwide and in India, which is actually evolving, growing from a state where it was mainly driven by families, by promoters, by owners who had an overwhelming stake in the company and would profit from its growth. We are now moving to a more evolved, a situation where there is more than one distinct stakeholder in the company. So what good governance is, it provides incentives for the board and management to pursue objectives that are in the interest of the company and the shareholders. Now, very important is what is the interest of the company and the shareholders, and we'll get there. So moving on, this is what I was talking about. Profit maximization has always been the objective based on which companies were run. So profit maximization was viewed as the end game by corporations, as directors nominated by shareholders were expected to pursue strategies that would result in the greatest benefit to the principals. So basically all the managers, their end goal was to try and generate more profits. And that has been the historical perspective to running a company. But we are moving from there. We are not there anymore. Because there are various issues that come up if we are only looking to maximize profits. While of course maximization of profits is a key issue that needs that needs to be adhered to. Of course, nobody is, unless you're a charitable company, you're not doing things for love and fresh air. You are certainly going to maximize profits, but there has to be an ethical, a moral standard, and a set of rules and structure based on which you pursue this end objective. So the traditional theory, the people who basically are proponents of this profit maximization theory argue that only such an objective would ensure that the board strictly adheres to its duties towards the company and doesn't exercise untrammeled power. So basically, unless there was a guiding principle of profit maximization, boards can take on various other ancillary things, which sort of, how should I put it, which actually goes outside of this profit maximization perspective. So profit maximization in the short term may increase the immediate net worth of the owner, but they may be at the cost of long-term growth to the minority investors and the other stakeholders of the company. Now, this is particularly important. So if we are only looking to maximize profits in the short run, then how does it work? I mean, you know, the best company for me is the one that has been growing steadily, not like a huge volatile curve that goes up and comes down equally quickly, but one in which there is sustainable development and sustainable growth. So everybody is looking for sustainable growth rather than volatile growth. And that is the principle that distinguishes between short-term growth and long-term growth. Further, there are others who believe that every corporation owes it to the society and to the people apart from the environment. Now this is particularly important. We'll just quickly see this in the perspective of mining in South Africa. So when you see the mining sector in South Africa, and Motlanthe, who was ex-president of South Africa, says this, that, you know, the living conditions for these mining workers was so bad. There was silica dust in the air that a whole bunch of them actually suffered from tuberculosis. And that was sort of in South Africa, in the mining sector, it was almost in the proportion of a pandemic. And over a period of time, that actually resulted in deterioration of the health and safety of workers across the mining sector in South Africa. Now, if profit maximization were to be the end game and the only goal, then obviously these things would come up, because, you know, the companies would not spend money on health, would not spend money on their environment, on a safe sort of a situation where people can work and contribute to the society. And therefore, it's very important that we don't just look at profit maximization, but we also look at the social sort of fabric that is coming up around the mining sector. We should look at the environment. We should look at cleaner, more stable housing for these workers, so that, you know, in the long run, you are not only maximizing the profit for the company, but you're actually helping society sort of improve as a whole. So, you know, therefore that brings us to the question of whether strategies framed by companies should be viewed with a long-term perspective, or should short-term profits regulate the policies of the companies. So while the short-sighted approach leads to better profits and growth in the short term, it can lead to significant value erosion in the long run. See, this is particularly important. Of course, if you are able to maximize profits in the long run and keep at it with your business model, then nothing like it. However, if that sort of prompts you to take risky judgments, to take judgments which are neither black or white but gray, and gray in the area of legal compliance and laws, then ultimately, it can lead to issues in the future, which ultimately brings down. And here, the loss to investors can be drastic, right? I mean, we've seen a lot of scams in India, we've seen a lot of scams internationally, which ultimately led to a massive value erosion. So what is the point in making profits for 2, 5, 7 years and then losing it all in a month? And, of course, that is over and above the harassment, the legal struggles that the promoters of these companies may face in the future. So obviously, there has to be a larger principle in place, and that just can't be short-term value generation. Moving on, let's discuss some of these principles under Indian law. So the LODR, which is basically listing obligations, these are obligations that are cast on all listed companies in India. Now, what are these laws and regulations are aimed at ensuring one thing, and that is transparency, that is disclosure, and that is working in a setup which actually looks after the rights of all stakeholders, whether that is the owner of the company who has a controlling interest in the company, or it is a retail shareholder who is actually investing in the company on the stock exchanges. So these are the principles that are in India that come from corporate governance worldwide, and this is how we have adopted it in India. So let's start with independence of the board. Now, in India, every listed company is required to have a certain number of independent directors. Now, when I say independent directors, I mean people who are actually not in an executive position in the company, but they are basically either retirees from various organizations who are basically there to ensure that the company is run based on the principles of sustainable development rather than short-term profits. They are the checks and balances that are put in place. So either 1/3 of your board, and that is a significant number, or half of your board of directors are required to be independent today for all listed companies. Now, what this entails is that you're not just you don't just have directors who have been nominated by the promoter or the controlling shareholder, who basically would toe the line of what the owner wants. These guys are not there to toe anyone's lines. They are to ensure that the public shareholders, because they have a fiduciary responsibility, they ensure that the public shareholders, the small shareholders, the other stakeholders, lenders in the company, they ensure that their interests are also taken care of. Now, recently there has been a change. Now, 75% of the shareholders need to pass a special resolution for the appointment and removal of these directors. Usually, if it's any other kind of director, it only requires a 50% resolution, 50% majority. But in case of independent directors, understanding that it is fraught with more responsibility, you need 75% present in voting to be able to appoint or remove one of these guys. Committees of the board. This is another very, very important development that has happened over the past decade or so in India, is that, there are boards, specialized boards, and these boards are primarily, the majority of these committees should be independent directors. So for instance, there is an audit committee in place which reviews all financial transactions that the company gets into. And this audit committee is comprised with independent directors as a majority. So usually there are 3, out of which 2 end up being independent directors. So these ensure that there is scrutiny in the financial transactions. Another issue that the world has seen ever since the financial crisis is the remuneration of management, for instance. Are you paying too much to management as compared to the money that the company is making? What is the remuneration that would befit a key managerial position goes to the remuneration committee. There are resolutions there, and only then can the remuneration be approved. Another, which I don't speak about here, is a recent development in which the markets regulator in India, SEBI, has come up with, is a risk management committee. Now, the top, I think, 1,000 or 500 companies in India require to have a risk management committee now. Now, obviously, the decisions that a company takes can have wider ramifications for its future. And therefore, it is really important that there is a risk management committee in place which is actually going to evaluate the risks behind every decision, every strategy that a company makes. And this is certainly, in my view, a step in the right direction. Liability of independent directors. Independent directors shall be liable in respect of such acts or omissions or commission by a company which had occurred with their knowledge attributable through board process and their consent or connivance, or where they had not acted diligently. So currently in law, there are provisions which ensures that an independent director is truly independent and does not toe the line of the controlling shareholder. That, to me, is another step in the right direction, because everyone needs to be liable for what they're doing. Whether you're independent, not independent, ultimately you should be answerable to the law. And that's what it does for independent directors. Related party transactions. Now, this is an important topic worldwide. I've practiced in India, I've practiced, I was with an international law firm in London for very many years. I did transactions based out of CIS, based out of the African mining companies, etc. And one way in which profits are actually taken out by the people in control are related party transactions. In India, this is particularly relevant because in Indian corporate history, the owners have always tried to extract the maximum amount of profits from the company. And therefore, it is only fair today that there is a full set of principles that actually govern related party transactions in India. What are they? Firstly, every related party transaction has to go to the audit committee. And, it has to be approved by the audit committee. And in that, only the independent directors are able to vote. So RPTs, you cannot have a related party transaction. This ensures that every RPT is actually at an arm's length and beneficial for the company. Secondly, every related party transaction which is over a certain threshold in terms of turnover of the company, these need to be approved by the board, and if the transactions are of such a material nature based on its turnover, then they would go to the shareholders. And not just that, the persons interested or the controlling majority would not be allowed to vote in these resolutions. This again ensures that related party transactions are for the best of the company, they are at an arm's length, and basically the principles of arm's length transactions are all adhered to. So finally, all material RPTs, which is the last point, is shareholders' resolution, and related parties cannot vote in this is something that goes a long way in ensuring that these transactions are at an arm's length. Now, there is a whole disclosure regime that is carved out today under corporate governance, which ensures that the smaller, so okay, if you're an institutional investor holding a large chunk in the company, you would in all likelihood have a board seat. So you would be clued into every decision that the company makes. Even if you don't have a board seat, you would at least have an observer position in which these people interact with the company to ensure that their stake in the company is not diluted in any way. But what happens for the small shareholders? There is no such board seat, no such information that is going out to them by being part of the management of the company, albeit in a non-executive capacity. The small shareholders don't have that. So how do you ensure that all that is happening within the company is actually reported to the minorities? The way to do it is to have a robust disclosure regime in place that ensures that as soon as a certain decision, material decision is taken at the board, they are immediately, within a period of 30 minutes, disseminated to the public at large through the stock exchange mechanism. This ensures that, you know, when a small shareholder takes an investment decision in either investing in a company or holding on to it or divesting, they get the information as quickly as anyone else to be able to make their investment decisions in the shares or securities of that company. Now, here are some of the examples that you have: acquisitions, issuance of securities, revision in ratings. Revision in ratings is a particularly important one, and there are certain other laws as well that rating agencies need to adhere to, so that every rating that a company gets is disseminated fairly quickly. Now, without getting into the rest, let's move on because we're running out of time here. So, other than that, you have the ICDR regulations in India, which is like the Prospectus and Transparency Directive in the EU, which sets out the rules for disclosure in relation to every capital issuance that a company does, whether it's bonds, it's shares, it's other kind of quasi-hybrid securities. There is a disclosure regime in place in India. Moving on, the last topic before I take questions, the last topic that I want to speak about today is shareholder activism. Now, historically speaking, and having done this practice for a number of years now, I can tell you that historically, the small shareholders, the minorities, even the institutional shareholders at some time, who are you know basically taking a chunk but not really involved in the running of the company, in nominating a director to the board of such companies, these guys would not attend shareholder meetings. At the end of the day, that would enable a guy who has maybe 30%, 35%, 40% stake in the company to push through their resolutions fairly easily. That is not the case anymore. And, you know, while COVID has brought about a whole lot of negative things to all of our lives, the one positive thing that COVID has done for us is ensured that voting on every shareholder resolution today is done not just physically, but virtually. Now, this virtual meeting actually has resulted in a lot more participation by these smaller shareholders in the decision making of a company. And let's see some examples of what has happened. So basically, institutional investors approached NCLT to requisition a shareholders meeting for the removal of the managing director and appointment of 6 independent directors on the board. This is unheard of.
Mr. Kaushik, you have 2 minutes left.
Yeah. So this has not been seen in the past. So today, a small shareholder is taking a much larger role. Let's take Eicher Motors, Hero Corp, Balaji Telefilms, which have actually rejected resolutions for increasing the remuneration of top executives. And lastly, I'll talk about the PNB case in which Carlyle was an investor. They were trying to come in, but due to proper process not being followed in the acquisition was set aside and had to get cancelled. So basically now, and this is based on a complaint made by a shareholder. So today, every small shareholder is actively participating in the strategic decision making of a company. Now, I think that's it from me here. And if there are any questions, I would like to take that now.
Thank you very much, Mr. Kaushik.
Yeah, Kaushik ji.
Should I take that one?
We have 1 minute left. Yes, one question.
Yes, yeah. As you said that actually corporate governance is good. So what I understand is actually today we are speaking of ease of doing business. And I see that in the name of the corporate governance, so a lot of compliances. Okay, so is there any harmony between these compliances and ease of doing business?
So Prashant, right?
Yes.
Oh, hi Prashant. So I think, ease of doing business is extremely important in India, but it is more important that the guy who's coming in and investing in India, his value is not eroded. So if there are any issues, any perceived difficulty in the ease of doing business, let's look at the long run. Let's think about preserving that guy's investment and making it grow in a proper manner, in a structured manner, rather than focus on the ease of doing business. Maybe maybe it does contradict in a certain way.
Thank you very much, Mr. Kaushik.
Thank you very much.
Thank you, gentlemen. We will need 5 chairs, please. All right. Next is our panel discussion on new business models, collaboration between banks and fintechs solving multiple use cases. Our panelists are Felix Bright, Vice President for EIC Corporation. Welcome, Mr. Felix. Mr. Vikram Dugal, Chief Risk Officer at Vance Tech Labs. Welcome. Niraj Gupta, CEO for PoliceBazaar.ae. Sorry, PolicyBazaar.ae. No? Ish Anand, founder, CEO of Your Growth Story, and CEO and country manager of Global Wealth Group. Welcome, sir. And last but not least, Lito Villanueva, Executive VP, Chief Innovation and Inclusion Officer, Digital Enterprise and Innovations Group Head for RCBC. Welcome, gentlemen. So I believe that we can, okay. All right, gentlemen, the timer will be set. Please leave some time for questions from the audience. Thank you.
Ladies and gentlemen, good afternoon. I know it's post-lunch. We've got a third place playoff later on this evening, so I'm sure a lot of you want to go and see it. There are some nice big screens there, so we'll get through this as fast as possible. Since yesterday, all the lawyers I've met, I've said just one thing. The legal people and the financial people, they have to live with each other. They can't live without each other. So It's nice to see a lot of the legal profession here, and I think we work hand in hand. We've got a fantastic panel here. We've got a perspective from 3 different continents. So I think you'll see a host of information being shared, and I hope you can make good use of it. So to start with, Lito. He's from the Philippines. He runs a digital bank. He's part of the team there. Felix is from the Côte d'Ivoire. He's going to share a perspective from Africa. And Vikram here is from India, and he's going to share the perspective from India, what's happening in the fintech space. And my name is Ish Anand. I'm going to be the moderator for this session. So to start off with, let me ask Lito, please give everybody just a 1-minute introduction about yourself.
Okay, thank you. Just to introduce myself, I'm Lito Villanueva. I'm the Executive Vice President and Chief Innovation and Inclusion Officer for RCBC, and concurrently as the Chief Digital Transformation Advisor for the Yuchenko Group of Companies, which is one of the oldest conglomerates in Asia. And also wearing another hat as the chairman of the Fintech Alliance.ph, which is the largest fintech organization or association in the Philippines, and also the global chairman of the Alliance of Digital Finance Associations, which is a South Africa-based, where about 35 member countries are a part of that association. Thank you.
Thanks, Lito. Felix, could I request you to?
Good afternoon. I am Felix Bright. I'm from Côte d'Ivoire. I was raised and born in Côte d'Ivoire. I was educated in France and the USA. I have a background in computer science and business. Today, I'm the Vice President of EIC Corporation, which stands for Eagle Investment Capital Corporation, which is an international organization present in 50 countries with head office in Paris, France, and executive office in Abidjan in Côte d'Ivoire. We are mainly focusing on financial education for the mass, democratization of finance through decentralized finance platforms, and also economic diplomacy to enhance the relationship between businesses and government. Thank you.
Thanks, Felix. Vikram, may I?
Sure, thanks. Good evening, ladies and gentlemen. I am Vikram. I am the Chief Risk Officer for Vance Tech Labs, which is an early stage fintech in India. We are building a global neobank, and I think this is a very pertinent topic, and a pleasure to be here amongst the eminent panelists as well to share my thoughts. I have about 20 years of experience in working in different banking and financial sector industries in India across different banks and in different roles. So pretty happy to be here and share my views. Thank you.
Thanks, Vikram. Briefly about myself, I have about 32 years of experience behind me. I've worked in 5 different continents. I've worked in 6 different industries, which includes fintech, private equity, real estate and infrastructure, hospitality, education, and a 2-time entrepreneur with 1 company going to an IPO. So that's my background. We all know that COVID-19 was a defining moment for humanity, not just a community, but humanity. It was a defining moment for humanity. The way we lived, the way we did things on a day-on-day basis changed. And financial technologies, the way we transacted was no different. Probably financial technologies was one of those things that got hit the hardest. And the way people spent money, the way people transacted in spending money was something that actually changed the way we lived. And this was not just common to one continent or one geography. This happened across the world. So I think we were all impacted. There was all something in common that all of us focused on. COVID-19 could also be called a blessing for the fintech space. Why? Because if COVID-19 had not hit, we would not be talking about the kind of fintech that we're talking today. And India is one of those countries that has taken a lead in the fintech space. Today, financial technologies and penetration in the fintech space is probably the highest in India. However, that doesn't change what we do and integrate or how we integrate with the global scenario. So let's just look at some figures. I just want to give you a couple of figures to think of, because finance and data, if you don't marry the two of them, doesn't work. So, data shows that 60% of businesses would face closure if not for the changing scenario in the financial services space. So this is something that we just really need to keep at the back of our minds. And this is something that is driving growth. It's spurring on growth. It's something that has changed the way people live. There's been tremendous amount of innovation in business models. Take a look at India, for example. We have, for those of you who are familiar with payment systems, we have RuPay, we have the UPI system, which is now becoming a global phenomena. And we have a number of other innovations that have come about in the Indian fintech space, which if I were to go into, we'd spend the next 2 hours talking about. So, having said that, let me just hand over to Vikram to start with. Vikram, do you want to touch on the Indian scenario a little bit and tell us about what your thoughts are on some of the innovations that have happened in the Indian fintech system? It's also important to note that India being a huge country and one that is extremely diverse, there are two extremes in terms of the financial disparity. So it's also very important to note that what the top end of the spectrum uses may not be the same as what the bottom end of the spectrum uses. So Vikram, please touch on some of these, and then we'll go over to our next panelist.
Sure, thanks. I think, as you rightly mentioned, last 5 years have been tremendous for the fintech growth in India, and COVID has definitely, been a panacea, if I would say that, for the fintech industry. Now, coming to Indian ecosystem, I think a couple of things which have happened, which has really propelled the growth of fintech in that economy is, one, the government support. I think the ecosystem, which is supported by the government, is phenomenal. There have been, I would say, a lot of digital innovation push by the government in India. You look at the India stack in terms of, the GST portals, the income tax portals, all getting digitized. And the ecosystem which have been created by Aadhaar, which is a biometric authentication platform, which basically provides the KYC journey entirely digitally. So there is no manual paperwork which is required for anybody in India to open a bank account or any kind of an account, or even do a KYC there.
By the way, if I may just interrupt you for a minute, this is the largest such platform of its kind in the world. So, a few years back, probably 10 years ago, who would have thought that India would develop a system which was so huge and humongous in nature? And it's becoming like one national ID card where all the services that you want to load onto this card, and for a country of 1.4 billion people to implement this, I'm sure all of you would agree it's not an easy task, but it's been done. So, we're proud of it, and I think it's an example which a number of other countries are also looking at picking up from us. And the same goes, just to kind of add on to this. During COVID, we developed a system to record vaccinations, to see how the spread of vaccination is happening in India. That system was one of its kind in the world, and a number of other countries. I know for a fact that Australia's trying to pick it up. A few other countries I know in the Middle East, a couple in Europe. So you may want to also dwell on that a little bit, Vikram.
No, absolutely. So as I mentioned, obviously to start with, it was government ecosystems which really pushed the growth, and the fintechs obviously started to innovate ideas how we can leverage the government infrastructure, be it the Aadhaar databases or the income tax and the GST portals, to collect information about the individual and making the journey or the customer experience seamless for the people. Now, in terms of other use cases, obviously, if I talk about fintechs broadly in India, there are multiple use cases which the fintechs are solving. Payments is one of the biggest. Now we are getting into the cross-border payment space as well, which till date has not been innovative enough. I think we still depend on legacy infrastructures of SWIFT payments, which are archaic in nature, and now there are a lot of innovations happening in that payment space as well. Lending is another big use case. I would say the entire customer onboarding journey, right from doing the KYCs to the alternate underwriting algorithms to assess credit worthiness, and even managing the collections bit digitally. So there has been a lot of innovation in that space where new business models have been created. And even just last comment would be on the wealth management space, how fintechs are solving for personal financial management, customized offerings for clients, HNIs, and tailoring their needs to kind of invest in stocks, bonds, even locally as well as globally. So I think those are multiple use cases which I can recall in India.
Thank you very much, Vikram. Felix, over to you.
Thank you, Anand. Before I go into some of the use cases in the fintech space in Africa, I want to ask a simple question. How many of you have been traveling to West Africa? 1, 2. Okay, so I owe it to myself to give you some data, some key data, because it's important to share where we come from. So, as I said before, I'm from Côte d'Ivoire. Côte d'Ivoire is a French-speaking country on the west coast of Africa, okay, with the neighboring country being Ghana, Togo, Burkina Faso, and Mali on the north. Côte d'Ivoire's population is about 30 million people, but you'll be surprised to know that the banking rate in Côte d'Ivoire is less than 20%. So only 1 out of 5 people in Côte d'Ivoire has a bank account. But guess what? On the other side, 23 million people out of 30 has a mobile phone and have subscribed to a mobile money application. So this is to tell you the opportunities that we've been uncovering using the mobile technology. But Côte d'Ivoire is also part of a region, which is the West Africa Economic Monetary Union, which is 8 countries in West Africa. And those 8 countries share a single currency, which is the CFA franc, pegged to the euro. Okay, this is for the region. But for your general information, Africa, in terms of population, is about 1.4 billion people. 1.4 billion. If we take the West Coast, our region, we are close to 300 million people. Okay, so opportunities in this fintech space for us is mainly to drive the usage of mobile phones to facilitate the access to financial services, to loans, and to capital funds, capital raising. Because the majority of people and businesses have difficulty to access the banking system. So amongst the use cases which I want you to talk about briefly, the one is, which is now coming very strong, is a mobile application using a credit scoring scheme which allows people to basically receive microloans instantly in less than 2 minutes using different algorithms. This particular platform, within 12 months to 18 months of existence, has already 2 million people. Okay, so this is very important to note. Okay, we also have the majority of fintechs involving in the P2P transfers solutions, okay, for utility bills payments, for salaries payments, and other type of payments, even pension funds payments, because as I mentioned before, because of the lower banking rate, lots of people don't have the bank account, so they will receive their salaries or their pension fund on the mobile phone. Okay, so I want to stop there for now.
Felix, thanks. Just one comment. I don't know how many of you know, but Felix, please correct me if I'm wrong. Africa had mobile wallets much before many, many other advanced or developed countries in the world. Is that correct?
That's correct. And I can give you a figure that Africa is responsible for 45.6% of mobile money transactions in the world.
Wow, that's, I mean, we all think that, only one part of the world is growing or is advancing down the technology way, but, this was a data point that I stumbled on just by chance. Africa started mobile wallets long before
well,
we
actually, on the contrary.
Yeah.
I just would like to correct that one because Philippines was the pioneer in mobile money. It was actually smart money that was founded in year 2000. M-Pesa was founded in 2004.
Fantastic.
So that was actually just to correct, to make it factual.
I stand corrected.
Because the mobile money regulation actually came out from the Philippines, and that became the model across the world. In fact, even Bangladesh Bank, and even Pakistan, State Bank of Pakistan, and the regulators coming from African region were also present or visited Philippines on the best practices insofar as mobile money regulations are concerned. But having said that, I just would like to to drill down on the topic assigned to us on the collaboration between banks and fintechs insofar as solving multiple use cases. Because in my case, I'm wearing a hat as a banker at the same time as a fintech practitioner as well, because I also started Smart Money in the Philippines, and from a fintech world, I'm now with a bank. And it's more of how you could now do the fusion between banks and fintechs, and I call that bank techs, or neobanks or challenger banks, or even digital banks. So it's more on how banks are now working closely or collaborating closely with all fintech players in practically in the whole world, because no single universal or commercial bank in the world right now who would not be collaborating with a fintech player, because fintechs or platforms of fintechs are practically there's a surplus of solutions out there. So because banks would no longer have to come up with their own hiring of talents in terms of developers or tech people or IT guys for them to develop their own platforms. It's a matter of how they will now be able to collaborate with these fintech players. Because one of the things that I would want to highlight here is that to the point made a while ago, COVID-19 really was practically there's a silver lining in the COVID-19 global health pandemic or global health crisis, because we have seen, not just in Africa, but practically across the world, the exponential growth of digital financial transactions in the whole world, especially in Asia Pacific, for example, where we have seen also the resurgence or the influx of digital banking, digital bank licensing framework. We have also seen a surge of this regulatory or enabling regulatory framework pertaining to open open banking or open finance or digital banking licensing, or even the lack or the absence or even the lack of it insofar as regulating digital assets. We've seen how FTX, collapsed and also be able and made make this Hollywood or sports celebrities accountable for even endorsing FTX, right? And in fact, other regulators in the world are now in a quandary as to how they will be able to regulate digital assets providers, such as, for example, Binance, which is practically all over the world. Because, beyond this topic about collaboration between banks and fintechs is on how to protect the consumers, right? Because it boils down to one thing, consumer protection, while at the same time having to provide or promote inclusive digital finance amongst peoples in the world. So the thing here is that there should be a striking balance between, good thing that there is law component in this particular conference and finance on the other hand, because for example, in the earlier topic a while ago, is IP laws, are IP laws relevant now, or what do you call this, at par with advances in technology such as AI? I mean, the question on how IP laws would be able to address the likes of, say, NFTs, for example, on how we could provide, embedded finance and be able, and who will be the one responsible? Is it the bank providing the services, or the one, or the platform providers providing that service to the bank? Right? So, I mean, those are the key questions that would also be tackled or are being discussed in several fora. And I think these are some of the relevant points that must be considered insofar as how we are really integrating our services between practically, that's why it's not only fintechs, but the likes of insurtech, wealth tech, regtech, souptech, all the techs of this world, right? So in fact, this is not just about banking and finance, because digitalization or digital transformation goes beyond the banking and finance sector. It actually cuts across all industries and sectors. Thank you.
Thanks, Lito. So just some, I'm going to throw some data points and I'm going to ask you all to comment on those. Digital banks, very interesting figure. 14.2 million US citizens, digital banking is the only form of money transactions that they conduct. And that's 6% of the adult population. And it's increasing all the time. Digitalization of brick and mortar banks. I think a lot of banks are now going the digital way in order to survive. A lot of them are very, very concerned about their survival. That's something that's, it's a striking feature. Banks used to have a monopoly at one time. I mean, if you didn't go into a bank, there was a problem, because there was no other way you could get money. Just another figure on this is in 2020, UK-based TSB announced that it will close 160 branches. The Irish AIB announced it would close, cut 1,500 jobs. Commerzbank in Germany announced that it would close over 340 branches in the next few years. So those figures are fairly large. So there is a change towards the digital banking space. Banks are beginning to realize connectivity is beginning to catch up. Also, investment in digital is growing tremendously. 34% of banks across the world have announced tremendous increases in their digital spending. So, gentlemen, Lito, maybe we start with you this time. Just some comments on this.
Yes, actually, just to further amplify that point that you made, I mean, just to give you a classic example, or this is actually the RCBC case, right? Prior to the pandemic in 2018, RCBC ranked 8th amongst private universal banks in the Philippines in terms of assets. But fast forward to 2020, because of digitalization, remember, RCBC is a 62-year-old legacy bank. Because of digital transformation, we were able to now rank 6th from 8th in a matter of 2 years, and we'll be able to rank number 4 in a matter of another, by next year. That's in the growth of about 88% year on year, and exponential, exponential growth in terms of gross transaction value, and year on year growth in terms of net income at 88%. And with that point that you mentioned on the investments of entities into a local bank, for example, that is really into massive digitalization. Say the biggest investment made by Sumitomo SMBC into a Philippine bank happened about a month ago, which is about $425 million US. That represents about 15% additional equity, making their equity into RCBC at 20%. But this is actually because of digitalization that happened or that is still happening in the bank, because that is the way forward, is the way to go, because it's a matter of surviving and thriving amidst massive digitalization.
Thanks a lot, Lito. What are your thoughts about this in Africa?
Yes, I like when you're saying surviving. It's a matter of survival. Today, for banks to survive on the African continent, they will have to go digital, okay? And the fintechs are bringing, in fact, a new untapped market, okay? If I take the case of Côte d'Ivoire, okay, which you may know, which is the world's first producer of cocoa, okay, with over 2 million tons. We have over 1 million farmers, okay, working in those cocoa plantations. And those 1 million farmers, they impact the lives of over 5 million, probably 10 million people. So you could imagine a third of the population in the country, in Côte d'Ivoire, is impacted by the cocoa. So we are building a new business model, okay, which in fact, will be an ecosystem, a digital ecosystem, to capture the entire value chain, okay, for the cocoa supply chain from the farm all the way to the local market or international market. And we have a project currently under EIC Corporation where we are developing a blockchain-based solution to actually put in contact farmers, cocoa production companies with either local buyers or international buyers. So this is where we are taking the business model.
Thanks, Felix. Do you want to go ahead?
Yeah. So, I have been a banker myself for the last 18 years. Last couple of years, I have been in the fintech space. In last 20 years, the banking industry itself in India has undergone major transformation. I have seen times where, people, even 2 branches of a bank were not connected. And if a customer of one branch wanted to go to a different branch to, withdraw money, there used to be a telegraphic transfer which was done by one branch to the other so that he can receive the money. And see, today in India, we have gone through the era of internet banking, then mobile banking. ATMs came much earlier than that. So it has been phenomenal. But for the last 5 years, fintech is taking this to a next level altogether. And I'll come to I'll take a step back and just address a problem, when we are talking of the topic, banks and fintech collaboration. I think traditionally, with all due respect to all the banks, there has been a mindset resistance also from big banks. Banks have always thought about that they have built a large franchisee of customers, and banking is obviously trust-based, right, which is very hard to replicate, even for a fintech, right, or any kind of a new organization. And with this mindset, the innovation was never a priority for legacy banks. They were running on legacy infrastructures, and they were never thinking of customer-first approach. And this is what changed in the last, 5 years or so, at least in India, where I've seen a lot of emphasis on unbundling the banking services, taking a particular use case, and the fintechs really doing it well. It could be a digital KYC journey, a good experience for the customer in terms of onboarding. It could be a fulfillment of a loan or a credit. it could be an alternate credit underwriting algorithm, right? Where, you know, you are not asking sheets and sheets of financial data of the customer, but you know the customer through different alternate data points, right? So, and you know, I would say that it's not the challenge or loss of a bank. I think today we are in a situation where we need to find a sweet spot of banks and fintechs coming together and collaborating and really making a good business use case to profit from the business model, right? I think Lito made a very relevant point that for banks, they have more to protect than to gain in this kind of a relationship, right? Because of customer privacy, customer data, customer protection laws, even regulatory compliances, right? And now the thought process from the fintechs is also changing. I have, just recently heard about the VCs who are putting money in the fintechs. Earlier, it was all about customer acquisition, growth, showing the numbers. However, with the recent episodes which we have seen both in the crypto world as well as other spaces, I think there's a lot of focus on from the VCs who are putting money in the fintechs about compliances, profitability, bottom line. So the thought process is changing, and it's again going back to the same thing, how do we find a sweet spot where both banks and fintechs can come together and really take it forward? Because fintechs solve for innovation, for efficiencies, for customer experience, and obviously they gain more franchisee and trust partnering with the bank, whereas bank obviously gains in terms of extending their reach and getting to financial inclusion kind of goals as well.
Thanks, Vikram. Thanks. Couple of more things. I think we've done a discussion on this yesterday. Everybody loves to talk about crypto. And when you talk fintech, you can't miss out on crypto. So Lito, let's start with you. What are your thoughts? I'll just give you one set of figures. I was just checking out, Bitcoin saw a high of, what, $67,000 US in November of 2021. Now, that figure is quite staggering, yeah? And Tesla bought $1.5 billion worth of Bitcoin last year. So, just some comments on that. What are your thoughts?
I'm also a columnist in the business section of the Philippine Star. That's the major daily in the Philippines. And in fact, I wrote a series of articles about crypto and the collapse of FTX and how the crypto world, insofar as managing it in a wild west scenario, on how you could best protect the consumers is still a major issue. So, but I think to your point, the question would be, would crypto, after the FTX debacle, would it be still the same crypto as we see it now, and as we saw it before? I think yes, but the thing is that if you are to look at statistics now, a lot of people are really into crypto, but the problem is regulators are not really monitoring or are practically not within the radar of the regulatory perspective. But just case in point, in the Philippines, about 10% of the inward remittance volume coming to the Philippines in a matter of 3 years is now about 10%. Filipinos who are living overseas or working overseas are now remitting funds into the Philippines via crypto. And it grew by as much as 10% in a matter of 3 years. So imagine that is only inward remittance volume, but in a matter of 3 years. But definitely, the scale by which crypto is growing by leaps and bounds will definitely be something of significant value and impact, not in various markets or various jurisdictions. And I think the main issue right now is on how regulators will be able to finally, hopefully, eventually, and very soon, that they'll be able to come to particular point where they will be having a united stand in terms of having a standard in regulating the crypto players out there.
Gentlemen,
Thanks.
5 minutes left if you'd like to take questions from the audience.
Sure, just give us 2 minutes. We need
Yeah.
touch on this in Africa
please.
a little bit.
Yes, as a former banker, definitely I'm not into speculation, okay? But talking about the crypto, we have a use case in West Africa because, as you know, Africa is 55 countries, 41 currencies. So how do you settle and how you clear 41 currencies across the continent, okay? So one solution is to use a crypto asset. I don't know if I should name it, okay? But we have a crypto asset which we use to do the settlement between various currencies across the continent. And it's working very well, which means today you could send money from Cote d'Ivoire to Kenya, from Kenya to Ghana, instantly, as opposed to 3 or 4 days a few years ago.
Thank you, thank you. You want to touch on this very quickly, Vikram?
Yeah, so I think it's a double-edged sword, I would say. India has about $6 billion of investment in crypto assets. We have seen significant decline in volumes over the last week or so due to the FTX episode, which you all know. So obviously there are regulatory issues. There are pressures from, and specifically in India, RBI is definitely worried about crypto investments. There are tight regulations in India, and it's not accepted as a medium of exchange at this point in time. There are taxes on it. So, but there are use cases, right? And we as a fintech are also evaluating, as Lito mentioned, crypto could be a very good use case for cross-border payments, which is already there in the market. So basically, it's about the underlying value, right? I mean, crypto, if it has an underlying value which is tied to a fiat money or a commodity like gold or any kind of, where it derives its value, I think there are use cases. But, other use cases are real
I
speculation.
think it's about regulation following innovation.
Absolutely,
Yes.
absolutely.
Yeah. Thanks, Vikram. So just 2 lines of wrap up, and then we'll have a couple of questions. So, fintech is such a large space. There are many more use cases. There are AI and ML use cases. There's lending. There is accessibility to financial literacy. That's a huge issue. There is, and that's a totally different topic for discussion. Financial literacy in most parts of the world is extremely underserved for the time being. So I think, there are payment systems, there are various other things. So I think having said that, I'd like to thank Lito, Felix, and Vikram, for an engaging discussion. Can I open out the panel to, please? I was hoping you'd come up first. I was really hoping you'd come up first.
Yeah, thank you. Because, this is another topic close to my heart. The way I see fintech as a disruptor for traditional banking, okay? So the question, wouldn't it be considered as a real threat to the throne of traditional banking? And how do you see this actually real working in cross-border transactions? Or at the end of the day, that will be considered some sort of a transformation between traditional banking towards new digital, fully digital or virtual banking in the sphere of new era, actually, of implementing especially cryptocurrency and other stuff that will change the rule of the game in terms of new concept of digital banking transition.
Sure. So I'll just make one comment, and then, I'll request Lito and,
We have 30 seconds left, gentlemen. One answer,
Yeah,
please.
yeah.
Thank you.
Thank you. Just one question. So just to give you a very brief answer, fintech has to be looked at methodology or a medium to bring in financial inclusion for a larger population. That's the only comment I'll make. I won't make any other comment. Gentlemen, if any one of you wants to make one single...
Thank you very much, gentlemen. Thank you.
Yeah?
Fantastic panel. Please, warm hand of applause for this panel discussion. Thank you very much. My apologies, gentlemen. We need to remain respectful to future panelists. Absolutely. Yes, sir. Can you write it, please? Can you please come? Professor Abdul Rahman? Oh, no, no. Is he here? Thank you very much, gentlemen. And now we shall move on to the honoring of our awardees in our awards ceremony. I'll take the mic. I would now like to call upon Professor Dr. Abdul Rahman Ahmed Omer of Burjeel Hospital to join me on stage to present the awards. Dr. Ahmed. All right. Welcome again. Welcome back. Would you like to? Good. Okay. And so let us commence this awards ceremony. And our first award will be going to Dr. Fawaz Alami. Congratulations, Doctor.
I would like to thank the conference. I would like to thank you for attending the conference. But mainly I would like to thank my wife who is sitting here. She is a great educator and a superb manager. She managed me for the last 52 years to get this award. Thank you.
Thank you, Dr. Alami. Our next award recipient is Edith Norman. Come on up, Edith. Congratulations.
Ladies and gentlemen, it's an honor and a pleasure to be here. I would like to thank the fine ladies and gentlemen who are organizing this conference today for bringing us together here, because we're talking about AI and all technical things. But we came to the conclusion, and I share that it's all about people being together, and meeting you is also one of the achievements that the conference did. And I hope to be in touch with you after the conference as well, because this is also the way that we pay our experience forward to the next generation. And that's something that I really share with you all, and looking forward to doing that. Of course, at the same time, thanking our families for supporting us, because we have even heard that people are here on their honeymoon. So as lawyers, we tend to work a lot, and our families cope with that and accept us as we are. So very thankful for that, for the team, and thanks to you all.
Thank you, Edith. Next awardee is Mr. Roar Thunweger. Roar, welcome, sir.
I would like to say thank you. Thank you to some of the elements that Edith just said, and I would like to connect them to three words: people, connecting, and communication. And what we have been able to do here the last 3 days is to connect with knowledgeable people. And then part of them I would like to honor this award to is, first of all, my family. It's also many of our trainers and mentors that I've had, and also a lot of the past and present colleagues, and among them also our clients. So with the people we are connecting, and this is a great opportunity to connect. And what we do then is communicating, and communication is negotiations. So thank you again.
Thank you, Ms. Rieger. Our next recipient is Sunita Sridharan. Come on up, Sunita. Congratulations.
Hello, good evening, everyone. Ms. Sunita is not here, so I accept this award on behalf of her. I would like to dedicate this award to all the team members of SKS Law Associates. Thank you. It's an honor to be along with you eminent personalities. Thank you so much.
Thank you very much. Next up is Harshita Kumar. Congratulations.
Good evening, ladies and gentlemen. I would like to dedicate this award to my team back home, Atlantic Law Associates, to my colleague and friend Sakshi. There are a couple of people I would like to thank. Most importantly, my husband. He's here with me for the conference, the man who actually steers my life in the right direction. Thank you so much for being here. my parents and my family-in-law back home for their constant support and love to me and my career, my sister for her undying faith in me, and the magician of our lives, Anadi. Thank you so much, and good evening, ladies and gentlemen, once again. Thank you.
Beautiful words of thanks. Okay, next we have an award for David Lagziel. Welcome, David. Congratulations.
I will do it quickly. Thank you very much for my family, my partner, my team that bring the ODR to this kind of level, and thank you very much.
Thank you, David. Our next awardee is Kanchan Tareja. Congratulations, Advocate Kanchan.
Hi everyone, good evening. We all can agree that the last 3 years have been very difficult for us because of the pandemic. While other sectors like the healthcare sector, the online delivery service, and our security services have fought the battle, so have we, the legal fraternity, by making radical transformation to bringing justice to the doorsteps. Today I take the opportunity to thank each and everyone out here to make this possible and a vow to do better. Last but not the least, I'd like to thank my husband, my parents and my children, my team back home, who have been a big support in my professional journey. Thank you.
Thank you, Kanchan. Next award will be going to Kaushik Mukherjee. Come on up, Mr. Kaushik. Congratulations.
So I think I've said far too much already in this conference, so I'll just say thanks to one and all.
Thank you, Kaushik. All right, a few more awards to go. This one will go to Ratvik Patel. Congratulations, Mr. Ratvik.
came for this event, I came with a limited understanding, and when I'm flying back to home, I'm going with ocean of knowledge. So thank you, all of you. So it's a knowledgeable community, and gathering itself is important, so I appreciate and I sincerely communicate my thanks to the organizer. Thank you so much. Thank you once again.
Thank you, Mr. Patel. It is indeed a fantastic platform for the sharing of knowledge. All right, our next award is for Isla and Claw Advocates. Congratulations, Isla and Claw.
Thank you, Lord 2.0, for this recognition. I'm taking this award on behalf of ILAC Law, and this is dedicated to the team. Thank you.
Thank you, sir, on behalf of your team. All right, next we have an award for Mr. Lito Villanueva. Come on up, Mr. Lito.
Allow me to express my gratitude to the organizers of Money 2.0. And of course, this Outstanding Leadership Award will not be possible without the women and men of RCBC and the people of, in the Philippines, whose practically RCBC is a 62-year-old traditional bank that has now become the undisputed #1 challenger bank in the Philippines, and thanks to digitalization. And two things. It's about winning together and, of course, our innovations with empathy. RCBC for the past 3 years has been awarded the Philippines Best Bank for Digital by Asia Money, and winning the back-to-back recognition by the Asian Banker as having the best financial inclusion app in the Philippines, which is called Discartech. And with this, thank you so much, and again, congratulations to my co-winners and co-awardees. Thank you.
Thank you, Mr. Villanueva. Next up, we have an award for Amir Tabksh. Congratulations, Amir. I guess we will hold on to Mr. Amir's award. Okay. Our next award will go to FidiPay for Outstanding Organization Award. Come on up, the whole team at FidiPay. Congratulations.
I would like to say thank you, Money 2.0 and entire team of FidiPay. Thanks for this award. Thank you.
Thank you, Felipe, and congratulations. All right. Our next award will go to Rajamani Gopalkrishnan. Congratulations. Come on up, Mr. Rajamani.
Good evening, everyone. I think it's a pleasure to receive this award, and I would like to thank the Money 2.0 team, the selection committee, and all the people who are here, okay, because it would not have been possible, attending a conference, I think after 3 years, so, and then getting recognized, it's really great. And I would also like to dedicate this award to my parents, including my late father, who's been very supportive. And I think he will be seeing from up and blessing me on this. And my wife, my children, my colleagues, and mentors and coach, who have been always uplifting me when things were going down the valley. So that is where they helped me to come up and keep on going on. So that is where I would like to thank. And I would like to quote from my coach, John C. Maxwell, who's been my leadership coach. And he always say, leaders are not great because of their powers, but they are great because they empower others to influence many. And I think we are in the right team here. Thank you.
Well said. Thank you, Mr. Rajamani. Our next awardee is Kenji Ijima.
Thank you very much, everyone here and the organizer. I belong to the one of the largest insurance group in the world, named MS&AD, based in Tokyo. And I myself is based in Tel Aviv, Israel, and heading my team to conduct the business development in collaboration with the business partners, startups, and the accelerators, etc., through the innovation. And by the implementing or their technology or the solutions into our operations, which is not in the Japan, but also the more than 40 countries in the world where we have run insurance businesses. So what I believe is that the innovation always involves the various kinds of the technologies. However, at the same time, I believe that the more important thing is how can we transform the culture and the mindset of the people by having the strong leaderships. So from this point of view, these awards encouraged me a lot. And let me continue to make extra efforts to make the world more safety and secure. Thank you very much.
Absolutely, the culture and the mindset at the foundation. Our next awardee is Nisarg. Congratulations, Nisarg.
thank you, everyone. Very good afternoon. And apart from everything that's been said about the conference, I think the most wonderful part I found is the ability of the organizers to bring in people from so many different countries into Dubai, which we always like to call as a melting pot of cultures. So everyone who has traveled from outside, ahlan wa sahlan and welcome to Dubai. I just want to say thank you for considering me in this august gathering of lawyers, a corporate finance professional. So thank you so much for the recognition. To my team, which motivates me to come in each day and do better. My partners in the firm who've been with me in this entrepreneurial journey throughout and from whom I've learned a lot. My parents who pushed me to move to Dubai from India more than 19 years back. And with their blessings, here I am. And of course, most importantly, my girlfriend and my wife. Just to clarify, it's the same person. She's watching it live on YouTube, so I just don't want any misunderstandings. She's been with me for the past 24 years, watched me from a young college-going, aspiring chartered accountant to where I stand today, has been with me through thick and thin. So I thank her for being part of this journey. And she still feels I can do better as a professional each day. So thank you for pushing me in this journey. And lastly, I just want to leave you all with a very small thought. My guru, who only gave me 2 teachings, very simple teachings, faith and patience. That's what I have built this business on. We operate in more than 15 countries, raising capital for companies across the globe, including many countries in Africa. And I would love to have a chat with you sometime soon. It's the blessings of the Guru with which I'm here. He's the designer and director of this journey. I'm just playing my part. Yeah? Thank you so much. Thank you so much.
Thank you very much, sir. That was funny. That was a good one. Strength and patience, everyone. And our last awardee is for Mr. Senthil Kumar. Come on up, Senthil. Congratulations.
Hi, everyone. Very good evening. First of all, I would like to thank the organizing committee for the 2.0. It's a wonderful way of organizing this. Connecting people is key, and bringing the like mindset, sharing the knowledge, and sharing the experience with the innovative leaders, influencers. It's a key to take our journey to the next stage. So on this moment, I thank dedicate this award to my parents, especially my mother, and who pushed me always in various hurdles. And without my mother, I can't stand here. So I'd like to dedicate this award to my mother, and always my mentors as well, across the globe, in Australia and US as well. So I learned a lot, the empathy and the honest and sincerity. So that helps me to be here. I would like to continue the same thing to next generation as well. How we can build the mindset and culture. My friend, a fellow from Japan, already explained that. So that's really important. And thank you so much for this opportunity. I am really thrilled and honored and happy to take this back to home. Thank you so much. Yeah. Thank you. Yeah. Thank you.
Thank you very much, Mr. Senthil. And thank you to Professor Dr. Abdurrahman. It is an honor to have you on stage with me. Thank you very much once again.
Thank you very much.
Thank you. Congratulations to all the awardees. Give yourselves a warm hand of applause. You clearly have deserved it. Congratulations once again. All right, before we end day 2 of this conference, we have our final fireside chat. Research suggests that proper domestic violence legislation has a massive impact on lowering instances of such cases. What else can the legal sector do to address the problem of domestic violence against women around the world? Speakers in this session will look at the possible answers as we bring to light this extremely important topic, breaking the silence, why the legal world must talk about domestic violence. Please welcome Advocate Chanchan Tareja, Senior Counsel at Advocate Chanchan Tareja and Associates. Welcome back, Miss. And Aliyah Alzira, lawyer and founder of Aliyah Alzira Lawyer and Legal Services, to open the discussion. Ladies.
Hello. Hi, good evening. So I'm back here again. Today, at the end of day 2, we're discussing a very sensitive subject, domestic violence. Breaking the silence, the first step towards fighting violence. With 15 years of experience in the industry, this subject is very close to my heart. I have had several clients who have been victims of domestic violence at the hands of their spouses, their partners, their live-in relationships, even the extended families of their partners. Hence today, I would like to break the silence, play my little role as a lawyer, as an officer of the court, as the Minister of Justice. Take the first step. Over to you, Alia.
Hi. Hello, everyone. First of all, I would love to break the ice. It's the first time for me in a panel discussion, and I wish it's not the last time. Well, today I'm here not as a lawyer. Today I'm here because we can see around us and all over the world domestic violence against women and the children. And we need to shout out so everyone can hear. When I say all over the world, I mean it. I don't mean only in the GCC or Arab countries, but all the world. So, what do you think?
Oh, yes. With the pandemic, with the surge in technology, we've also had a surge in domestic violence cases. Women have suffered at the hands of their spouses. But my question is, have men not suffered too? Has there been no violence against men behind closed doors? We would like to get the opinion from various lawyers sitting out here from different parts of the country. Hence, we thought of making this more of a chat, interactive session than a panel of discussion like we've had all day round today. Right, Alia?
Yes, we decided to make it a friendly chat, but the most important thing, we need your opinion as well, if you agree or disagree with us.
So while there are several laws in place against domestic violence against women, are there any laws in place for men who suffer from domestic violence? I've had several cases in my experience where men have suffered but are not ready to talk about it. Why so? Is it the society pressure? Is it that they're told, man up, deal with it, go home, it's fine? It's repeated abuse on a daily basis, which not only endangers their lives, but also their self-confidence, their respect, their quality of living. It affects the respect that the children hold in their eyes for their father.
I think most of the victims are the women and the children, because most of the women which is not independent and not working, they are weak, and so they have no option to keep be silent and accept what's going on, or maybe of the religion or the mentality or traditional things which they use to it. And also, I think because they don't have awareness of the law, of the organization, and no one support around. All of us involved in these things, I think. All of us have to help to whenever we see something wrong. All of us, we have to ask them, how can I help? If we hear anything out the door or on the road or anything. United Nations report on in 2021 only, which is in Corona, was 45,000 women or lady dead from their partner or one of the family, which means every hour 5 women are killing, which means each 11 minutes, one is dead. So it's a huge number. This is which is from United Nations. What about the others which we don't know about, right?
Absolutely. When we're talking of statistics, we talk of statistics of domestic violence against men. In America, 1 out of every 9 male is subject to domestic violence. Whereas in UK, it's 2 out of every 5. In a country like India, it's 51% of the entire male population that are subject to domestic violence. What are we doing here? If the same violence continued on the streets, if we saw violence on a daily basis on the streets, would the public not send out an uproar? Would it not make headlines? Wouldn't the perpetrators be punished? Why are these episodes of violence which are being done on a daily basis behind closed doors not reported?
Yeah, I believe as a lawyer, yes, there is a lot of change or update in the law. But the most important thing, there is no awareness or no one is helping or involving because they are not taking the case seriously. Am I right?
Absolutely. On a daily basis, we stop our children at home from playing violent video games, watching violent movies. But do we even think once when they are exposed daily on a daily basis, they're exposed to violence at home among family members? Are we thinking about that?
Yeah, and which make me shocked that not only Arab country or Asian, even Europe, which they are very strict in rules and there's a lot of organization and a lot of places will help them, but still they are in silent. I don't know why.
In a country like India, for a man to report or file a complaint against domestic abuse that he has experienced is almost next to impossible. He has no option but to knock at the doors of the court, and it takes him years to get about any orders in his favor. That is the case in our country. Would anyone want to talk about their country and what are the domestic laws put in place to protect women as well as men?
I think even by law, there is by law again violence against women. I mean, in all over, even in the work, even at home for the woman. And still, I mean, for example, here in Arab countries, if a woman wants to get divorced, she involved in a lot of complicated cases till she can, if she can get the divorce from the man, regardless, the religion is giving to her so easy and very complicated, and she have to run after the lawyer to open 5, 6, 7 cases, will stay more than 1 or 2 years. One of the strangest case which come to me in my law firm, one of my clients, you know, we are as a Muslim not allowed to have to have a baby without marriage. And one of the weird thing that my client was above 40 years, and in the systems written she is not married, which is not allowed in our religion, of course. And her son is around 11 years, because kind of, how can I call it? It's not a marriage, because there is few things every day they create a new kind of marriage which is not related to the religion or something. And she was running more than 11 years just to prove that this boy is her son and she's the mother. Till today she cannot. And till today there is no official relationship between her and this son, and the dad can take it anytime. So I think this is, for us, is very weird. What do you think? What about you?
We as a society need to accept domestic violence is happening, and it's happening on a daily basis behind closed doors. What is domestic violence? It does not limit itself to physical violence. It is emotional violence. It is narcissist behavior, which one partner puts his other partner to. It is that behavior that condemns his partner on a daily basis. Body shaming, putting the partner down, mistreating the partner and the partner's family. All of this encompasses domestic violence. We, as lawyers, ministers of justice, need to speak out, need to encourage the victims to come up and report it so that the perpetrators stop. Our families and friends who are aware of any victim going through such domestic violence, it is important we speak on behalf of them. Encourage the victims. Do not condemn them. Let them come up and file a complaint.
I think all of us, not just the lawyer, anyone here, anyone have the right in all over the world to be safe, and anyone supposed to help the other when they see or they think they need a help. And
fair enough. So our goal here is to encourage people to break the silence and bring up such reports so that the society accepts that there is violence against women, but there is also violence against men behind closed doors, which needs to be reported. Anyone here who would like to talk about the subject, would like to give their opinion as to how it is dealt with in their country, are welcome.
go ahead, please.
Good evening, everyone. My name is Aya. I'm a lawyer, and I have my own law firm back in Egypt. It's called Solid Law Firm. Actually, I myself was a victim of domestic violence. My husband used to do the things you were talking about. But because I'm a lawyer, I had the guts and I had the courage to file lawsuits. I had to file 5 lawsuits in order to get expenses for my children, because I have 2 children, 8 years old and 5 years old. I had to pay for more than 1 year all the expenses, the school expenses, the living expenses, and everything. Actually, he was convicted and he was forced to pay 500 pounds, which is like, I don't know, $1 is 24 Egyptian pounds now. But he was never put to jail because of the domestic violence. And still, I cannot get a penny from him for my kids and for my children. Well, I'm a lawyer. I filed the lawsuits, but I'm still waiting, and it's taking quite some time. And I'm encouraging everyone, including my friends, including my family, to speak up. And if you're facing violence, do not be silent. I'm not ashamed to say that I was a victim, but now I'm free of all what happened. I'm starting over again, but I've been through a lot. Thank you.
I believe 99.9, all of us suffer one day, or we keep suffering every day, not every month, let's say, somewhere or somehow, just because of gender maybe, whatever, regardless, or the religion, or whatever it is, but we need to work a lot on it, to be equal in everything and to respect the woman. And I'm wondering even how it will affect the children. Long-wise, it will be a big effect for the children. They will be a victim as well. So I think all what we need is awareness. We need to help each other and all over the world. Am I right?
And we need to be brave enough to report it and talk about it like she just did. Hats off to you. So, is there anyone else who would like to opine on the subject?
Or want to say something? Go ahead, please.
Thank you. Firstly, I think hats off to Aya. So I think all of us should acknowledge that and give her a big hand. It requires a lot of guts to get up in front of people and talk about it. You know, like all of us know, many of us don't even...
Sorry, we cannot hear you.
You can't hear me. Okay, now can you hear me?
Yes.
Yeah,
please.
many of us don't even dare to talk about it. Getting up in front of a forum is always requires a lot of guts, and I think that's creditable. However, the only thing I would mention here, this is more a societal issue, and it happens in societies across the world. It's to do with your upbringing. I think a lot of it is to do with your upbringing. If your parents give you the right values, they give you the right upbringing, I think a lot of these problems would not occur. So that's my opinion. A lot of people will differ with it, but yeah, I think a lot of it has to do with your culture, with your upbringing. Reporting it is one issue. Fighting to get your rights is another issue. But can we not take one step back and go back and tell our kids so that the next generation doesn't suffer the same issues?
Absolutely. We need to break the pattern at home.
Yeah. I think that's what's more important. The legal part is something that you do as an after effect. Yeah. If you don't take this up at the societal issue, this issue will never get sorted out. It'll become a legal issue. There's something else will happen. A new law will come up. You'll fight in the courts for a number of years. Who knows?
Absolutely. We need to break the pattern. Stand up. The victim needs to speak up so that the victim's children realize that this is not an acceptable pattern of behavior in the house.
Sure.
When the victim is silent and quiet, it is repeated over generations.
Absolutely.
So
Good.
we need to be the role model for our own children.
Absolutely. Thank you very much. And Aya.
Thank you. So is there anyone else who would like to opine on the subject? Please.
Hi, I'm Aditi.
Please, it's not clear.
Can you hear me now? I'm practicing law in India. One of the major problems that I feel women are facing to speak up or to report is that the judiciary takes a lot of time. Basically, a lot of women are dependent upon the salary or the income of the male. And they are dependent upon the interim maintenance that they get out of this particular case. So if the interim maintenance comes after a year or 2 years, they do not have any source of income for those 2 years, and they do not have any other place to go. That is one of the major problems why the women are not going against such issues, and they are trying to cover up, or they are trying to live in the same situation so that they can protect themselves and their children for those 2-3 years that the judiciary will take to even give them some interim protection. So I feel there should be some change in the judiciary, at least in India. I don't know about other countries.
Yes, I agree. Applications under the maintenance should be expedited, and it should be time bound, maybe 6 months or even 3 months. I know the interim orders come after a year or 2 in India, because of which women are not able to stand up. But then by not standing up against the violence that they're facing, they're only setting a bad pattern for their children. So it's We need to work on regulating the laws better, I understand, but it's important to stand up against the violence.
I think the problem even from sometimes the parents, when they start to teach their children that the woman, or I'm talking because in Arab countries, I don't know what about in India, or even in the school, they teach them that the woman's supposed to do everything with the husband or something, have to follow it up, and her place is just for in the kitchen. She cannot do anything in her life. Then she start to believe that she's half a human being or something, and to accept all the violence from the community. So I think one of the important things to teach the kids, especially the girls, that you are a full human being, you can give a lot, you have to be independent and work hard, because the financial, if she's independent financial, she will talk, she will say stop it, she will be awareness of everything, but if not, of course, she cannot take any action and she will be silent and accept everything. Am I right?
Yes, financial independence, that's the key as well. Is there anyone else?
Anyone want to add something or any opinion?
Okay.
Yeah, that's
it.
it.
So on that note, with the message that we all need to be responsible and break the silence against the violence that we may see around us or in our homes. Thank you very much.
Thank you very much.
Thank you very much, Kanchan and Aliyah. It is a very sensitive issue, but we need to talk about it, as you said. All right. Thank you. Ladies and gentlemen, this is the end of day 2. I hope you have learned a lot, gathered a lot of information. We shall reconvene tomorrow at 9 a.m. Please feel free to mix and mingle and network downstairs, one floor below, with your colleagues, and I shall see you tomorrow. Good evening. Thank you.